Hello and good morning. This is Trial TV Live, and I am the Squeegee of Justice. Thank you so much for joining us. And Super Bowl. We are going to be continuing on with Florida versus Henry Segura. And we are in day 8, and we're going to hear closing arguments, and then we're going to have a verdict. Hopefully, well, not hopefully, we will. How's everybody doing today? How is the chat doing? Therapist, good morning. Baka of 3, hello to you. Let's see. I can pull these up. Brat, good morning. Julie, hello. Dream Landry, good morning, good morning. Pammy says good morning. Julie, good morning, good morning. All right. Pants is getting settled in. Super Bowl is getting settled in. Carol O'Neill, good morning to you. Super Bowl, you get a good morning from Dream Landry. Brat, you feeling good today? Good. It's a Friday, right? It's a Friday. Good morning to you, therapist. All right. Yes, happy Friday. Happy Friday indeed. All right, guys, let's get started, right? Baka of 3, I did not, but I saw Joker retired and Sinner won. Didn't see what was going on the women's side. I gotta check that out. And I'm wearing a turtleneck, and I didn't shave, so I'm all scruffy squeegee today. Hello, Nan R. How are you? Super Bowl says hello as she settles in. Super Bowl is settling in. All right, you guys ready? Let's get going. Oh, Laura Dad says, hey, I have not watched any of this trial apart from some of the testimony of the guy claiming he did it. I have read the background info, so I rewatch or just go from here. That's up to you. Oh, that's up to you. Pammy, we got Shaggy, y'all. Super Bowl can be Scooby. That's funny. Oh, stop it! Yeah. She digs her claws into my sweater, then I try to fix it, and then she bites me. That's really funny, Shaggy. So sad for Novak. Are you kidding or are you serious? I'll tell you, I'm not a fan of Joker, but that's okay. If you're a fan of his, that's cool. I'm more of a Fed Rafa guy myself. All right, Laura Dad, should you rewatch? I would, yeah. Well, Henry, I would definitely watch Henry's testimony. He was, let's see, he was the first witness for the defense, and that was day 4. I would definitely watch his testimony because it gets pretty spicy. The judge yells at him, and then he kind of yells back at the judge. So I would watch that. Yeah, Santos, James Santos, he's definitely good. De La Cruz, he's the consulting gang expert. He was a gang member at one point. He's not bad. The forensic scientist is pretty good. Actually, the guy they had on yesterday was pretty good. That was the defense had on Michael Knox. He was yesterday. He was all day yesterday. So, Laura, I would say, yeah, if you could go back and, if you want, I would say watch Henry's day 4, watch Henry's testimony, and then yesterday's with the forensic consultant, because he kind of lays out, excuse me, he lays out everything. Then they show pictures, so be prepared. They show Brandi pretty well. They show her, it's graphic, but it's quick. They didn't cut away fast enough. But yeah, Pammy says, Laura Dad, good morning. If you watch up to that point, then you know what's going on. But yesterday was very brutal with pictures. Yeah. Laura Dad says, no, I haven't seen any of it apart from about a half hour of when he was on the stand. Stop. Stop it. All right? Just stop. Hey, Mandy, good morning to you. Okay, but I'll do it, go back after. Okay, cool. Baca, I know they're retired now. All right, my newest ones, I like Alcaraz. I love Coco on the women's side. On the men's side, I'm okay with Sinner. I don't mind him. I'm not a fan of Zverev, I think, because there's allegations of him abusing his girlfriend, so I'm not a fan of his. Alcaraz for sure. Fritz, I like Fritz. I like Sheldon or Shelton. He made it to the semis.
Well,
Alcaraz got beat by Joker. Yeah.
But Joker retired?
Joker retired, yeah. No. He retired not from the game, but just from the match.
Right, he's done.
Yeah.
He's not playing anymore.
No, he's not.
He's not going to win.
No, he's
that's
not.
That's what the main part is.
Yeah.
I don't care if he's... No, he's not.
He's not.
He's almost old enough to retire.
He's almost old enough, yes. We're talking sports ball. We're talking tennis.
It's the only sports ball I know.
We're talking tennis.
Or care about, really.
Talking tennis. All right. Lily Wayne says, rewatch on the weekend. Works perfectly. Right on. Therapist, video games, comics? No, tennis.
Tennis.
Tennis with the racket and the little ball. All right. Yes, I know. I saw a Sinner. Yeah, you know what? Ben went to University of Florida, and I had a friend that I used to work with whose daughters were going to UF at the same time that Ben was playing there. So that was kind of cool. Yes, therapist, whenever we say Fed or Rafa, we mean Roger Federer and Rafa Nadal. And that's where our cat Rafa got his name from Rafa, because he's a ginger, and Rafa's the king of clay, ginger. Get it?
Nadal.
And Rafa Nadal. And Roger Federer. Yeah, I'm okay with Mbaka. I like him. I'm going to root for him, for sure. So, all right, let's get started. Let us get this party going. Frames are dropping already? Yeah, kind of. Not too bad. All right, let's see. Day 8. So we're gonna
have it already.
Let's start with jury instructions. We're all.
It's all ready and rolled.
Jury instructions. All right, cool.
Your producer got you set up.
Yes, she did. All right. All right, we're going to start with Day 8, jury instructions. So let's get into Henry Segura, Florida versus Henry Segura. Day 8. As soon as I can figure out where my thumbnail is. There it is. Okay.
Court is back in session. Have a jury slip?
Remain standing for the jury.
Everybody be seated, please. Good morning, everybody. Thank you for being back here this morning. Next thing I'm going to do is instruct you on the law. You will be allowed to keep these jury instructions with you, so you don't necessarily need to take any notes unless we find a typo or mistake that we need to fix. Many times as we go over them, we still seem to always find some little mistake that we miss, but hopefully nothing significant. What I would ask is that you read along with me as I go through them so that I can be certain that everyone has been through them in their entirety on at least one occasion. Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I'm about to give you. Henry Segura, the defendant in this case, has been accused of the crimes of 4 counts of first-degree murder. Murder in the first degree includes the lesser crimes of murder in the second degree and manslaughter, all of which are unlawful. A killing that is excusable or was committed by the use of justifiable deadly force is lawful. If you find Brandi Peters, Tamiyah Peters, Taniyah Peters, and JaVonte Segura were killed by Henry Segura, you will then consider the circumstances surrounding the killings in deciding if the killings were murder in the first degree, or were murder in the second degree, or manslaughter, or whether the killings were excusable or resulted from justifiable use of deadly force. The killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the killing. The killing of a human being is excusable and therefore lawful under any one of the following three circumstances. 1, when the killing is committed by accident and misfortune in doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent. Or 2, when the killing occurs by accident and misfortune in the heat of passion upon any sudden and sufficient provocation. Or 3, when the killing is committed by accident and misfortune resulting from a sudden combat if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. Dangerous weapon is any weapon that, taking into account the manner in which it is used, is likely to produce death or great bodily harm. I now instruct you on the circumstances that must be proved before Henry Segura may be found guilty of first-degree murder or any lesser included crime. There are 2 ways a person may commit first-degree murder. One is known as first-degree premeditated murder, and the other is known as first-degree felony murder. The state has alleged both theories as to counts 2, 3, and 4. To prove the crime of first-degree premeditated murder, the state must prove the following 3 elements beyond a reasonable doubt. 1, the victim is dead. 2, the death was caused by the criminal act of Henry Segura. 3, there was a premeditated killing of the victim. The alleged victims are as follows. Count 1 involves Brandi Peters. Count 2 involves Tamiyah Peters. Count 3 involves Taniyah Peters. And count 4 involves JaVonte Segura. An act includes a series of related actions rising from and performed pursuant to a single design or purpose. Killing with premeditation is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. The questioning of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the killing. If a person has a premeditated design to kill one person and in attempting to kill that person actually kills another person, the killing is premeditated. To prove the crime of first-degree felony murder, the state must prove the following 3 elements beyond a reasonable doubt. 1, victim is dead. 2, while engaged in the commission of another human being, Henry Segura caused the death of victim. And 3, the defendant was the person who actually killed victim. This theory only applies to counts 2, 3, and 4. In order to convict the defendant of first-degree felony murder, it is not necessary for the state to prove that the defendant had a premeditated design or intent to kill. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crime of which he is accused, there may be evidence that he committed other acts that would constitute a lesser included crime or crimes. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser crimes indicated in the definition of first-degree murder are second-degree murder and manslaughter. To prove the crime of second-degree murder, the state must prove the following three elements beyond a reasonable doubt. 1, victim is dead. 2, the death was caused by the criminal act of Henry Segura. And 3, there was an unlawful killing of victim by an act eminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is eminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another and is done from ill will, hatred, spite, or an evil intent, and is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. To prove the crime of manslaughter, the state must prove the following two elements beyond a reasonable doubt. 1, victim is dead. 2, Henry Segura intentionally committed an act or acts that caused the death of the victim. The defendant cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide, as I have previously instructed you. Each of us has a duty to act reasonably toward others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. As to counts 1 and 2, if you find that Henry Segura committed second-degree murder or manslaughter, you will be asked to find beyond a reasonable doubt whether during the commission of the crime, Henry Segura used a firearm. You should designate this finding on the verdict form. Again, as to counts 1 and 2, if you find the defendant committed second-degree murder, and you also find beyond a reasonable doubt that during the commission of the crime, Henry Segura discharged a firearm and doing so caused death or great bodily harm to the victim, discharged a firearm, or actually possessed a firearm, you should also designate this finding on the verdict form. A firearm is legally defined as any weapon, including a starter gun, which is designed to or may readily be converted to expel a projectile by the action of an explosive, the frame or receiver of any such weapon, any firearm muffler or firearm silencer, any destructive device, or any machine gun. The term firearm does not include an antique firearm unless the antique firearm is used in the commission of a crime. To actually possess a firearm means that the defendant carried a firearm on his person or had a firearm within immediate physical reach with ready access with the intent to use the firearm during the commission of the crime. These comments relate only to the state's felony murder theory as to counts 2, 3, and 4. These comments have no relevance to your consideration of the state's premeditation theory as to counts 1 through 4. Counts 1 through 4 are linked in that the crime charged in count 1 is an essential element of the crimes charged in counts 2 and 3 and 4. You should first consider the evidence applicable to count 1. If you find the crime in count 1, either first or second degree murder, has not been proven beyond a reasonable doubt, you must find the defendant not guilty on counts 2, 3, and 4 as to the felony murder theory. If, on the other hand, you find that the crime charged in the count 1 has been proven beyond a reasonable doubt, you must then consider the evidence applicable to counts 2, 3, and 4. A guilty verdict on count 1 does not require a guilty verdict on counts 2, 3, or 4. You should find the defendant guilty on counts 2, 3, or 4 only if you find all the elements of that crime, including the essential elements contained in count 1, were proven beyond a reasonable doubt. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the indictment through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are, did the witness seem to have an opportunity to see and know the things about which the witness testified? Did the witness seem to have an accurate memory? Was the witness honest and straightforward in answering the attorney's questions? Did the witness have some interest in how the case should be decided? Does the witness's testimony agree with the other testimony and other evidence in the case? Has the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify? Had any pressure or threat been used against the witness that affected the truth of the witness's testimony? Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Has the witness been convicted of a felony or misdemeanor involving dishonesty or false statement? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. You must consider the testimony of some witnesses with more caution than others. For example, a witness who hopes to gain more favorable treatment in his own case may have a reason to make a false statement in order to strike a good bargain with the state. This is particularly true when there is no other evidence tending to agree with what the witness says about the defendant. So while a witness of that kind may be entirely truthful when testifying, you should consider his testimony with more caution than the testimony of other witnesses. However, if the testimony of such a witness convinces you beyond a reasonable doubt of the defendant's guilt, or the other evidence in the case does so, then you should find the defendant guilty. The defendant in this case has become a witness. You should apply the same rules to consideration of his testimony that you apply to the testimony of other witnesses. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. A statement claimed to have been made by the defendant outside a court has been placed before you. Such a statement should always be considered with caution and be weighed with great care to make certain it was freely and voluntarily made. Therefore, you must determine from the evidence that the defendant's alleged statement was knowingly, voluntarily, and freely made. In making this determination, you should consider the total circumstances, including but not limited to whether when the defendant made the statement, he had been threatened in order to get him to make it, and whether anyone had promised him anything in order to get him to make it. If you conclude the defendant's out-of-court statement was not freely and voluntarily made, you should disregard it. These are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. You must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. This case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of the exhibits and evidence in these instructions. This case must not be decided for or against anyone because you feel sorry for anyone or angry at anyone. Remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case. Your duty is to determine if the defendant has been proven guilty or not in accord with the law. Whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. The jury is not to discuss any questions that jurors wrote that were not asked by the court and must not hold that against either party. Your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. You may find the defendant guilty as charged in the indictment or guilty of such lesser included crimes as the evidence may justify, or not guilty. If you return a verdict of guilty, it should be for the highest offense that has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course your verdict must be not guilty. The verdict must be unanimous, that is, all of you must agree to the same verdict. As to counts 2, 3, and 4, if you return a verdict of guilty to the first-degree murder charge, it is not necessary that all of you agree the state proved first-degree premeditated murder, and it is not necessary that all of you agree the state proved first-degree felony murder. Instead, what is required is that all of you agree the state proved either first-degree premeditated murder or first-degree felony murder. The verdict must be in writing, and for your convenience, necessary verdict form has been prepared for you. If you look at the verdict form with me, I think it's pretty self-explanatory, but we'll go through it. Says, we, the jury, find as follows as count 1 of the indictment. This is the charge involving Brandi Peters. You have 4 options. Either A, guilty of first-degree murder, B, guilty of second-degree murder, C, guilty of manslaughter, D, not guilty. You would go through and check which of those 4 options you unanimously agree upon. Now, depending on what you've done, there are some questions that you might have to answer. If you've chosen B, second-degree murder, then you need to answer the interrogatory there. During the commission of the offense designated above, the defendant discharged the firearm causing great bodily harm or death, discharged the firearm, actually possessed the firearm, or did none of the above. You only need to answer that interrogatory if you pick B, second-degree murder. If you pick B or C, and then sometimes that gets a little bit confusing because it's after C, but if you pick B or C, you need to answer the interrogatory. During the course of the offense designated above, the defendant used a firearm, yes or no. So at the end, you must have at least 1 check mark for that. Count A, B, C, D. If you've chosen B or C, you need to answer the interrogatory. Count 2 works very similar to count 1. You have 4 choices: first-degree murder, second-degree murder, manslaughter, or not guilty. Again, if you've chosen B or C, you need to answer the interrogatories. Count 3 and 4 are a little different. Count 3 and 4, you only have the 4 choices: either A, first-degree murder, B, second-degree murder, C, manslaughter, not guilty. There are no interrogatories associated with counts 3 and 4. It'll be dated and signed by the foreperson. The foreperson will bring the verdict form back to the courtroom after your deliberations. Sometimes I get a question from the jury whether everyone has to sign the verdict form. No, just the foreperson signs on behalf of the jury. We're going back to the jury instructions on page 7, single defendant, multiple counts. A separate crime is charged in each count of the indictment, and although they have been tried together, each crime and the evidence applicable to it must be considered separately and a separate verdict returned as to each. A finding of guilty or not guilty as to one crime must not affect your verdict as to other crimes charged, other than what I've explained above under the verdict form, and as I explained earlier about interlocking charges. I'll get the concluding remarks at the end of the case. Both the state and the defendant have rested their cases. The attorneys now will present their final arguments. Please remember that what the attorneys say is not evidence or your instruction on the law. However, do listen closely to their arguments. They are intended to aid you in understanding the case. Each side will have equal time but the state is entitled to divide this time between an opening argument and a rebuttal argument after the defendant has spoken. Mr. Duke.
Thank you, Your Honor.
All right, so we just went through the jury instructions. So first degree, and then the lessers were second degree and manslaughter. I was trying to find the actual, I spent most of that time trying to find the actual transcripts, but I couldn't. Hope you guys caught all of that. And let's see, should we end the poll? Let's, what do you guys think so far? Let's end the poll. So far, is Henry guilty? 91% of you think so. Is he not guilty? 0%. I put no guilty. I meant to say not guilty. And not sure yet, 8% of you. So I hope that answers. Laura, I think you had a question of how we felt. I think that that pretty much tells you how we feel. All right, let's get on to closing arguments. This clip is 34 minutes, and this is prosecution closing arguments. Remember, he said he was going to talk for about 2 hours, so this is just his beginning. Then he'll come back, I'm sure, for rebuttal. Well, I know for sure he will come back.
Morning once again.
All right, hold on. Let me get this queued up. Okay. Prosecution closing argument. Let me put that up here. Pin that. All right, prosecution's closing arguments.
Morning once again. First thing I'd like to do is thank you. I know previously I thanked you for being potential jurors and answering the questions that we posed to you. I then thank you very much for being the jurors. What I'm, of course, at the opening statements, what I'm thanking you for now is doing exactly what it is that we knew and you were selected to do. I know I pay close attention. I know Judge Hankson does, as well as Mr. Prince. Y'all paid close attention to everything that was presented to you, and it's a long, some of it not as exciting as others. But you paid attention to each and everything, and thank you very much for doing exactly what it is that we chose you to do. We literally, again, cannot do this without y'all's participation. As the judge said, I get an opportunity to talk twice. The first thing I kind of like to do is talk a little bit about the jury instructions. I'm not going to belabor these because, of course, they were read to you, but I do want to talk to them a little bit. For first-degree murder, the state must prove that the victim, of course, is dead. There are 4 different counts you have there. The first one is Brandi Peters. No question, she's deceased. The next one is Tamiyah Peters. Again, no question, she's deceased. Taniyah Peters, the same. And finally, JaVonte Segura. No question that element number 1 has been met. So the next question is, was there a premeditated design in killing the particular victim? The judge told you there's 2 different theories. Premeditation. There's also felony murder. Let's talk about premeditation. As the judge instructed you, this is the rule. You have it in front of you. You're going to have it back in jury selection, so I'm not going to read it to you again. But the bottom line is, what it says is that there is no fixed amount of time that must occur. In other words, it's a decision to kill somebody, and it can be very quick, or it can be longer. So how does that apply? Question I have first and foremost, of course, is Brandi Peters. When was it that he decided to kill her? Was it when he got to the house and he brought a gun with him to the house? She was shot 7 to 8 times. 10 projectiles were recovered. They decided to kill her after the first shot, second, third, fourth, fifth, sixth. Remember, this is a revolver. Not a high-capacity magazine, holds 5 to 6 rounds. They decided he was going to kill her when he reloaded that weapon and continued to shoot. They decided to kill her after he dragged her back into the house. Remember, she escaped from the home. She got out the front door. They decided to kill her when he dragged her back in and started beating her. Which hit? He saw all the injuries she had to her head and her hand as she's fighting back. Remember, Dr. Flanagan said she wasn't dead yet, even after that most severe injury in the front. It killed her eventually, but it didn't kill her right away. At one point, they decided to kill. And I would argue, of course, he decided to kill when he brought the gun over there on Friday. Certainly decided when he shot at her 7 to 8 times, 10 times total. And certainly decided to kill her when he beat her to death in the manner in which he did. So next we have Tamiyah, when he decided to kill her. This is where we start getting into that felony murder. If a person has a premeditated design to kill one person, Brandi Peters, and attempting to kill that person actually kills another person, that killing is premeditated. So the premeditation actually extends to other individuals and the other persons that are killed. So, when he came over there, did he have an intent to kill Brandi Peters? And if so, that premeditation transfers. And transfers to Tamiyah when she is shot in the back of the head from close range. Taniyah and JaVonte drowned in the bathtub. Dr. Flanagan, 10 to 20 seconds, they were held under that water. Seconds holding those kids underneath the water, and that's after they took the breath of the water in. That doesn't include them just starting to be held under. Pretty conscious decision to kill somebody. Again, this goes back and talks about that felony murder that was talked about. You don't have to prove that he actually was premeditated and intended to kill those kids when he came over there. It can be felony murder. While in committing one murder, he actually does the second, the third, and the fourth. So we met that particular element as well. So now we get to the big question. Of course, this is the one, of course, up to this point, I don't think there's any disagreement from anybody. The big question is, how is the state proven that Henry Segura did this? And what you have to do is use those tools that we talked about in jury selection. You have to use your common sense. You have to use your education, whatever level that is. You have to use those experiences in life that you use each and every single day in dealing with the disputes that you deal with, co-workers, family members, things along those skills that we do, and look at the evidence as a whole and what that evidence tells you about this particular case and Henry Segura's culpability. Let's talk about it. Who has the motive, who has the means, and who has the opportunity to commit this murder? Because that's what law enforcement looks for. That's what everybody should look for. Who has the motive, the means, and the opportunity? Motive. Typically, you're talking about a love relationship type situation. Money is involved. Things along those lines in a typical situation. So what do we know? We know that Henry Segura owed child support to Brandi Peters. Child support's child support. A lot of people owe it. Mr. Peters actually, Mr. Segura already was owed child support on another child living in South Florida. But in this particular case, it's not only the child support. She's sending him and she's actively pursuing it. He's trying to get a job in Afghanistan. Now keep in mind, he's always talking to the other baby mama and saying that in that situation, he keeps asking her to take her off child support. Take me off child support. I can pay better. Take me off child support. That's what she told you. Brandi Peters isn't having any of it. She keeps hitting him with the stuff. Standing in his job, he's got a 6-figure job awaiting in Afghanistan if he can get that visa, but he can't. Ms. Peters is threatening him. I'm going to put you in jail. I'm going to take the IRS. I'm going to have all these liens against you, garnish your wages. She's taunting him. Sending him text messages. He's forwarding it on to his wife. Keep in mind, it's 11/16 of 2010. 3 days before the murder, this taunting is occurring. And also remember the main difference between this one and the one in South Florida. He didn't think JaVonte was his. Petitions the court back in June. Strong evidence support the kid is not his. Continues on. July 22nd, 2010. Not my child. So now we've got Brandi Peters doing what she's doing, taunting him, sending these letters for a child that he doesn't think is his. And 4 months later, after he files that petition, they're all dead. Timing is everything. So is there motive? Certainly. So next we turn to means. Who's got the means to do this? Who's got the strength to do that aspect? Who's got the anger to do those beatings in the manner that they were done? Who's got the strength to use a weapon in order to cave in her skull? Who's got the weapon? Big guy, welder. Deals with a lot of stuff that he has to do and carry things around. Metal, that's what welding does. Strong guy. Certainly has the anger and the frustration with Brandi Peters. Further, Calvin Moore, friend of his, lifelong friend of his, has previously seen him with a .32 caliber gun. Of course, the weapon that was used and shot in the house with 10 recovered projectiles is a .32 caliber. When do coincidences stop being coincidences? So he's seen him with a .32. He knows it's a .32. He's Army, he also does firearms. He knows it's a .32. And he described it. The weekend before, Miss Wilcoxon told you, it's the week of the Classic. Classic is in November. The weekend before, he asked Tyra Wilcoxon for a gun. I need a throwdown gun. I need your gun. Doesn't want to use his own gun. Asked her for a gun. Can't find one. He has to use his own gun. And then finally, opportunity. When was the murder? Who had access to the house in order to commit the murder? Because remember, this is not a forced entry. Nobody kicked the door down. Nobody pried the door open. Nobody picked a lock. This person walked in the front door. Who was there at the time? And now we start looking at cell phones. And y'all have heard a lot about cell phone analysis. You've learned a lot about cell phones and cell phone analysis over the course of time. Some of it gets boring, some of it's kind of interesting. But what do we learn? This cell phone, and we saw everything earlier about how much Brandi uses her cell phone. This cell phone stops working. The last time she touches it is 6:53, and it goes off the grid forever at 8:21. Never charged again, never used again, never even able to receive something because it's completely and totally off the grid, which is inconsistent with everything in the weeks leading up to this in the cell phone records of Brandi Peters. What does that tell you? Ladies and gentlemen, this tells you right here that these are the time periods. This is when we're talking about that the murder occurred. Because she no longer had the ability to plug her phone back in if it had died. She no longer got the ability to turn it back on if it had been shut off. One of the things, of course, your jury instructions say is you must consider the evidence and weigh it and compare it to the other evidence in the case and the other testimony in the case. Archeron Timmons. Archeron Timmons says that I went over there and I saw him I saw him eating when I came home from school. They were eating Burger King. It was around somewhere between 4 and 5. And then I was sent over there to get him for the oxtail soup at around 5:45. No. Is that consistent with the other evidence in the case? The autopsy, the food content. Can't really give a firm time period of how long it was before they ate. There's different things that make up. Soup digests different than hard substantive food, but what we know is within a couple of hours of eating, they're dead. That 6:53, that 8:21 is consistent with them eating soup around 5:45 and eating more substantive food between 4 and 5 o'clock in the evening. So who was there at the time of the murders? Henry Segura, interview on November 20th, 2010, the day after the homicides occurred, the day they were discovered. I was home all day long. I was home all day long. We now know that not to be true. So why lying to law enforcement? To cover up an affair? After you just found out your son's dead? November 30th, 10 days later, he lied 23 times in that video alone. 23 times in that one alone. No, I was home. He goes farther than that. Check my cell phone. My cell phone say I'm at home. He challenges law enforcement. Check my cell phone. I'll tell you I was exactly where I said I was. Okay, what's your phone number? 509-4380. You have any other phone numbers? Yeah, I've got a home number. Here it is. So they do. 509 number, says he was home. Just like he said he was. Setting up his alibi. That's why he left the phone at home. But they asked. Doesn't tell him about that 408-8669 number. He tells them that belongs to a friend of his, Silas Thornton. They confront him about that 8669. We know you have a second phone. Oh yeah, but I got rid of that long before Brandi was dead. Okay, never tells him what the actual number was. He just says I had a second phone and that I got rid of it long before Brandi was dead. Again, not true. Law enforcement officers say, hey, we know for a fact you were on that phone on Monday. He just looks at him. You have these videos back there. Just looks at him. I know what's there. Caught in a lie. At that point, does he come off and say, you know what, I've lied to you? Sorry. Trying to not mess up my marriage. I apologize. I was at her house. I had sex with her. Nope, doesn't say that. Doesn't say that in any way, shape, or form, and continues to maintain, nope, I was home all day. And of course, what the analysis of that second phone is, he was not home all day. That where he was consistent with being at Brandi Peters' house. They did the analysis. They did a scientific test. They get a known control cell phone, and they go out and they do data sessions at different locations at different times to compare them. Same phone, same carrier. And the information they got when they stand in Brandi Peters' living room is the exact same information that they got from that 408-8669 number. And what it says is that Henry Segura was there when her phone stopped communicating, when she stopped being able to communicate with her phone, when she was murdered. So they go back and they get further analysis. And they look at the text analysis. And even that says he wasn't home where he said he was. These are the text messages from his wife. Call me back. Answer the phone. I need to stay late. Can't depend on him. Can't get hold of him. He's not using his phone. Keep in mind, this is 8:15 at night and she's still texting him, saying, where are you? You're not here. Why? Because at Brandi Peters' house killing her and the kids. But when they go back and look at the cell phone analysis and Henry Segura's phone, mysteriously, these phone numbers and these text messages that would contradict his alibi have been deleted. Got rid of the evidence. Every one of them. Remember what we were saying. Part of the motive was the taunting, the harassing that Brandi Peters was doing. Those text messages. But guess what else is gone from his cell phone? He's not hiding these from Malika like he says, because he forwarded them to her. What he did was he got rid of them off his cell phone because they were evidence against him. Deletes them. Defense hires John Sawicki, cell phone analyst. Comes in, says, yeah, that TBD's right. He clearly was not home. He reports his finding to defense. Nothing wrong with the analysis that TBD did. Reports to the defense. And what do they realize? Realizes that November 20th and November 30th statement of I wasn't there isn't going to work. Can't say that anymore. Keep in mind, Henry Segura sat through the trial, listened to each and every piece of evidence, was given every piece of evidence over the 8 years since his arrest, had an opportunity to go through it all. So what does he know? He knows that his claim of I'm not there and his alibi of being his home, the one that he set up by leaving his phone at home, isn't going to work. And enter stage right, James Santos. Lo and behold, years after this occurred, 2016, he's been previously interviewed 2 times, denied any involvement in the homicide. The state's handed a typewritten affidavit from James Santos in which he now declares that Angel Avila was hired by him to kill Brandi Peters and the kids. The only typewritten statement he's ever made. Everything else you've got is handwritten. To paraphrase William Shakespeare in Macbeth, Santos is but a walking shadow, a poor player that struts and frets his hour upon the stage and then is heard no more. Is a tale told by an idiot full of sound and fury, signifying nothing. That sums up what Mr. Santos is. Mr. Santos, again, through the only typewritten statement he's made provided to the state by the defense, says Angel Avila, I hired to kill him. This is after there's a hearing in which Angel Avila's named. Later on, 2017, there's another hearing at the beginning of August in which Mr. Paramore's name comes up at that hearing. All of a sudden, 2 weeks later, there's another letter, handwritten this time, from Mr. Santos saying, oh yeah, by the way, the other guy I hired was Mr. Paramore. You got an evidence report by Dr. Hudson. Yes, you have 2. You have one that was done on August 1st, which the defense introduced. And then shortly thereafter, on August 3rd, he's handed additional documents by his attorney and says, whoa, I need to go back and readdress this now that I've reviewed those other documents. The state didn't have a hand in this. And what he says, and I'll just read some of it, whereas he is competent to testify, Mr. Santos reports he was born in Nigeria. His mother is Nigerian, and when he got off a plane in Chicago, all of a sudden he was a vice lord. He reports that he has an 18th grade degree from Las Vegas University. Never heard of such a thing. 18th grade degree. Contacts his mom. Mom's like, nah, he was born in Georgia. I don't know what he's talking about. The profile reveals significant immaturity, narcissism, grandiosity, resentment of authority, and repressed hustle and anger. Was consistent with a delusional disorder of grandiose type. It is my contention, this is from Dr. Hudson, it is my contention that the inconsistencies in his grandiose claims across time and context can be best explained by a history of deceitfulness and indicated by repeatedly lying, use of alias, this has been confirmed, and conning others for his personal profit or pleasure. He has a delusional disorder of grandiose type and is consistent with prominent narcissism and antisocial personality traits. And remember, Dr. Dela Cruz, his expertise that is derived from his deceased brother and his paperwork that was destroyed, he's being peer reviewed on Google Academic. All of that is based upon James Santos and his testimony. And I would certainly argue to you that James Santos is untruthful. What he's talking about, it just defies logic. He even admitted on the stand that his associates in Nigeria were the people that were sending the emails out and offering me money and loans. He agreed to anything. So what they know is that Mr. Segura's prior testimony or his prior statement to law enforcement that he was there isn't going to work. And he has to come in and explain that to you, and he does. And he takes a stand, and now he's saying, oh yeah, I was actually there. I was there to have sex. Has to. No other option. But what you got to see is a true Henry Segura. The man that gets frustrated and snaps and gets angry. Snaps at Judge Hankinson. I'm a grown man. Imagine what he would do to Brandi Peters if he's willing to do that here in court while he's on trial for murder to Judge Hankinson. Just like everybody else, you have to look at Henry Segura's statements, compare them to the other pieces of evidence that are out there, and how they line up with that. And I would certainly argue with you when you do that. Not only did he lie to law enforcement on those days, but he also was untruthful to you here in court. But let's not forget one other thing. Henry Segura is locked up in Oklahoma City. Oklahoma City. Not Tallahassee Democrat. Not WCTV. Prior to any big television asset here, this is 2011. He's locked up with a guy named Kelsey Kennard. Now, Kelsey Kennard's a snitch. He's a jail snitch, no question about it. He doesn't try to benefit himself. He thinks his plea deal is that if there's anything he becomes knowledgeable of anything that's criminal, he has to tell people. Thinks it's part of his plea deal. Whether it is or not, doesn't matter. And what did he tell you? He says, while I was there, I told Henry not to talk to me because I'm a snitch. Don't talk to me, dude. But he did. Then what Henry Segura tells him is he killed 4 people. Is that statement from Kelsey Kennard consistent with the other pieces of evidence? Well, we know there's 4 people that were killed. Told him that on occasion he wakes up screaming. Nightmares. Does he have nightmares of what happened on that day? Beating her to death, drowning 2 kids? Wouldn't make sense. Said he killed his baby mom because of child support. She wouldn't take him off of it. We know that to be true as well. Again, this is Oklahoma City, federal prison. Says he hit a gun in a car. Is that consistent with any evidence? Well, there's a text message. Come get this car. Remember, this is 3 days after the homicide. 3 days after the homicide. Come get this car, I want it gone. He doesn't even have to give me any money for it. This is the guy that only had $100 and something in his account when he made that withdrawal. This is the guy that can't pay child support. This guy supposedly was out of work for however long because of a bullet wound he had in another gunfight. Yet he wants rid of a car for no money. And what else do we know about this text message? Just like every other piece of incriminating evidence against him that was under his control, it's deleted. How is it proven that Henry Segura did it? He's arrested in Minnesota. Had the conversation, I'm not going to play the whole jail call, but the entire conversation he's having with his wife about this. She says, I've given up my life for you. And what does he say? Looking like I gave up my life for you as well. After he's just been arrested for homicide. And these kids. After he's just been arrested for a homicide in which that he had actively communicated with her about the frustrations of having to take child support of a child that he did not believe was his. he makes a statement, it looks like I gave up my life for you. After carefully considering each and every piece of the evidence as a whole, and putting it in context and comparing it with the other pieces of evidence, leave out James Santos because he's unreliable in every way, shape, and form, and all the things that are derived from James Santos's testimony, because it is in fact unreliable based upon everything that you heard. He's previously confessed to multiple murders they didn't do. 2 of them didn't have bodies. 1 of them he couldn't have done because he was in prison. And when you do this and you compare it, and you cannot change what happened here in court in the testimony of Mr. Segura and his reasons for making that testimony, because he was dead to rights on his motive, or on his alibi blowing up. And when you take all of that and put it in context, he is guilty of killing Brandi Peters, Tamiyah Peters, Taniyah Peters, and JaVonte Segura. Thank you.
We'll take 15 minutes and let the jury step out. Either side needs. Okay. All right, we'll take 15 minutes.
All right, so let's go through the prosecution's closing arguments. And first, we want to wish Lil Miss a happy birthday. I know it's on Sunday, but happy early birthday, and I know you have to get back to your editing, so thank you for popping in, and I hope you have a very wonderful birthday on Sunday. And hopefully we'll see more of you next week. All right, so let's go to prosecution's closing arguments, and this is by Mr. Fuchs. You would think that I would know his first name by now. John Fuchs. Prosecutor John Fuchs with the closing arguments. He talks about the 4 counts of first-degree M, which would be Brandi, Tamiyah, Taniyah, and JaVonte. I was looking at something else and I was saying his name wrong. Sorry. So there's 4 counts for them. Element 1 was met. They were all deceased. Was it premeditated? That's always the question, right? Was it premeditated? Did they actually, plan it? And I guess they say that you don't have to think about it for a year or a month or a week or a day, So no locks were picked, no door was kicked in, a person just walked right in. And then the big thing is the cell phone. Brandi's cell phone stopped at 6:53 p.m. and then it was off the grid at 8:21. So this happened sometime between, and they showed in one of the testimonies, they showed all of her activity on her phone, and she literally was on the phone just, like every minute practically. She was texting, or she was calling somebody, or somebody was calling her or texting her. Brandi was very, very active. She was very, very active on that phone. So for her to be, not doing anything from 7 to 8, very unusual. And then 8:21, just completely off the grid. Henry says he was home all day. Why lie to law enforcement? Just because, you didn't want your wife to find out. Your wife already knew you had 4 or 5 girlfriends. You had 3 or 4 other kids with those girlfriends. Why lie at that point? Doesn't make sense. In his interview on November, I think he said the 30th or the 20th. I wrote down the 30th, but I think that was, no, I guess it was the 30th. 23 times. In that one interview alone, he lied 23 times. Why? Why lie? In the years since the incident, he knows I wasn't there doesn't work, so then enter James Santos. So in 2016, Mr. Santos comes up, and as Mr. Fuchs paraphrases Shakespeare, Santos is but a walking shadow, a poor player that struts and frets his hour upon the stage and then is heard no more. It is a tale told by an idiot full of sound and fury, signifying nothing. Yeah, that pretty much sums up Santos's testimony. Then he brings up the exchange with the judge. I think this might be the thing that gets him, you know. And he's like, I'm a grown man. We remember that. We remember that exchange. He says, imagine what he would do to Brandi. If he does that to a judge in a courtroom, shows his anger because Judge Hankinson is just telling him to stop talking over. I think that's what it was. He was like, you're talking over, you know, the lawyer. I think it might have been Fuchs who was crossing him. He's like, you're talking over him, you know, just stop talking. And he's like, don't talk to me like that. I'm a grown man. You know, does that show his true colors? And then he talks about the Oklahoma City lockup with Kelsey Kennard. Why? And I think he said it was like 3 days after his arrest in Minnesota. He got arrested up in Minnesota, don't forget. Why tell this? Well, if you believe him, he's a snitch, I guess. But if you believe him, why tell him all these things? That he has nightmares, that he offed his baby's mama because of child support. Like, why would that guy make that up? Or to what end? Yeah, he didn't have nothing to gain, to be quite honest. So why do that? All right, let's get to some of your comments. What are you guys thinking? Curviel, you think that's going to do him in too? Yeah, I think so. Dreamer Landry, it showed he cannot control his temper for sure. Evil Queen, no time for the kids. I reckon if she was on the phone all the time. Oh, I think she had time for her kids. Curviel, I think the delay was because it wasn't until the job denial that it really affected him. Oh, is Haley Mouse with us? Hey, Haley, how you doing? Thank you so much for joining us. Yes, and happy birthday to Little Miss on Sunday. How was the closing? Good? I thought so. I've seen better. It was good. You know, it was adequate. He's going to come back. He's not done yet because he said he's going to talk for an hour and a half to 2 hours, and that was only a half an hour. So that was 34 minutes. So he will be coming back. He'll get his rebuttal. Oh, and Curviel, we took a poll earlier before you got here. 91% thought he was guilty. 0% thought not guilty, and 8% thought not sure yet. OnlyFans says they always save the best for rebuttal. Mandy Strong says Henry was showing signs of PTSD from the crime and needed to tell someone what he did. Yeah, the nightmares. Oh, Haley Mouse, thank you. I appreciate that. Glad you guys appreciate that. Yeah, Curviel, 0 thought not guilty. 0. And we know, look, well, we always know more. We always know more than what the jury knows, that's for sure. Widespread Panic says, no, I meant the amount of time it took his wife to divorce him. Oh, you guys are having a convo between each other. Dreamer Landry, yes, she loved the phone, for sure. Widespread Panic thought the closing was very good. Nanar says, I didn't vote. I only watched some yesterday. Okay, fair enough. Curviel, yeah, shocking compared to the first trial. Yeah, it's funny. We were, therapist, you know, was the one that suggested this rewatch for us. And she'd first pulled up the first trial. And when I saw it ended in a mistrial, I'm like, oh, no, I didn't want to, like, subject myself and then you guys through, 7, 8, 9 days and it end up in a mistrial. So I was like, Don't want to do that. So then I found out that there was this trial, and I remember watching this with Aaron. We watched this second trial. I do remember it. Jenny, no, I did not. I'm thinking about it, but I did not. Maybe it's the turtleneck that's making it look different. I don't know. Brett says, given that his in-court reaction was when he felt dissed, I wonder when she might have said that during that last visit earlier that week. What she might have said during that last visit earlier that week. Well, she, according to him, Brandi was saying, taunting him, this isn't your kid, JaVonte's not your child, he's somebody else's. She could have. Jenny, I have not touched it. I was thinking about a trim soon, though. I think it's the turtleneck. It's all like relative. My neck is shorter. What did I remember? Fala? I just noticed. Sorry, not a good morning. You remembered? Oh, I remembered the turtleneck. Yes. Inspired by Ashley Benefield's lock yesterday. All right. You guys ready for defense closing argument? This is going to be an hour and 45 minutes. So, and then, and then we'll get to the next segment. So this is an hour and 45 minutes of Mr. Prince. Okay, see you guys on the other side.
Everybody be seated, please. Mr. Prince.
Thank you.
All right, so I don't know anything about any Shakespeare. I can barely keep track for my kids of redfish, bluefish. So I'm just going to talk about the court's instructions, how they apply to the evidence in the case, and then we'll focus on the evidence in the case. I don't have any clever rhetorical devices for you, and I can't rhyme very well. So let's just talk about how to frame the question that you're here to answer first. I think that's the best place to start. Anytime you have to look at a variety of issues and a variety of complex evidentiary topics like we do in this case, I think it's important to first start by identifying the question it is that you have to answer. You've heard the state ask a lot of times as the evidence was presented in the case, in my version of the events possible, in my version of the events possible, in my version of the events possible. That's what a defense attorney is supposed to say, right? As the judge instructed you at the beginning of the trial, the state has the sole and exclusive burden to prove with evidence each element of the offense beyond and to the exclusion of a reasonable doubt. And so as we go through, we're not talking about questions pertaining to belief. A lot of times the state tries to frame their arguments in terms of what do you believe, who do you believe? While it's important to answer those questions, the ultimate question you have to answer is not one of belief. A lot of times, and I don't know if Mr. Fuchs will reference it, but there's a part of your jury instructions which Judge Hankinson read to you that says you may rely on your own conclusions about the credibility of a witness. A juror may believe or disbelieve all or any part of the evidence or testimony of any witness, as a means of suggesting that the standard is belief. Well, if the standard was belief, then the question would just be, what do you think happened, right? That's not what Judge Hankinson instructed you. The question about, or the instruction about believing witnesses and disbelieving witnesses, that has to be read within the context of the evidentiary standard that applies in the case. And what the judge told you about the evidentiary standard that applies in the case is that the defendant has entered a plea of not guilty. This means that you must presume or believe that the defendant is innocent. The presumption stays with the defendant as to each material allegation in the indictment unless it has been overcome by and to the exclusion of and beyond a reasonable doubt. So the question that you're ultimately answering here is one of exclusion. What that means for purposes of your evidentiary analysis is that the state's witnesses and the defense witnesses are not on equal footing, at least insofar as the state's witnesses carry with them the state's burden of proof. And what I mean when I say that is that for state witnesses, belief is a threshold question. Only if you believe them can you go on to decide whether their testimony, the evidence that they've presented, proves the case beyond a reasonable doubt. Whereas with defense witnesses, you may not believe them, but you may find that because they've taken the stand and testified, their testimony has given rise to a doubt which is not speculative and not imaginary, but is rather reasonable and therefore must be excluded affirmatively by the state. And so what that effectively means is you analyze the evidence that's been put before you and as you try to apply the instructions that the judge has given you to the case. To be clear, you could believe a state witness and still find that their evidence fails to exclude every reasonable doubt. Similarly, you could not believe a defense witness, but still find that that witness, his testimony or her testimony, gives rise to a reasonable doubt. So in the context of your analysis here, what does reasonable doubt mean? Remember, we talked in jury selection about how reasonable outside these walls just means what do I think is probably true. The reasonable doubt in here has a very specific legal definition, okay? As the judge instructed you, reasonable doubt is not a mere possible doubt, a speculative doubt, an imaginary doubt, or a forced doubt. So when a doubt is not speculative and a doubt is not imaginary, I would suggest to you that the only rational way to interpret that instruction and apply it to the case is to take it to mean evidence-based doubt. And the example that I like to give jurors to assist them in applying that instruction to the facts of the case is as follows. If this were a bank robbery trial, right? And the state puts on witnesses to say, I saw the defendant, they put on a video that shows somebody that looks exactly like the defendant committing the bank robbery, and the defense attorney stands up in closing argument and says, well, what if he has an identical twin? Right? That's a speculative, imaginary doubt. It's not based on evidence, it's based on argument. On the other hand, if the defendant in that armed robbery case takes the stand, testifies in his own defense that I do have an identical twin brother, that may or may not be true, but then it becomes incumbent on the state to disprove that or exclude that evidence-based doubt with evidence of their own. And that's an important distinction to make. What does it mean to exclude every reasonable doubt? There are instructions that give you guidance as to how the state must go about the task of trying to meet their burden. One of the instructions the court gave you says that the presumption of innocence stays with the defendant as to each material allegation in the indictment unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. Another instruction in the rules for deliberation section says this case must be decided upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of exhibits and evidence. So what does that mean as a practical matter? That means that the state can't overcome evidence-based doubts, that is non-speculative, non-imaginary doubts, which I would submit under the instructions that have been provided means a reasonable doubt. State can't overcome reasonable doubts with argument. Now, I'll give you an example of where that's going to apply down the road as we go through the evidence here. There's been a lot of talk already about Marquise Davis. Marquise Davis says that he took Brandi Peters' food at around 7:30, fed the kids around 7:30 as well. There's absolutely no evidence that is even inconsistent with his testimony. And introducing evidence inconsistent with his testimony is not the state's burden. When a doubt arises from the evidence, they have an obligation to affirmatively come forward with evidence, not argument, and exclude the reasonable doubt created by that evidence. We can use the hypothetical that Mr. Fuchs used in jury selection to illustrate this point. In jury selection, he was talking about how, well, if you're trying to decide beyond a reasonable doubt if your friend drove himself over to your house and you answer the door and he's standing there and you see a vehicle that you think is his in the driveway, maybe it is reasonable to think that he drove himself there. The question's not, is the state's version of the events reasonable? The state's burden is, have they excluded every other reasonable doubt? And if you've noticed, the judge didn't instruct you that the state gets the benefit of any inference, presumption, or assumption. They don't. The defendant is presumed innocent, as we've already talked about. So in the case of the hypothetical Mr. Fuchs used, let's say somebody comes and testifies, hey, I checked the VIN or I checked the license plate on that vehicle, and that actually is your friends. Well, that's a good piece of evidence to start with, but it doesn't prove he drove, and you're not allowed to give the state the benefit of any presumption. Let's say a witness comes and testifies, well, I saw him get out of the driver's seat. That's extra evidence. That's good, right? But what if that witness is biased? What if that witness has a grudge against the defendant? Those are just examples of things that you have to analyze, okay? So hopefully, as we discuss those things just a little bit briefly here, it gives you some practical idea about how you should go about applying the instructions that the court has given you to the facts of this case. The last thing we need to talk about from the preliminary instructions before we jump in to the evidence itself is the question about how a reasonable doubt arises. And the instruction on that issue says that a reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or a lack of evidence. And we're going to kind of deal with those in reverse order, starting with lack of the evidence. Before we do that, though, I just want to clarify so that the issues before you are clear, what we don't have to decide. You don't need to decide whether this is a lesser included offense. This is premeditated first-degree murder, a death penalty offense for sure. If this isn't, nothing is, right? This is the worst offense ever committed in this town. The people who committed this offense are the most evil people who have ever come through this town. So skip past that part when you get to the jury instructions. It is first-degree premeditated murder without a doubt, right? The other thing you can consider is that, or I should say that you don't have to consider here, is whether it's justifiable or excused. It's obviously not. There's no excuse for drowning children, beating and shooting Brandi Peters. So just go to the question that's actually at issue, which is the identification of the person or people who committed these offenses. I think it's best to start, now that we're going to start talking about the evidence, at the place that I started in opening statement, and that's with motive. And we're talking about motive now in the context of a lack of evidence. Nothing about the state's case doesn't make sense if the motive doesn't make sense, okay? In order for the evidence that they put on regarding the person who committed this offense to make sense, there's got to be a motivation. Now, that's not an element of the offense as instructed by the court, but it is a necessary logical step to get to those elements, right? Nothing else makes sense if there's not a palatable motive here. Mr. Fuchs starts off talking about how Mr. Segura must have been afraid of jail and driver's license suspension, professional licensure suspension, wage garnishment, tax refund, liens, international travel ban. That argument completely ignored what the evidence actually was. Because what the evidence actually was that Mr. Segura was already subject to every single one of those consequences. His baby mama, Tamiyah Hawkins, who does not like him, did not want to testify for him, did testify for him, and would have testified here again live if not for a personal medical issue. And what she testified to was that she had already sent him to jail, and he figured out how to get out by making partial payments. She had already got his driver's license suspended. He had already figured out how to get it reinstated by making partial payments. He worked jobs where no professional license was required. Instead, he just took a skills test at the beginning of each job. He avoided wage garnishment by working as an independent contractor and working out of state. She testified that that made it effectively impossible to garnish his wages. She already had a tax lien in place. Anytime he got a tax refund, it was already going straight to Tamiyah Hawkins. And in addition to that, she already had a child support judgment of a sufficient amount to keep him from traveling internationally. Mr. Fuchs gets up here and talks about he wants to go to Afghanistan. He's worried about his wages getting garnished. All that stuff was already in place. So what are we talking about here? If there's no additional consequences beyond, a couple of extra $100 a month, is that really a motive to kill a mother and 3 children? I would submit that doesn't make any sense whatsoever. And remember, the guy from DSF that they called, the Department of Financial Services that they called in, went through each of those consequences and acknowledged that if there was already a child support judgment in place, Mr. Segura would already be subject to all of those consequences. The other thing that I want you to think about there is that Mr. Segura already knew exactly what to do about the arrearage judgment that had been placed upon him. What Tamiyah Hawkins said was that last time he got a child support judgment against him, it was in excess of $20,000. What did he do? Did he kill her? Did he kill his daughter? No. What he did was he went to court. Now the state wanted to introduce evidence that said, oh well, if he filed something with DCF, they were just going to ignore that and go forward. So what? They're not the court. They're not the final arbiter. He can file a petition with the court like the DFS guy acknowledged, and he can go get a final determination from the court. The other thing that I would ask you to consider, and the state mentions this as an indication of motive, I would say that it is an indication of motive, but not motive to kill, but rather to legally deal with the problem. He had already started the process of contesting paternity because Ms. Peters had left him voice messages saying that he wasn't the father. That process hadn't even worked through yet, right? Why is he going to go through the process at all of filing documents with the court, contesting paternity, if he's just going to kill everybody, right? It doesn't make any sense for him to cut that process short and just kill everyone when he may very well be able to get paternity determined and get out from under the child support judgment altogether. Even if paternity had been established, however, Tamiyah Hawkins told you what he did with the child support judgment last time he had it imposed against him. He went to court, he told the judge about the fact that he had bought diapers and made payments, and it got reduced from over $20,000 down to $9,000. When Mr. Segura testified here, he told you that in this case, he actually had receipts of payments and diapers and this kind of stuff, so he stood an even better chance of being able to get his child support arrearage judgment reduced. And again, he already knew how to stay out of jail by making partial payments, keep his license by making partial payments, how to avoid garnishment by working out of state. His job didn't require a professional license. When you look at that and realize that all of the consequences that the state is suggesting as motivation were already in place, nothing about that motive theory makes sense. Tamiyah Hawkins' testimony absolutely eviscerates the foundation of their entire case. There's absolutely no additional sanction that Mr. Segura is facing as a result of this new child support judgment. The other thing I'd like to point out that the state conveniently ignored yet again, they didn't present it during their evidence, I had to extract it from Sergeant Corbett, so I'll mention it again. He's talking about all these text messages that Brandi Peters was sending. Oh, these mean text messages, she's taunting him. Something changed in between then and Friday, didn't it? Y'all remember that? What changed? Brandi Peters sent him another text message after he came over there on Wednesday. And this is going to be a theme throughout my closing. Let's rely on Brandi to tell us things so we don't have to divine things for ourselves. Mr. Segura, we know, based on his phone records and his own testimony, went over and saw Ms. Peters on Wednesday, right? Sergeant Corbett said that the phone records showed that. After he goes over there on Wednesday, on Thursday at 9:58 a.m., he gets a text from Ms. Peters. What's the tone of that text? Is she taunting him? Is she talking about child support? Is she saying she's going to have him put in jail? No, none of that. Her exact words were, "You was looking good. If you wasn't my baby daddy, I would have given you some. LOL, exclamation point." Does that sound like somebody who's trying to mess with him, get him sent to jail, get his driver's, or does it sound like somebody who's been appeased by whatever conversation they had on Wednesday? That text right there, again, further serves to absolutely eviscerate the state's motive theory. Henry had dealt with Brandi. He went over there, and it's like he said, they're like any other couple that has a sexual relationship. They fight, they make up. They fight, they make up. That's part of the pattern of their relationship. And that's what happened here. That's what Ms. Peters' own words indicate. And the phone records further suggest that Mr. Segura wasn't making up this story about going over to her house to have sex once he realized his initial lies to law enforcement weren't going to work. The phone records prove that what he's saying is true. They corroborate what he says. As soon as she sends him that text, what happens? They haven't been talking on the phone at all. Not in months. All of a sudden, she sends him that text. Boom. 2 minutes later, one call. "I can't talk right now. Call me back in a few minutes." He does. They talk for half an hour. Mr. Segura said when he testified that they were planning to hook up the next day, which would have been Friday. Friday, they have a couple conversations in the morning and then talk for an hour on the phone. Does that look like somebody, when, again, they haven't talked in months, does that look like somebody that's fighting? Or does it corroborate Mr. Segura's testimony that they're planning to hook up? As soon as they finished that conversation, around 11:30, 12, whatever it was, you see Mr. Segura's phone travel into town. But when he gets to Brandi's house, she's not there, so he goes over to his sister Sean's house. Sergeant Corbett and Mr. Sawicki both agree that Sean's house is consistent with the phone records. Remember, when we introduced those maps, we showed that he wasn't line jumping between Sector 2 and Sector 1 for a couple of hours there, between 1:30 or 1:41, I think it was, and about 3 o'clock. After that, he goes back over to Brandi's because she tells him she'll be home with the girls after she picks him up from school. The phone records are consistent with that too. After 3 o'clock, he starts sector jumping again because he's back up at that church parking lot where he told you he sat waiting for Brandi's mom to leave. Finally, he said she left around 5 o'clock. The phone records support that too. He continues to line jump for a while there after he goes over to her house. Both of their phones then are inactive for about 25 minutes or so between about 5 o'clock and 5:25 while Mr. Segura says they have sex. So as we go through the rest of the evidence and talk about the motive, I want you to keep in mind that there is no evidence that supports the state's motive theory. Okay? That's a big piece of missing evidence that I want you to keep in mind, because nothing else makes sense without that. Another group of evidence that I want to analyze under the lack of evidence prong of the analysis here is the evidence from Jack McLean Park. If you could go to that first slide there. All right. So there was testimony about a scene potentially connected to this murder at Jack McLean Park. I had to introduce that evidence, so those pictures are before you, and there's some other physical exhibits that we'll talk about in a little while here. The first thing that I'd like to talk to you about as it pertains to the question of whether Jack McLean is related to this murder is its proximity to Brandi's house. You could see from Sergeant Corbett's maps that Jack McLean is a matter of a quarter mile or so away from Brandi's house. Now, another question is whether the trash can would have been changed out during the time between the murder and when it was discovered here 6 days later. I mean, I don't know if any of y'all have ever been to a city of Tallahassee park. I've never seen any park anywhere around here where the trash is changed every single day. And on top of that, this isn't a trash can at the front of the park where people go all the time. This is when you go in the park there. I'm sure people are familiar with it. You turn to the right. You go all the way to the back of the park where there's a pavilion and there's a bathhouse. This ain't picnic season, right? It's the same date as it is right now. Right? It's 6 days after this. The murder was today. The Jack McLean scene was discovered 6 days later. So anybody out there having picnics, and remember this was also Thanksgiving week, right? So even if city workers would have normally been working, and even if city workers would have normally changed the trash can on a semi-regular basis, there's no evidence that would have happened here. And what I would say beyond that is that if the state really believes that, rather than trying to suggest it indirectly through investigator Lewis's, I have training and experience about, nobody has training and experience about who changes trash cans, but okay, that's what you want to say, let's go with that. Why don't you just call the person who changes the trash can, right? You the party with the burden of proof. If you want to exclude every reasonable doubt about whether this is related to the murder, why don't you just call the person who changes the trash can, or get records from the city of Tallahassee to demonstrate that it was changed if you think that happened. They didn't do that. They don't have any evidence of that. They prefer to rely on conjecture. Another thing that I'd ask you to consider as it pertains to Jack McLean Park is that there is evidence of a crime recovered by FDLE experts here. First, Joel and Brown identified blood on one of the latex gloves that was found in this trash can. You can start going through there. Next slide. Next slide. So there's a bunch of latex gloves that were discovered in this trash can, I think 5 or 6 of them. They're in evidence. They're defense exhibits in this case. Joel and Brown discovered another set of gloves. There were 7 gray gloves that she found. Some of those also had blood on them, if you recall, and I know y'all were taking thorough notes and were taking notes throughout the entire trial. Blood was also identified by FDLE expert Diane Guzman in 2018 when the collared shirt that was found there was tested for blood for the first time. There was also a t-shirt with red-brown stains on it that we'll talk a little bit more in a little while. That one did test negative for blood, but you can see on it that there's a puncture wound from which the red-brown stains emanate, and as Joel and Brown said, if you set something on fire, that can have the potential to ruin DNA, and it may test negative after that. Another thing that I asked Investigator Lewis about was the fact that there was an empty box of shop towels found in and around this, and if you go through this, one thing that you'll notice is conspicuously absent from the trash itself. You can keep going. Notice that in none of these pictures are there any of these blue shop towels. Keep going. Go back one, please. That box right there is the empty box of shop towels, and the only one that you see in any of these pictures is right over there. So there, you have a whole big box of shop towels. You can go to the next one. You got a whole big box of shop towels, but no shop towels to be found until you get inside here. Go a little farther, and we see that somebody's been flushing them down the toilet. Now, is that by itself prove that this was necessarily a cleanup scene? No, but you got to take everything together, like Mr. Fuchs said. There was also a bleach bottle that was found at the scene. Now, I imagine that the state is going to try to suggest that perhaps all this stuff is from a janitor or something. But one thing that I would ask you to consider about that argument is as follows. Number one, we're not talking about a single set of gloves here, or even a couple of pairs of gloves. This is one bathroom and like 14 different gloves or pairs of gloves here. You can get the exact number if you want to see them in evidence up there. Same thing for the gray gloves. Again, these are some of these are bloody gloves, same as with the white latex gloves. And there's multiple pairs of each. Again, there's an empty box of shop towels there, but no shop towels to be found, indicating that they were flushed. And another thing that's recognizable outside here, go to the next slide, keep going, is you'll find new clothing tags in and around the scene where all this stuff was found. Go to the next slide. Another UPC code there indicating that, that new clothing was purchased. Probably the most relevant thing and the best indicator, however, that this isn't anything that a janitor did is the point that Investigator Lewis begrudgingly admitted, which is that all of the garbage was set on fire, right? That's why it's all burned up, because somebody set it on fire. I doubt any janitor that's cleaning those bathrooms is going to do all the cleaning, get blood all over everything, and then set it all on fire unless it's evidence of a crime. That doesn't make sense. Now, another thing that you should consider about all this evidence, now having discussed what evidence potentially links it to this case and to this scene, the state didn't test the bloody collared shirt, which is also in evidence as a defense exhibit, for touch DNA. It only swabbed it for blood until 2018, after Mr. Segura had been in custody for 7 years. What that touch DNA analysis showed was that there was foreign male DNA at multiple locations upon the shirt. Mr. Segura was excluded from that touch DNA. To this day, the t-shirt that was discovered with red-brown stains on it has not been analyzed for touch DNA. To this day, the latex gloves that were discovered have not been swabbed for touch DNA. To this day, the gray gloves that had blood on them have not been swabbed for touch DNA. To this day, the bleach bottle that they found has not been swabbed for touch DNA. And the UPC codes that they found there were never followed up on either. Remember what Mr. Knox said a homicide detective or investigator can do when they get UPC codes close in time to when those items were purchased. They can go to the originating store and they can get video associated with that purchase. That would have been pretty good evidence, huh? I mean, wouldn't it have been pretty compelling if they'd gone to Walmart and got a video and it showed Mr. Segura, for example? That'd be an example of excluding reasonable doubt, right? But that's not what they did. They just left it sitting there on the garbage and took pictures of it. Now, another point that I want to talk about relative to the lack of evidence in this case is the lack of evidence connecting Mr. Segura to the actual crime scene on Saddle Creek. Mr. Fuchs kept using the term an absence of evidence is not evidence of absence. I don't know what exactly that meant, and Joel and Brown didn't know exactly what that meant. But I think it's important to focus on the phrase excluded here, because excluded is not an absence of evidence. Excluded means there is evidence, we can compare your profile to it, and it ain't you. That's what excluded means. So let's go through and talk about the DNA found at Saddle Creek that excludes Mr. Segura. There was DNA found under Brandi Peters' fingernails. That excluded Henry Segura. They never did bother to take any scrapings from underneath the children's fingernails. There was some testimony about the fact that they were short, and what? You can't get dirt, grime, skin under short nails? I mean, it's certainly worth a try. They got it from underneath Brandi's nails, and some of her acrylic nails were broken off. Henry was also excluded from the DNA found on the phone cradle. That's an important point to realize. I know that there was some dispute about whether it's a Vila, whether it's not a Vila. Even in the best case scenario, and according to Kevin McElfresh, it isn't Henry's DNA and it isn't JaVonte's DNA, which means it's a foreign male's DNA on the phone cradle. Henry was also excluded. Actually, I'll go through and I'll give you the state's exhibits here in case you want to note that. So with the fingernail scrapings, that's going to be states 103C, H, and I. With the phone cradle, it's going to be states 35. The next item is the DNA that was found on the phone cord, which is attached to the phone cradle we've been talking about. That's State's Exhibit 34. Henry was excluded from that DNA. The reason I'm talking about these surfaces in particular is because they have apparent connection to the murder. Remember, there's that big scuff mark on the wall by the phone. The phone cord is ripped out of the wall. The phone cord is cut in half. All of those are indications that that particular object, those particular objects are relevant to the murder investigation. So he was excluded from the phone cord as well. He was also excluded from the DNA mixture found on the projectile, which was recovered from the hall closet. That's State's Exhibit 26. He was excluded from the DNA found on the shovel next to the victim's body. That's State's Exhibit 76. He was excluded from the phone plug in the kitchen, which I believe was also unplugged. That's State's Exhibit 96. His DNA was excluded from the mixture found on the exterior of the purse. Remember, there was testimony that the purse was picked up, dumped out, all the contents were rifled through. He's excluded from that DNA. He's also excluded from having touched the contents of the purse. They took 5 swabs off of various places on Ms. Peters' wallet, and he was excluded from all of those except one where they could make no determination because JaVonte's DNA was potentially included there. He was excluded from the DNA mixture recovered from the blood droplet in the hallway at the entrance to the common bathroom. We were going kind of fast there, so I don't know if that testimony landed with anybody, but that's State's Exhibit 17. So there's a blood droplet on the carpet as you're going into the bathroom where the children were found. The major contributor to that blood droplet was the twins. Obviously, it's the twin who was shot, Tamiyah. But there was also a minor profile within that blood droplet. Mr. Segura was excluded from that blood droplet. That was State's Exhibit 17. He was also excluded from surfaces around the bath bar, which we'll talk more about later in great detail. But let me just talk about some of the surfaces that were found in close proximity to the bath bar for your consideration as well. He was excluded from the DNA swab of the bathroom faucet in the common bathroom. That's State 61. He was excluded from the DNA on the swab of the flush handle in the common bathroom. That's State 65. He was excluded from the DNA on the exterior doorknob for that bathroom. So that doorknob had to be opened. There's foreign male DNA there. JaVonte's excluded. Henry's excluded. Even on the blood smear on the back of the wall where the bath bar is, that's only Brandi's DNA. There's no minor profile. He hasn't contributed to that at all. Now, we know that Henry was in fact there, so why are we talking about all these surfaces where there's no evidence of his DNA? Well, because we're talking about surfaces related to the murder, right? That's why he's not on these surfaces. If they had tested surfaces that were not related to the murder, they may well have found touch DNA from him. For example, if they had tested the sheets in the bedroom, or if they had tested the pillowcases in the bedroom, if they had tested the couch cushions where he said he was sitting with the kids and Brandi, any of those places may well have yielded touch DNA, but understandably, that's not what they were looking for. They were looking for relevant information as it pertained to the murder. Another thing to keep in mind is that there was no blood transfer. Remember, I asked Investigator Lewis about the fact that they had executed search warrants at Mr. Segura's house in each of his 3 vehicles. He had the white Monte Carlo, the green truck, and his wife's vehicle. And what Mr. Knox said is that anybody involved in perpetrating these murders would have been covered in blood spatter from Ms. Peters. There would have been blood transfer in any vehicle that they rode in. Yet all of his vehicles were dirty, but without any evidence relevant to this case. That's one thing I'd like you to consider there. Another thing to consider as we're talking about the lack of evidence at 908 Saddle Creek is the lack of testing on the hairs. Now, I know you guys, again, were taking thorough notes, so you probably noted some of the hairs that they found didn't meet the criteria for DNA analysis, which is to say that they didn't have roots. Other ones did have roots and were capable of being analyzed, but they didn't do that because Investigator Lewis or anybody else from the Tallahassee Police Department didn't ask him to do that. Another important point I want to make outside of the DNA as it relates to the lack of evidence developed at the crime scene is the lack of evidence pertaining to the shoe impression and scuff marks. Again, Investigator Lewis said a search warrant was executed at Mr. Segura's house, and upon all his vehicles, they had access to or possession of every single pair of shoes he could have worn. And they never bothered to gather or test any of them against the scuff marks that they recovered from the crime scene, nor the shoe impressions that were identified at the crime scene. And then finally, there again, they had the ability to perform soil analysis on that shovel. Mr. Fuchs' suggestion was that, perhaps that was something that the kids brought in. We'll talk more about that later when we're talking about some additional DNA analysis, but they didn't do the soil analysis. Certainly, if it revealed that there was soil consistent with coming from Brandi's backyard, that would undercut any argument that it could be potentially a calling card from actual Los Zetas cartel members or people, for lack of a better expression, who want to be affiliated with them locally. Another thing that I think it's important to consider is the lack of injuries present on Mr. Segura. So Mr. Knox did indicate that Ms. Peters had a whole bunch of defensive wounds, but that she also had broken fingers and bruised knuckles, and some of her acrylic nails were torn off. And remember what he said. He did this motion and said those indicate that she would have grabbed at her attackers and potentially sustained injuries to her hands doing that. And this was a dynamic and prolonged struggle. We know that also that she was scratching at least one of the assailants because she had foreign female DNA discovered underneath her fingernails. Now the state suggests that maybe this is from a nail tech, but I would make a couple of points about that. First of all, you can't just say stuff like that when you're the party with the exclusive burden of proof. If you think that, why don't you go ask her sister, who's sitting right over there, where she gets her nails done at, and then go ask for buckle swabs from those folks. That would be a means of excluding every reasonable doubt. But they didn't do that. They just threw that suggestion out there for you to consider. Another important point relative to the possibility that the DNA under her fingernails is from a nail tech is that the acrylic nails growing on top of her own nails have grown out a discernible space there. What that obviously means, I'm sure that the female jurors who've gotten acrylic nails can explain to the males, is that that acrylic nail has been on there for some time. It wasn't done within the last week or so. It's been there for some longer period of time, which of course is also inconsistent with the state's suggestion on that point. I think that it's also important to consider that we also have potential foreign blood spatter in the foyer of the house. And that was discussed, number one, on the tile next to Brandi's body. Each of them testified that there was a round blood droplet on the floor there that wasn't consistent with impact spatter coming from Ms. Peters, wasn't consistent with cast off from a weapon. And again, we also have foreign blood identified going into the common bathroom on the floor mixed with one of the twins' DNA right there. That's important. That's important as it relates to the evidence found at Jack McLean Park, because one of these sleeves here, in this sleeve here, you can see that there's a puncture wound, or rather a puncture to the cloth on the shirt, and that is the area from which these red-brown stains emanate. It's, I would say, the most reasonable interpretation of that evidence, in light of the blood droplets that we have on scene and the spatter analysis performed by the only people qualified to perform that analysis in this case, is that potentially one or more of the assailants had suffered injury during the attacks here and were bleeding. Now, when you look at Mr. Segura, you can go to those pictures. When you look at Mr. Segura, there's no obvious injuries. There's no visible injuries, and of course he's light complected. So if there were injuries consistent with having battled Brandi Peters, those would have shown up. You can go to the next one there. Again, no obvious injuries, certainly no injuries consistent with having been gouged by acrylic nails. He does have a few minor scratches, which you can barely see, of course. You can go to the next one. Same thing, go to the next one. All right, you can go back. None of those injuries are in any world consistent with having battled Brandi Peters and having been scratched. Those are consistent with exactly what he described, that he went to his buddy's house, he shot arrows, and he reached into the bushes, to go ahead and grab the arrows. I mean, you don't have to be a board-certified medical examiner to identify what looks like a scratch from reaching into a bush and what would look like a scratch from being gouged by a person with acrylic nails. I also want to talk about the lack of evidence supporting the state's theory about the time of death. So I would direct your attention back to the fact that Officer Jernigan testified that Monica Peters told her on the morning of 11/20, when the bodies were discovered, that she had last spoken to Brandi Peters at about 10 o'clock the night before. Now, although Monica Peters claimed that Brandi's phone, or home phone, was disconnected, the circumstantial evidence indicates that's not true. There's no reason why Brandi would have run to that home phone in the back of the house in her bedroom if the phone was disconnected. Moreover, the assailants would not have had to yank the cord out of the wall, nor would they have had to cut it. If, however, you want to assert that, probably the best way to do it is to just get the phone records. We're sitting here 9 years removed from the murder, and still the state doesn't have any phone records relating to Brandi Peters' home phone. If you wanted to exclude the reasonable doubt about whether Brandi was still alive at 10 o'clock, probably want to go ahead and get those records. We can also talk about Brandi's cell records. Mr. Fuchs stated in his first close that in the weeks leading up to the murders, we can see that she's active on her phone. They didn't give you weeks. They gave you a week. 1 week, and this day is different than the other days. It's a holiday Friday, number one, and number two, we know that she has company, right? Mr. Segura's over there from like 5 o'clock to 8 o'clock, 8:15, and then immediately after that, we know that she had another visitor in a dark-colored SUV based on Marquise Davis' unrebutted testimony. Those two things distinguish this day from other days, and I would suggest if you really want to establish that there's actually a pattern of never being inactive for more than a couple hours, give us a month, give us 2 months. Call detail records are not like text records. They don't evaporate after a short period of time. You can go back and get call detail records back and back and back. Those records aren't in front of you. You got a week. So that's what you have to draw a conclusion based on. I would also say that, it probably goes without saying that the state is going to try and make some argument about why Marquise Davis is either lying or wrong or whatever. But if you think that's true, you can get his records too. I mean, I understand law enforcement didn't talk to him initially, but I disclosed him as a witness in 2017 or so. They've had every opportunity to go get his phone records like they did for everybody else. If he didn't leave his house around 8:15 like he said, or I guess it would have been about 7:45, got back about 8:30, if that weren't true, his phone records would show that. You could impeach him with that. That would be a means of excluding reasonable doubt about the fact that other people were over there after Mr. Segura left. But of course, they didn't get that either. In terms of lack of evidence, I also want to talk about the opportunity that Mr. Fuchs keeps referring to. Keep talking about Henry's this big, strong guy. Where is that evidence? I mean, you can see him. It's not like he's some bodybuilder, right? He wasn't a bodybuilder at the time. No, he's not a little weak, like wafy guy either, but there's no evidence about what his physical abilities are. And the way that Mr. Fuchs is describing what a welder does is, to me, kind of indicative of somebody that doesn't do blue-collar work like that. Welders aren't carrying around giant sheets of sheet metal. They have laborers that do that. They're skilled trade workers that stand in a place or on a scaffold or on a high-rise or whatever they're working on, and they put the pieces together after the laborer brings them up. Moreover, the only evidence about Mr. Segura's physical abilities at that time indicate that he had recently undergone an invasive intestinal surgery to remove a bullet. That's why he's got that big 9-inch scar on his stomach. You don't have to go back to it, that's fine. That's why he's got that big scar on his stomach right there. And remember, both Mr. Segura and his friend Adam Thornton testified that Mr. Segura was not yet back to a full workload on the jobs that they were doing. So all this talk about he's got opportunity because he's the Incredible Hulk is just inconsistent with the evidence that's before you. I'd also want to talk about a lack of admissions by Mr. Segura. So I know that there's Kelsey Kennard, and we'll talk about that. But remember what Investigator Johnson said about the fact that Mr. Segura's vehicle was like wiretapped or bugged or whatever for 8 or 10 months, and they didn't get a single admission at any point in any conversation with anybody during that time. So in the 8-10 months following the murder, before he goes up to Minnesota to work on those jobs, doesn't talk to anybody, doesn't make any admissions to anybody, but the second he gets to Minnesota, he can't stop writing raps and telling people about all the children that he's killed. That doesn't make sense. That's inconsistent with common sense. Another point that I would try to make is, regarding the lack of evidence pertaining to admissions, The state came back in their rebuttal case and tried to suggest that Mr. Segura had secret knowledge of facts of the case were not readily disclosed to the public. I would first say that it defies common sense to think that the family members of the victims are not going to immediately ask how they died and that law enforcement would not immediately tell them how they died. Now, if I knew they were going to make that suggestion, I would have just called Pine, but I didn't, so I didn't. What I can rely on, though, is the burden of proof. Because what would the best evidence that Pine, Marguerite Douglas, did not tell Mr. Segura that day, the 20th, that the children were drowned? What would the best evidence of that be? Probably call Margaret Douglas herself, right? She's here. We all know who she is. She was interviewed in this case. That would be the best evidence. If you're the party with the burden of proof and you're trying to actually exclude reasonable doubt, you probably want to go get her rather than suggesting that's what happened with witnesses who don't have firsthand knowledge. I'd also like to mention, in terms of the lack of evidence, the lack of follow-up on other potential suspects. Back in 2011, remember, TPD conducted a confidential informant operation where they sent Gregory Washington as a CI to talk to his cousin, DeMario Paramore. Lieutenant Basio at the time was listening over a wire to their conversation, and upon some prompting and being reminded with his report, he admitted that he heard Mr. Paramore admit to having participated in these murders. That was the quote. I know it was phrased a little bit differently during the state's case. For any of these things, if you have factual questions about them, don't rely on me, don't rely on him. You can ask the court reporter to read back any portion of any of the evidence to you. So if there's a dispute about that, you don't have notes, you don't have a recollection, just ask. You can hear anything you want. What Basio actually said upon prompting on cross was that, yeah, Mr. Paramore admitted to having participated in the murders and explained why they killed the kids. Dead men don't talk. That was the quote. Lieutenant Basio had to admit also, though, that he never bothered to talk to any of Mr. Paramore's alibi witnesses. He had to admit that he never bothered to get his phone records. He had to admit that they never bothered to send off his DNA buccal swab until I kind of gave him a hard time about that at a deposition in 2016. And even at that point, he didn't follow up to make sure they tested it against the appropriate number of exhibits. He just made sure it was sent off and left it at that, and there was no testimony elicited from any of the FDLE experts or McElfresh or anybody else about what, if any, comparison was done between Paramore's buccal swab and any of the evidentiary exhibits. And then last, as it relates to the lack of evidence, I'd like to talk about briefly Tyra Wilcoxon here. So the starting point with her, of course, is that she's a jaded ex of Mr. Segura. Their last interaction was her calling his wife to say, hey, I'm sleeping with your husband, and him kicking her out of the car and leaving her on the side of the road in Georgia. Not a great place to start if you're trying to determine if a witness has bias or an axe to grind, right? What she said when she was testifying under oath before you is that she only called Crime Stoppers in order to make a record in case something happened, that she had knowledge about this case. But then she was impeached with prior sworn testimony where she admitted that she had actually hired an attorney, Mr. Waters, to try and sue Crime Stoppers to get the money that she was really after here. That's what motivated her to make these allegations. She was trying to get the Crime Stoppers money. Most importantly, though, and this is the biggest point with Tyra Wilcoxon, she said that Mr. Segura came to her house to get this gun on the 16th, that Tuesday, the week of the Classic, right? We know that the state has both of Mr. Segura's phones, the records for both of his phones. If that were true, if his phone records showed that he went to Tyra Wilcoxon's house on Tuesday during the week of the murder, don't you think they would have introduced that evidence? Wouldn't that be good evidence to corroborate what she was saying? Again, they didn't introduce that evidence because that's not what the phone records show. It's their burden to exclude every reasonable doubt. It's their burden to introduce evidence which corroborates their witnesses if they want you to rely on that testimony, and they simply didn't do that. Another area where reasonable doubt can arise, as the jury instruction indicated, was conflicts in the evidence. And I'm not going to spend a ton of time here because this kind of bleeds into the evidence itself, but there are a couple of individuals that I'd like to deal with in the conflicts in the evidence section. Mr. Fuchs mentioned Kelsey Kennard. One of the factors that the court gives you to weigh, and this applies to multiple witnesses in this case, number 9, has the witness been convicted of a felony? or a misdemeanor crime of dishonesty. But in Mr. Kennard's case, it was multiple felonies. He was serving a long federal prison sentence. So that's something that can weigh against his credibility, or should weigh against his credibility. Another factor that you can consider is, has the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify? Well, we know that's the case, right? If there was a stipulation read to you that after he offered that videotape testimony, guess what he got? Motion for substantial assistance, sentence reduction, out of prison. Essentially, he got the benefit he wanted. And the instruction says that you're to take special care when evaluating that testimony. And in fact, there's a special instruction that applies specifically to a situation like this, and I'll read that to you as well. You must consider the testimony of some witnesses with more caution than others. For example, a witness who hopes to gain more favorable treatment in his own case may have a reason to make false statement in order to strike a good bargain with the state. This is particularly true when there's no other evidence tending to agree with what that witness says about the defendant. So while a witness of that kind may be entirely truthful when testifying, you should consider his testimony with more caution than the testimony of other witnesses. However, if the testimony of such a witness convinces you beyond a reasonable doubt of the defendant's guilt, or if the other evidence does so, then you should find the defendant guilty. Again, he had already received a sentence reduction here, and the jury instructions specifically tell you to give special care when evaluating his testimony. Another of the factors that Judge Hankinson has instructed you to consider when weighing the credibility of a witness's statements and testimony is whether the witness at some point made other statements that were inconsistent with the testimony offered in court. In the video that you saw played here in court, Mr. Kennard said Mr. Segura admitted to killing 3 children. He said that he drowned 2 and shot 1. He said the kids came home while he was killing Brandi. Lieutenant Basio, his video was played on the back side of that, and I know it was quick, so if you didn't get notes about it, if you don't remember it, you can ask to come back out and watch it again. What Lieutenant Basio said is, Kennard didn't say anything about kids during his interview at the prison back near the time of the offenses. A pretty important detail not to tell somebody when they come all the way to Texas, I think it was, to interview you. Lieutenant Basio also said that Kennard offered absolutely no other details about the nature of the killings. Nothing about kids drowning, nothing about kids coming home, nothing about shooting, at least as it pertains to the kids. He said Brandi was shot. Another factor that the court has instructed you to consider, and this applies in Mr. Kennard's case as well, is does the witness's testimony agree with the other testimony and evidence introduced? Mr. Fuchs pointed to the fact that Mr. Kennard said at one point during his video testimony that he killed the baby mama because of child support. Well, I don't know how, again, it was quick, so I don't know if you caught that, but he also said that one of the reasons was that she had a drug debt, and he was trying to say that there was some sort of drug debt with Mr. Segura. What that should indicate to you is that he's just pulling media reports from anywhere he can get them, mangling everything together and trying to give something that sounds credible or believable. Beyond that, I mean, there's additional evidence that is readily disprovable that Mr. Kennard provided. So one of those things, one of those pieces of evidence that's readily disprovable is that he hid a gun or the gun in the engine block or around the engine block of this Monte Carlo. Okay, so the Monte Carlo was subject to a search warrant. It was seized in 2010. They still got it. It's still at TPD. In their impound lot or at whatever, tow yard that they subcontract with, they got it. Okay, so if that gun is in that car, they could go get it right now and get it before rebuttal. But of course, they never did that, and they don't have that evidence because that isn't true. Another thing to consider as it relates to the Monte Carlo and the text message that Mr. Fuchs pointed out about getting rid of the Monte Carlo. Again, it's stolen. Its VIN is on the engine block. If it's not stolen, that'd be pretty good evidence, right? If Mr. Segura is trying to get rid of this car that Mr. Kennard is suggesting is involved in the murder as a hiding place, and it's not stolen, that would completely undercut his explanation. They've had 9 years to run the VIN and see if it is in fact stolen. I can promise you, if it wasn't stolen, you would have heard a witness come in and testify that in order to rebut Mr. Segura's testimony. Another important piece of evidence that is inconsistent with what Mr. Kennard said is the weapon that was used. Mr. Kennard said that Henry admitted to having a 9mm gun. Of course, the weapon used in this case was a .32 revolver. Mr. Kennard also said that the kids came home while Brandi was being killed. That's not in any way consistent with what the physical evidence shows. That's not possible in light of the physical evidence, is what I mean to say there. So the exchange that took place back in the bedroom, that's relatively quick, right? Because there's not a lot of bloodletting back there. She doesn't suffer any significant injuries back there. There's a struggle over the phone. There's 2 shots fired into the bathroom. There's 1 shot fired out the window. There's a shot back towards the door to the bedroom that goes into the closet. And then there's a struggle down the hall, but Brandi makes it outside. If at any point the kids are walking across the street while the stuff in the bedroom is happening, they're probably gonna notice a bullet smashing the window and coming out the house. Even if they don't have the judgment to stop right there, where is the beating taking place? Immediately inside the front door. And how did the police find the front door? Locked. All of that is inconsistent with what Mr. Kennard claims about the kids coming home and walking in on the murder taking place. On top of that, think about where Taniyah is shot. You know, she's not shot in the face as soon as she walks in the door. It's on a couch or near the couch, which is, you know, several, like 8, 10, 12 feet past the tile foyer area. That couch is saturated with her blood, and that's her only injury. So we know she's well inside the house when she's shot. Another piece of evidence indicating that the kids did not come home and walk in on this murder. Just the clothes they were wearing. We're talking about the same time of year we're talking about now, right? It's cold outside. Anybody notice that? JaVonte was barefoot and had no shirt on. Just had his corduroys on. Is that consistent with him having just walked back across the street from eating dinner at the neighbor's house? Similarly, Tamiyah is wearing little pink shorts and a little tank top, and she had those pink slippers that were cast off at various points in the living room as well. Again, given how cold it is outside, I would suggest that the evidence is inconsistent with the notion that she had just walked back across the street in a little tank top and shorts from eating dinner at the neighbor's house. Another witness that I'd like to discuss under the conflict in the evidence section of the analysis is Kevin Mapafresh. You can go to that left paragraph there. Okay, so there's a number of points to make with Mr. McElfresh. The first point that I'd want to make here is, yes, he's paid, but that doesn't necessarily mean that he's any less credible. That's one of the factors that you can consider. The court instructed you about that, but that's true of any expert that testifies, right? They should be paid for their time. That's what they do for a living. The thing that was kind of shady about Mr. McElfresh is he's the only expert that tried to fudge what his time and therefore money earned on the case was. On direct examination, he says, oh, I've worked 8 to 10 hours. Then on cross, I remind him, well, you said 8 to 10 hours last November when I was deposing you. By the time we get done going around and around about when he worked, when he came up to Tallahassee and all this kind of stuff, it's closer to 30 hours. And oh, I thought it's time analysis, time spent actually working on the case versus traveling, blah, blah, blah. It's 30 hours, or roughly thereabouts. He's the only one that had a problem downplaying the amount of time that he had spent on the case. Obviously, another question to consider with him is whether his testimony agrees with the other testimony and evidence offered in the case. So Joellen Brown and Kevin Oppinger both testify that Brandi, the twins, and JaVonte are all included as contributors to the mixture of DNA obtained from the swab of the bath bar. And this is the profiler swab of the electropherogram swab of the bath bar right there. Joellen Brown and Kevin Oppinger say that because JaVonte's DNA is present, you can't make any determination about Henry's potential contribution to the mixture. A good example of why that sound analysis can be seen by looking at Brandi Peters' mother. Remember what Joellen Brown and Kevin Oppinger said about that. Because Brandi is a contributor to that mixture, when they ran Brandi's mother's profile against that, they couldn't exclude her either, right? That's something that you should consider as it relates to Mr. Segura. Anytime JaVonte is present, it's going to be difficult, if not impossible, to make a determination about Mr. Segura's contribution to that mixture. Another thing to consider with respect to this mixture is that there are only 2 foreign alleles in the entire data set here. So there's this 12 down here at D5, which is the start allele, and then there's that 16 there at D8, which is also a start allele. A couple of important points to make about that. First of all, I would ask you to recall Joellen Brown's testimony. It was actually from Mr. Fuchs' first direct of her. Hopefully some of you took notes about that. What she said about frequency of occurrence when you're only looking at 1 or 2 allele is that the frequency of occurrence on that could be 1 and 2. Half the population could be included. Now, she didn't do a statistical calculation, but she's giving you a rough idea. When you're working with 1 or 2 allele in a big data set like this, that doesn't tell you a whole lot, even if it was potentially his DNA. So that's not something that tends to lend itself to reliable interpretation. It's also important to remember, I would submit, that Mr. McElfresh did his interpretation with knowledge that the state wanted a particular result. Remember what his testimony was. So he's hired in 2016. They want him to look at all the complex mixtures. He looks at all the complex mixtures. He gets paid to do so. He opines at the time that the only exhibit about which he can offer additional testimony is the swab of the phone cradle. Only after the state calls him and specifically says, can you do something different with the swab of this bath bar, does he say, oh, you know what, as a matter of fact, I can do something different with that bath bar. And let me guess what you want me to do. Henry Segura included? Boom, there you go. Henry Segura is included. It's important to remember what Joellen Brown said about unbiased testing. Remember what she did? Before she got standards for all these other people, she did her analysis. She determined what she thought was there before she was looking for people, before she was looking for known potential contributors. What really blows up McElfresh's testimony on the bath bar interpretation, though, is what Mr. Bundy testified to. So we'll stay on this electropharogram for a minute here. First things first. I had all the witnesses testify, all the DNA witnesses testify to this, including McElfresh himself. But SWGDAM, first and foremost, what's everybody admitted SWGDAM requires is that any analyst interpreting data out of a particular lab use that lab's interpretive guidelines. FDLE's interpretive guidelines prevent analysts from doing inclusion on less than 100 RFUs. And that's important. Here's why. Analysis, reliable analysis, is based on 2 factors. Of course, like Mr. McElfresh said, it's based on the experience of the person doing the analysis. But just as important, it's based on knowledge of the instruments being used. And Mr. McElfresh has absolutely no specialized knowledge of the instruments being used. This is an important distinction to make. He does have specialized knowledge of how these molecules work. He was part of the working group that helped identify which markers they were going to use for DNA comparison. That doesn't have anything to do with the profiler validation, either at the developmental stage, which is where the manufacturer goes through and does all these tests to ensure that the instrument is reliable, or at the lab validation phase, where they test their instruments under certain conditions and make sure that they're reliable. And what FDLE said, based on all of their testing, was that you can't do reliable analysis at less than 100 RFUs. Mr. Bundy also said that when you're looking at the sample, the first problem you're going to run into, if you're trying to do inclusion on any male, is the quantity of male DNA present here. Remember what each of the analysts testified to about the amylogenin marker here. That's the gender marker here with the XY. All of them said amylogenin is going to be the highest quantitative value, the most accurate representation of the amount of biological matter present for each of the contributors. At the largest and easiest to amplify locus, amylogenin, we have 1,041 for the X, which is the female marker, and only 85 for the male. At the best locus, males, whoever the male is only showing up at 85 RFUs, which is going to make trying to include a male at any of these other loci virtually impossible. And that's what Mr. Bundy said was one of the first problems with what Mr. McElfresh had done here. The second problem, and this is obviously indicative of the reason why SWGDAM requires analysts to use the specific guidelines developed for use in a particular lab, Mr. Bundy says this 14 right here is a Rockstein key. That means, again, in case you didn't get notes, I know that part's kind of complicated. The way that they amplify this biological material is they use different colored dyes. Sometimes the dye from this row of the electropharogram will bleed down here and it will create a steady peak pattern throughout the entire third row. Because Mr. McElfresh doesn't have any specialized knowledge of FDLE's instruments, he didn't know that that was a rock sty peak, and so he used it when it shouldn't have been used at all. Another problem another problem with Mr. McElfresh and his analysis as it relates to this evidentiary exhibit here is that he's, of course, using star allele, and we've talked a lot about that. You can't do inclusion analysis on peaks that are lower than 100 RFUs. Another problem that he had is that after he did inclusion at whatever locus he was going to do it at, he used FDLE's frequency of occurrence tables to give you statistics, 700 billion times more likely. What's the problem with that? Mr. Bundy said those frequency of occurrence tables are based on frequency of occurrence, and I guess let me kind of back up and tell you what that means. So what they're talking about when they say frequency of occurrence, that deals with how commonly are you going to see a 7 at D5? 1 in 600, 1 in 600,000. But the important thing as it relates to this exhibit is the frequency of occurrence tables are based on frequency of occurrence in unrelated individuals. You can't use those tables when you have multiple related individuals contributing to the mixture as you do in this case. That leads not only to inaccurate analysis, but inaccurate statistical reporting. Another problem here, as Mr. Bundy indicated, is that Mr. McElfresh is doing inclusion at locus where there's absolutely no indication of contribution by anybody else, let alone a male. So a good example of that is at D3. So all of these analysts testified to the fact that peak proportions are generally indicative of DNA coming from a single person. So here we have peak proportions that are almost identical. You have a 15 at D3 and a 17 at D3 at 245 and 246 RFUs respectively. That's one of the locus that Mr. McElfresh is using to do inclusion statistics there, and that's not a reliable method of DNA interpretation. Last, Mr. McElfresh only had part of the information. He was only relying on this profiler electropherogram. In 2015, remember I introduced this exhibit through Mr. Bundy. In 2015, the swab of the bath bar was rerun on a more modern kit, on Identifiler Plus. We have that electropherogram. With the more modern kit, what do we notice? The 12 he was calling down here at D5 drops out altogether. What about the 16 at D8? It's dropped out altogether. Those were the only two foreign allele. Now these are in two different places, so let me point this out for you. This is where the 12 would have been on the last electropherogram down here at D5. It's dropped out. Up there at the top left, you see that the 16 is dropped out as well. This is a more modern kit, and it reveals exactly what FDLE guidelines are designed to prevent. Calling peaks that aren't real peaks. That's why they have that rule. It leads to false inclusion. Now I know I'm covering a lot of stuff. Some of this is really boring. I'm sorry. I only get one chance to talk to you, so I have to cover it all. Obviously, this is a very important case. The last thing I need to talk about is reasonable doubt based on the evidence itself. Remember, reasonable doubt can arise based on the evidence, lack of the evidence, or conflict in the evidence. We've made it to the last section. I know you're all thrilled about that. The evidence. What does the evidence itself show? First, let's talk about time of death. The medical examiner did not say, and you can read it back, she said it multiple times, did not say a couple hours. That's not what she said. Dr. Flanagan said the food in the victim's stomach was digesting for a few hours. A subtle difference, but an important difference, because we're talking about close timelines here. Here's why that's important. Mr. Fuchs knows he doesn't have any evidence that's even moderately inconsistent with what Artron Simmons and Marquise Davis say. And so, the closer back in time we can move that timeline, the less bad it looks for the state. And so let's talk about each of those guys one at a time. So Marquise Davis. He says that he fed the twins and JaVonte oxtail soup at 7 or 7:30. That was his unrebutted testimony. The state has absolutely no evidence which excludes the reasonable doubt created by that testimony. Their obligation is not to introduce evidence inconsistent with reasonable doubt. Their obligation is not even to present evidence more believable than evidence that creates a reasonable doubt. They have to exclude reasonable doubt, disprove, eliminate reasonable doubt. They don't even have evidence that's inconsistent with what Marquise Davis says. And I suppose when Mr. Fuchs gets back up, he'll have some arguments, not evidence, but arguments as to why Mr. Davis shouldn't be believed. Why? I can't think of a single reason why. I encourage you to try and think of one if you can. Why would Marquise Davis lie on behalf of Henry Segura? They don't know each other. They've never even met each other directly. Mr. Davis cared for Brandi and her kids. Miss Peters was his girlfriend at the time, fiance at the time, her best friend. He took care of the girls and JaVonte 2-3 nights a week, fed them dinner. Why would he lie for some guy he doesn't even know? That defies common sense. He has absolutely no reason to offer false testimony in this case. His sole motivation is that he's been called to testify truthfully, and he's offered that testimony. I would also submit to you that Mr. Fuchs mistakenly mischaracterized what Artron Timmons' testimony was. And I'll remind you, and if there's any dispute about it, if you don't remember, if you don't have notes, go ask the court reporter. What Artron Timmons said when he got up the first time was exactly what Marquise Davis said. He said the girls and JaVonte ate dinner at their house about 7 o'clock. Mr. Fuchs had to call him back to try to correct that. Remember, he gave him his statement. Well, this says right here that your mom, you all called the kids back over about 5:45. Good, okay, no more questions. Then I got up, read the next line of your statement. What's that say? Oh, at 6:15, my mom sent me to get paper plates so that we could actually feed the kids. He's 14, he ain't got a driver's license. He's gotta go at least half a mile to whatever store he's going to get the paper plates. And when I asked him the next question, what's the answer? When'd you get back with the paper plates? I don't know, 7:30? That's the unrebutted evidence about when their last meal was. And you have to take Dr. Flanagan at her word. She certainly ain't gonna lie for the defense. She said a few hours from their last meal. That puts the time of death 10, 10:30, 11 at the very earliest. Why is that significant? Everybody agrees. Corbett agrees. Sawicki agrees. Henry agrees. Everybody agrees. Henry's back down in Woodville by 9:30 p.m., never comes back up anywhere near Brandi's house that night. That was the undisputed, unrebutted testimony by both cell phone experts. And it's not as if either of his cell phones are just sitting there unattended. Remember what Corbett said Henry was doing for the rest of the night. He's sitting there texting with Natasha Hawthorne, trying to set up his next hookup. I would submit to you that the combination of the time of death with Mr. Segura's activities that evening by themselves conclusively rebut any idea that he could have been involved in the commission of the offenses. We also have eyewitness observations, which at least circumstantially corroborate what Mr. Davis and what Mr. Timmons says. Number one, Marquise Davis again testified that he saw a dark-colored SUV in Miss Peters' driveway when he got home. Henry's gone by then. Remember, the phone records show him on Paul Russell Road at 8:21 p.m. There's a communication on his phone. And when Marquise Davis gets back to his own house at 8:30, he sees this dark-colored SUV. Does that mean that the person in the dark-colored SUV is killing Brandi and the kids? No. Remember, the food in the stomach says they got to be alive till about 10:30 at the earliest. But what it does mean is that if somebody else is visiting her, there's a reason why she's not using her cell phone, which the state is pointing to as their only piece of evidence to suggest that she was dead earlier than what Dr. Flanagan is requiring her to be dead. DeHanna Scott, another witness, neighbor of Brandi Peters, says when she gets home at 11 p.m., she sees a white SUV in Brandi's driveway. I don't really know if the state's trying to do something by introducing a picture of Brandi's mom's car, eliciting testimony that Brandi's mom has a white SUV. Nobody said anything about Brandi's mom being over at Brandi's house at 11 o'clock on the night of the murders. If Brandi's mom was there, she would have gone inside or not been able to get a hold of anybody, and she would have called the police, presumably. In any event, there's no evidence about her being there, and any suggestion that she's there is simply based on conjecture and not evidence. And again, state's burden, introduce evidence, not simply get up here and talk. Then you have Darius Mount, who corroborates what DeHanna Scott says about the dogs going crazy, barking right at Brandi's house, so crazy and so out of the ordinary that he calls the police that night. All of these things, while individually not conclusive, are circumstantial pieces of evidence. We've also talked about the kids' clothes. While Brandi's clothes are certainly indicative of stuff that you would normally wear during the day, and so are Taniyah's, Tamiyah and JaVonte's are not in any way. And again, remember, this is Friday, this is a holiday weekend. They're probably staying up later than normal. At least two of the kids are dressed for bed, and that's something that you can take into account when you're weighing the time of death. And then lastly, remember the testimony that the twins' TV in their bedroom was on when officers came in the house. If they're just coming across back from the street and they're walking in on a murder, I doubt they're going to have time to go in their bedroom and flip the TV on before they get killed. That's just another piece of circumstantial evidence that you can consider. Another important area of evidence that we have to talk about when we're talking about reasonable doubts based on the evidence is the evidence which tends to indicate that multiple people were involved in the commission of the offense. Now, we've talked about the fact that Henry was excluded from all this stuff. Now I'm going to run through these, and I'll do it as efficiently as I can. All of the foreign DNA, that is DNA which is not from Brandi, the twins, JaVonte, the officers, friends, family, all the foreign DNA found in the house, and not just found in the house, found on murdery surfaces. Keep an eye on that as we go through each of these exhibits. So there's foreign female DNA under Brandi's fingernails. We've talked about that. I'd like to stop there for a second, though. What do you think the state would be saying if it was Henry's DNA under Brandi's fingernails? You need not look at another exhibit. Brandi's calling to you from beyond the grave. Brandi's sending you a message from beyond the grave. We have foreign female DNA under her fingernails. And maybe it's a nail tech. I don't know. Don't worry about that. That's not sufficient when you got the burden of proof. You have to do something to show. If you have an idea about where you think it's from, you got to introduce evidence to do that. In the absence of evidence, what we have is foreign female DNA identified by their expert, as it were, underneath her fingernails. There's foreign female DNA on the interior front doorknob as well, which, again, that's significant because it was locked. That's State's Exhibit 22. There's foreign male DNA on the swab of the back of the shovel. We don't know definitively that that shovel has anything to do with this. We don't know if it was there the whole time. We don't know for sure that it was a murder weapon. Mr. Knox said it didn't appear to have been used as anything, and there wasn't spatter on it consistent with it having been on the floor the whole time. What we do know, however, and this is relevant, Mr. Fuchs said, why is it there? Kids bring weird stuff inside. Not these kids. Their DNA was excluded from being a contributor to the mixture on the shovel. That's important to keep in mind as well. So it excludes Mr. Segura, it excludes the kids. There's foreign male DNA on the shovel. That's State's Exhibit 76, area number 5. There's foreign DNA on the phone plug in the kitchen, which I believe, again, was also unplugged. Brandi, Henry, the police, Brandi's family and friends are all excluded from that. There's foreign DNA on the purse in Brandi's bedroom. Again, that's dumped out. That's State's Exhibit 32. There's foreign DNA on the contents of the purse. There's 5 areas of the wallet that were swabbed, like we talked about before. On Area 1, Brandi and the twins were included. Henry and JaVonte are excluded. Foreign male DNA was identified. On Area number 2, foreign male DNA was found again. Brandi was the major contributor. The twins, JaVonte, Henry, all excluded. Area number 3 of the wallet, foreign female DNA was found. Brandi was included in the mixture. The twins, JaVonte and Henry, all excluded. Area number 4, it was indeterminate because JaVonte was a potential contributor to the mixture, and so no determination could be made about Henry. But as it relates to area number 5, foreign male DNA is found again. Brandi is included. The twins, JaVonte and Henry, all excluded. And this is significant because, again, it's not just some random, item. It's an item that appears to have been picked up. Everything's dumped out of it and rifled through. So that's something that you can take into account as well. As it relates to the blood droplet that's outside the common bathroom on the carpet right there, the twins were the major contributor to that droplet, but there's foreign DNA in that droplet as well. Brandi, JaVonte, Henry, all excluded. And again, this is important because it's consistent with the other droplet on the tile out in the foyer that appears not to have been deposited by Brandi. It's not blood spatter, it's not impact spatter, it's not cast off, it's a straight downward blood droplet on the tile out there. That was State's Exhibit number 17. On the projectile discovered in the hallway, this one's important as well. Only foreign DNA is found on that. Brandi's excluded. Remember, this is the shot that's fired from the bedroom and into the hallway closet. Brandi's excluded. The twins are excluded. JaVonte's excluded. All the officers, families, friends excluded. Only foreign DNA is noted on that. That's State's Exhibit 26. On the swab of the bathroom faucet in the common bathroom where the kids were found, foreign DNA discovered again. All 4 victims were included, but Henry's excluded. On the swab of the exterior doorknob going into that bathroom where the kids were found, again, Henry and JaVonte, all the officers excluded, and foreign male DNA noted. Likewise, on the bloody collared shirt from Jack McLean Park, the touch DNA developed by Diane Guzman revealed foreign male DNA. All 4 victims and Mr. Segura were again excluded there. Another important piece of evidence or type of evidence that I would say gives rise to a reasonable doubt when you're talking about doubt based on the evidence is evidence indicating multiple weapons being used. So, as Mr. Fuchs indicated, we've got multiple shots being fired by the .32 revolver. We've got 4 shots at least fired in the bedroom, 2 in the bath. Remember, there's 2 in the master bathroom. One of those strikes the shower, one of those strikes the toilet. We've got one that goes out the window, that's 3 shots. We've got one that goes into the hallway closet. It's important to note that the one that goes into the hallway closet couldn't have been the one that struck Brandi, if any struck her in the bedroom, because it doesn't have her blood or DNA on it. There's only foreign DNA on that projectile. And you know, she's shot 8 times, so we're potentially at that point at 12 shots, and then Taniyah was shot as well, so that puts us at potentially as many as 13 shots, which would have required the assailants to reload twice. In the best case scenario for the state, they have to reload once. The reason that's significant, again, it's a prolonged dynamic struggle with Ms. Peters. If somebody's having to grapple with her, fight with her, strike her, they're probably not going to be able to calmly reload their revolver, which is, you know, much more difficult than a semi-automatic. And again, dump all those shell casings out, not drop them on the floor, put them in a pocket or a bag or something else. There's none of those on the ground anywhere, and then reload the gun and fire more shots. We also have a circular weapon being used, and the wound patterns are consistent with that according to Mr. Knox. You can go to that first autopsy photo. All right, so this one's significant and important because this was the one that both Knox and Mr. Lafort said can't have been deposited by a firearm. There isn't a firearm that has, you know, like a 4 centimeter perfectly round shape like that. It has to correspond to the type of weapon that would have caused the injury, and that injury, according to both experts, is not consistent with having come from a firearm. Now, I think it's important to draw a distinction between what Dr. Flanagan is doing and what Mr. Knox and to some extent Mr. Lafort were doing. Dr. Flanagan is looking only at the wounds, right? And so the best testimony she could offer for the state is, sure, these are consistent with having come from a firearm. That's possible. And yes, it is consistent with any number of other weapons. Again, state's obligation is to exclude every reasonable doubt, not introduce one possible version of the events. That's the first problem. Second problem, she's only looking at wounds. She's not looking at cast-off. She's not looking at, you know, the kinetics and physics involved in inflicting these wounds relative to the crime scene. She's only considering one piece of the puzzle. So when she says it's consistent, that shouldn't carry as much weight, I would submit, as when people qualified to testify in all the forensic disciplines offer their own opinions on that topic. Another thing to keep in mind as we go to the next wound here, we see this oval injury to the forehead. You can go to the next one. Again, oval injury. Remember what Calvin Moore said when he was testifying. He offered this voluntarily. The state was trying to get him to say, yeah, that looks like the .32 that I saw Henry with, and he voluntarily offered. Yeah, but the butt on that one was more square. Remember him saying that? That's inconsistent, certainly with the round one, and then obviously with this oval-shaped injury as well. The next type of injury we have are the teardrop injuries that Mr. Knox pointed to on the other side of Brandi's head. After that, we have the crescent-shaped lacerations. These are the straight ones here that we're looking at, which, again, we're going to be corresponding to the shape of whatever object, some sort of straight object that struck her. Next photo. These are more of the straight injuries that Mr. Knox was referring to. This is one of the crescent-shaped ones. Now, again, Mr. Knox was not saying that these injuries could not possibly have come from a firearm. What he's saying is that based on his wealth of experience, all of his training, all of his experience, all of his education in all of these forensic disciplines, that's not the most likely explanation. The most likely explanation is that some different weapons are used. And we know at least a couple of different weapons are used because both he and Lafort opine that, okay, we know a gun's used because she shot a bunch of times, but also some object of at least a couple of feet in length has to be used. So that's 2 different objects right there, and there's no indication that one person would have been able to wield both of those as this prolonged dynamic struggle is ongoing. Another piece of evidence that's consistent with their opinion is that as you go outside the home, we may have passed these, but actually let's go through these first. Go back one slide. Okay, so as they talked about the blood spatter analysis, I want to remind you of a couple of things. So this cast-off spatter here at the top of the door, Mr. Knox said was from cast off from some long object coming down like this. And as it came forward, it was slinging the blood. That's why there's high volume. That's why there's high height. What he and Mr. LaForte also said is that there's upward traveling cast off right there, consistent, and it goes up, it actually goes up under that curtain right there on the door. That's consistent with backward motion. So you've got one person standing on this side of the door, moving forward. You've got another person on this side facing this way, and their weapon is going backwards. So you have cast off consistent with two different positions by two different people there. Same thing as you look at the east wall here. Next slide. Next slide. Okay, so on the east wall here again, Mr. Knox said that this was impact spatter consistent with downward motion from a weapon. The person would have been facing that east wall. That's consistent again with the void pattern in the spatter on the west wall. Remember how we talked about that west wall wasn't covered in spatter like the front door was and like the east wall was. Again, that's consistent with multiple people being in multiple locations. Of course, none of those opinions exclude, and Mr. Knox acknowledged that, none of those opinions exclude the possibility that this is one person moving into different locations. But in light of all of the evidence, he didn't find that to be most likely. What I would submit is the most compelling evidence that multiple people were involved is the shoe impression evidence. As you go back and you deliberate, you're going to have an opportunity to talk about how credible each of these witnesses are and were. I would submit to you that Mr. Knox was the most credible witness either party called. He wasn't married to one opinion. He didn't try to go too far for he just told you what it was. And his credentials are impeccable. He's the only person that's qualified to testify about each of the areas of forensics that we discussed. And his opinion was that these are 5 different shoe impressions or probable shoe impressions. Could he say definitively, yes, these are absolutely shoe impressions? No, he didn't try to say that. He said, based on my experience, my training, my education, each of these are most likely shoe impressions. What he said beyond that is that, number 1, the officers are excluded from having deposited each of these, and number 2, these are each different from the other. These are 5 separate, distinct shoe impressions. Like, I don't know, to me that's the end. What else can you do about that? You don't have an expert that says anything different than that. I called the FDLE guy, even though he didn't agree, because I'm just putting everything in front of you. Right? I'm not afraid of the evidence. I called all the FDLE people. I called all the state experts because I got the evidence in this case. That never happens for a defense attorney, but that's what this case is about. So even though he disagreed with Mr. Knox, I called him, and his opinion was kind of consistent with what Mr. Knox said. He wasn't comfortable saying these are probable shoe impressions. He said they were impressions. None of them were left by law enforcement. That's at least somewhat consistent with what Mr. Knox says, and I would submit that Mr. Knox is the best witness to get that evidence and information from because he is the most qualified and he's the person who has the most training, knowledge, experience, and education dealing with each of these topics. And before moving on from this photo, I think it's also important to note, I know it's been a long time, but whoever the evidence tech from TPD was that put down all this leucocrystal violet, remember what she said about why she put it down? Because she thought those were shoe impressions. That's why she did that. That's what she testified to. She thought that as well. Now, she wasn't qualified to go do all the shoe impression analysis, but she didn't have to be. She created the evidence, she got the evidence documented, and somebody that was qualified, Mr. Knox, took a look at it. And then we come to Santos' testimony. So, I like to think, as I think most attorneys do, that I'm not an idiot, okay? And so what I mean when I say that is I know that Santos has obvious credibility issues. I'm not blind to that fact. I'm not asking you to believe every word he says. I don't believe every single word he says. But the reason I call him is that significant parts of his testimony, material parts of his testimony, are corroborated by other important testimony, more reliable, more objective evidence and testimony. So the first thing that I want to talk about, just in passing, I suppose, is the fact that one of his statements is typewritten. Mr. Fuchs keeps coming back to this point. I think it bears mentioning that's what investigators do. Investigators for his side. Mr. Newland's done that in this case too. That's what they do. That's what they're supposed to do. They go talk to a witness, they do an interview, they take notes, and then they go make a typewritten statement based on that interview, so it's not all sloppy and ugly looking, so that the attorney reading it can read it, right? That's why they do that. So any suggestion that that's improper is frankly simply silly. Going on past that though, I think there's important pieces that we can talk about here. So I guess I'll talk first about the mental health evaluation that Mr. Fuchs referenced. That's funny to look at because you look at the date of the evaluation and the date of the report, it's 7/31 and August 1. There's a second report from the same guy with the same evaluation date and the same report date that says something totally different. And I quoted that during Santos's cross-examination where it's talking about there's no evidence of any mental illness and he's manipulative basically. He does what he wants to do to advance his own agendas. Does that mean that he's not lying? Certainly not. And is there a way to tell what he's being totally truthful about and what he's lying about? No. I mean, like I say, there are pieces of evidence which corroborate some important pieces of his testimony, but we can't tell for certain what all he's being truthful about. So let's talk about the things that can be corroborated. So one piece of evidence that corroborates his testimony, and I understand the timing on this could make it that, you know, it's kind of like a self-fulfilling prophecy. He hears about it and then offers testimony about it. But the fact is, this guy, Demario Paramore, confessed to a confidential informant on a recorded line, and Lieutenant Basio stated that he heard that confession. That corroborates what Santos says. Again, is that definitive? Certainly not, and that's not the best piece of evidence that I'm going to refer to in supporting parts of Santos' testimony. Another thing that I would ask you to look at, and again, this is just circumstantial, Mr. Fuchs asked a bunch of witnesses about domestic violence. You get very angry. Doesn't that lead to violence and escalating anger? Folks, this ain't baby mama drama stuff. This is the most heinous violent offense in the history of Tallahassee, right? That's not domestic violence stuff. That's not, oh darn, I gotta pay another $200 a month. That's not what causes this offense. That doesn't make a father of 4 go drown babies. Doesn't make a man who just had sex with this woman go beat her face in. That doesn't make sense. This offense is so violent and so heinous that it tends to be what Dr. Dela Cruz, as quirky and weird as he is, said. This is more consistent with a cartel hit. And I know that sounds kind of too fantastical to be true. I mean, that sounds more like movie-ish. It sounds like throwing something at the wall. But when I get to the most compelling evidence which supports Mr. Santos, hopefully you'll see that evidence the way I do. Another piece of, I suppose, circumstantial corroborative evidence is that the spade placed near the body doesn't have spatter on it consistent with being at that location during the murder, and Dr. Dela Cruz testified about the fact that if the Zetas are involved, that can often be a calling card indicating their involvement. One circumstantial point, one additional circumstantial point that should be mentioned is, there was testimony elicited by the state, okay, Brandi's living in Section 8 housing, where's the money? She got all this cocaine, where's the money? There were grazing references to where the cocaine went, and you can extrapolate that. But I would submit that based on the testimony, the most likely destination for that cocaine was Kalo. Monica Peters testified about Brandi's relationship with Kalo. Santos testified about how Kalo was actually in the federal detention center over on Capitol Circle in 2010 at the same time, which puts the timeline for him being federally indicted for cocaine trafficking kind of in the same time frame that Santos was talking about the thefts taking place. Again, Brandi was dating Kalo, and JaVonte was rumored to be his child. That's who Henry thought was actually JaVonte's father. That's who Brandi was leaving him messages about, saying JaVonte's dad is this other guy. So, is that definitive proof? Of course not, but it's one potential explanation based on evidence for where that cocaine went. And we should also talk about, of course, the DNA that links Avila to the scene. And this is another point of contention between McElfresh and Joellen Brown and Kevin Noppinger. I think it's important to stop at this point and remind you who Joellen Brown is. She isn't just some hack that I hired. I didn't pay her anything. She's not my witness. She is or was at the time, the senior biology analyst at the Florida Department of Law Enforcement Tallahassee lab. She's their trial horse. She's their war horse. She's the one they ride into battle. Why do you think she got this case? She's the senior analyst. She's the CODIS administrator. She's the one who's in charge of, she's the gatekeeper for people putting evidentiary exhibits into CODIS. Why? Because she knows best. She's got experience doing complex work like this. That's why she got this case in the first place. And it's also important to realize, based on the cross-examination the state tried to do, she is the only one who handled this properly. FDLE hid the exculpatory DNA match through CODIS from the state attorney, because the state attorney has an obligation to turn over all exculpatory evidence, and they always do that. Mr. Fuchs does, and Mr. Campbell before him. They hid that in violation of FDLE operating procedures from Mr. Campbell at the time. That was a violation. The only person who followed FDLE operating procedures, as she said, was JoEllen Brown. So this suggestion that she was like forced to retire or something, which she was the only person who didn't violate, was frankly patently absurd. And she clarified that point herself. So before we talk about the analysis, I just thought it was important for context to understand who JoEllen Brown is. Again, she's spent her entire career helping law enforcement agencies, helping the state attorney develop evidence for use in criminal cases, and helping them secure convictions. Do you really think on the most serious, most heinous, most disturbing, most disgusting case that she's ever handled, just all of a sudden, out of the blue, for no reason, she's gonna flip on FDLE and help the guy who may have committed these horrible murders? That doesn't make any sense at all. Her testimony is unbiased. She isn't getting paid. She's a law enforcement witness, a career law enforcement witness, testifying truthfully for the defense because that's what the science most accurately supports. So we have the context now, and again, as I go through, I'm going to refer to her because she's the most credible, but my witness, Kevin Knoppinger, just kind of said he agreed with everything that she said. So let's talk about what she said relative to the DNA. You can go to that slide that depicts, there we go, okay. So this was JoEllen Brown's analysis. This is not a situation like we were dealing with the bath bar, where you got two allele, okay? Look at all these matches. He's a 12 at D8, it's a 12. He's a 8-10 at D7, you got a 10 plus. He's an 8-9 at THO, you got an 8-9. He's an 11-12 at D13, you got his 12. He's a 9-11 at D18, you got his 11. He's a 17-18 at VWA, you got his 17. At TPOX, he's a 9-11, you have his 11. At D18, he's a 15-18, you got his 18. At D5, he's an 11-12, you have his 12, and then this is the significant thing because under the FDLE operating procedures and interpretive guidelines, this is the one that allows you to do inclusion statistics. You have a genotype. A genotype is when you have both allele from a contributor. If you don't have that, you're not allowed to do inclusion, but you do. You have a genotype here and he matches every place else. Yes, there's masking going on. Yes, there's dropout going on. But she isn't violating operating procedures like McElfresh did to arrive at this conclusion. She's not using any start allele. She has a genotype. She's properly and unbiased, in an unbiased fashion, interpreting this DNA evidence based on her training and experience. Now, on top of the DNA analysis by a law enforcement analyst who links Mr. Avila to the scene, remember I had her look at the actual electropharogram and she looked at it and said, yes, he is included. You have Avila's own testimony and his own behavior. So the first thing we know about Avila, you can go to that first highlighted page there. The first thing we know about Avila is that he's a real drug trafficker, like a Narcos style, you know, whatever movie, site, whatever TV series, like he's a Colombian drug trafficker. He was caught bringing there you go, 42.75 kilograms of high purity cocaine, $100 million worth of coke into the country on a ship. He's the captain, they catch him, right? So we know he's a real player. His testimony was that except for this little misunderstanding in the first day of his case, his boss calls his wife, I'm gonna kill you. Oh wait, that was a mistake, I'm sorry. Neither he nor his family are ever in danger. This is the federal judge's order and this is in evidence. Go to the next slide there. What does the federal judge say about him or his family not being in danger? In 2001, Quinones was not at liberty without risking the life or at least the well-being of both himself and his family and his friends to cooperate with the United States. The prospect of retaliation by the criminal enterprise was tangible and imminent, which accounts for his unwillingness to accept responsibility for his crimes. He told you he was never in danger. That's a bold-faced lie. Pretty sure we can rely on the words of a federal judge about what the situation actually was. Another point that we have to look at is that Avila claims specifically and repeatedly that he never actually cooperated against any person. Now, I just said, you know, my thing. That's not true either. The judge says he cooperated conspicuously by, among other things, returning to the courtroom in which he was convicted and sentenced, appearing before the judge who sentenced him, and testifying decisively against one of the princes, if not one of the kings of the Colombian cocaine realm in which he formerly operated. He goes on to say, a review of the transcript of Quinones' trial testimony against the guy, his boss there, which fully and accurately discloses his role in the 2000 criminal episodes and earlier episodes. So he's saying, I didn't cooperate against anybody. The federal judge says, okay, buddy, you're a liar. Okay, so we know he's lying. Now the relevant thing is not that he's lying, it's why is he lying. And the reason I would submit is because these facts go along with the defense theory here, and he knows that. I mean, I'm the one cross-examining him about these points on the video. Look, what I was suggesting there, as you saw yourself, is so you cooperate, you get a motion for substantial assistance, you've now helped them take down this part of the ring. He gets back to Colombia within 3 days of landing in Colombia. Even though he says all his associates have been arrested, he's contacted by the cartel and they're trying to bring him back in. That's what he says. What I would submit is that his life was in danger at that point because he cooperated, as the federal judge said it would have been. And so what does he do? He makes contact with a woman he hasn't seen in 10 years. He does a marriage by phone to her in Italy so that he can get a spouse visa, and he hightails it over to Italy, where he stays until after these murders are committed. Now, the state says, hey, look, he completed his college class, he paid his rent in November, and also he doesn't have a passport, because no illegal immigrants ever make it into the United States, right? Especially a boat captain. I'm sure he couldn't have found a boat over in order to illegally enter. Further, I'm sure no college student has ever passed a semester's class when they miss a class. That doesn't happen either, right? And then finally, when people go on vacation, they never pay their rent. Obviously, if they're not there, they don't have to pay rent. They don't have to pay their mortgage, right? I say that sarcastically just to make the point that, look, none of that stuff, none of that supposedly corroborative evidence proves anything of relevance. What we have lies about are the purposes for which the defense introduced this testimony. It's to show that he had a motive to be involved in this murder. It's that he had, remember I talked in an opening statement about wet work. That's what that is. That's why his own quote was, he went back in 2013 after these murders occurred to Colombia and could walk the streets in peace. That's what he said. Why do you think that was? Why do you think he hightailed it out of there with some chick he hadn't met or hadn't seen in 10 years, and then all of a sudden after the murders are going, I can walk the streets in peace after getting a 20-year sentence reduction? Does that definitively prove it? Of course not, but it's circumstantial evidence that points in the direction that I'm suggesting it does. Now, the last thing in terms of corroborative evidence relative to Santos that I want to point to are some things that show that he was actually, and again, this is the most compelling evidence that I was referring to, at least from my perspective. We know that they were in actual communication. Brandi and Santos were actively communicating with each other. When law enforcement went into her house, they searched the place, of course. They seized everything of evidentiary value. They found like 7 or 8 letters from Santos to Brandi, and these are all sent within like the 2 weeks leading up to the murder. This right here is the envelope that C.C. Timmons referenced. So the day before the murder, Brandi gets this letter, and she comes over to C.C.'s house, and C.C. described her as displaying mannerisms indicative of her being afraid. This is in evidence. What it says on the back of this envelope is, death before dishonor. Word is bond, bond is life, and a man should give his life before his word fails. Say what you mean and mean what you say. And it says below that, dear Mr. Mailman, if this letter happens to get lost, just send it to heaven because it's going to an angel. On the other side it says, I thank God for you, and I ask that he look out for you and our 3 little angels. Chilling, right? That's not me telling you Brandi was scared. That's her best friend. Her best friend is telling you she gets that letter. She knows what it means. Remember why this was introduced? It wasn't just that I introduced it. Is that the state's asking Mr. Santos questions. You don't even know her. What's she look like? Now, how old is she? What's her complexion? Suggesting that he doesn't even actually know her. That's not the case. We know that they're in communication. We know it for a fact. Her best friend testified about it. And the other thing that the communication show is, remember there was some reference to her emailing with Mr. Santos. Now, you may not remember this because it probably didn't seem significant at the time, but what Mr. Santos yet said is that he was using another inmate's Corlinks account, which is the inmate emailing service that they use at the Federal Detention Center, to communicate with Brandi. Now, Kayla was using that sometimes as well, but there were specific communications wherein Brandi's response indicates, Santos appears to be talking nonsense, but Brandi's responses indicate she understands the code language that he's using. Marriage, remember Santos says that means meeting up with somebody, that's the person who you're going to work with on this job. And so you can go to the emails. These are Brandi's own words. These aren't my words. These aren't Santos' words. These are Brandi's words in the days and weeks leading up to her murder. I'm not trying to get fucked up about no BS. I need to know what's going on. So before I send a pic or write back, I want to know his real name, date of birth. Is he really there? My life means a lot to me, as well as my 3 kids. Those are her words. She ain't writing that about Henry Segura. She's writing that back and forth about this guy that Santos is trying to send her to go see. Next one. This is sent just a couple of days before she's killed. And again, this shows that she understands what Santos means with that apparently nonsensical code. Tell Kalo that I really, really need to talk to him. These are all in caps, like it's depicted here. ASAP. If not, I'm going to do some crazy shit, and I know he don't want that. I'm going crazy right now, so he needs to let me know something, because I don't play with me and my kid's life. These are her words. Who knows best what Brandi's in danger from? Brandi does. Brandi knows best what Brandi's in danger from. You don't want to believe Santos? Don't believe Santos. Believe Brandi. You don't want to believe the shoe impressions? You don't want to believe the DNA? You don't want to believe the blood spatter? You don't want to believe the cell phone stuff? You don't want to believe Henry? All that's fine. Believe the one person who the state won't cross-examine. Believe the one person who is unimpeachable. Brandi Peters. She knew what she was in danger from. She knew best what she was in danger from. Her words alone, as are many of the other pieces of evidence I've talked about, are reasonable doubt in and of themselves. I appreciate your patience, everybody's patience. I know this has been long. I only get one opportunity to talk to you. There's a lot of evidence in this case. This was a 2.5 week trial, so there's a lot to cover, and I appreciate that you've all had paid attention to me this entire time. In closing, I just want to emphasize the importance of your job now. I've thought for a long time that I've carried this burden. We talk about burdens. The state has an evidentiary burden, but you have a burden and I have a burden, and everybody involved in this case has a burden of some sort because it's an important case. There's a lot at stake. Children were killed here. An innocent mother was killed here. She's got family. They deserve justice. Mr. Segura is a father and a brother and a son and a friend, and he deserves justice. Folks, justice can't start until the search for the right guy or right guys or right people starts. This has been 9 years in the coming. Mr. Segura has waited patiently for 9 years. I put him on the stand knowing he's not a superstar witness, right? Like, you would expect somebody that committed an offense like this to be well prepared, buttoned up, unflappable. That's not him. All I told him was get up there and be real. Like, you've waited for this moment, get up there and be real and be you. And they want to try and say because he gets frustrated that he's the killer. Is that your best evidence that he's the killer? He got frustrated? Look, as he told you himself on the stand, he's been in custody for 8 years for an offense he didn't commit. Who wouldn't be frustrated under those circumstances? Who wouldn't pop off under those circumstances? He doesn't even talk about it in terms of years anymore. He talks about it in terms of inches. His son Trey was this tall when he went in. His son Trey is now a college football player. You understand my point? His frustration is not in any way evidence of guilt. It's evidence of a man who has waited for you for too long. You're the only ones who can deliver justice. You have power in your hands now that you've never had and will never have again. You have the power to save, you have the power to take life. I ask that you follow the law that you promised to follow, that you hold the state to its burden, and that you find Mr. Segura not guilty.
Debated on timing, but I think we have to take a break, I'm sure. So I think what we're going to do is go ahead while we're doing this. Let's take a lunch break. Let's be back and ready to go at 1 o'clock. Don't discuss the case among yourselves or with anyone else. Have a good lunch. Let's go to sidebar, please. The lawyer.
All right, I thought that was pretty good. He did bring up some pretty good points, I think. We'll go through them. So Mr. Prince comes out of the gates. I don't know anything about Shakespeare. Don't have any clever rhetorical comments or rhymes. Let's just look at the evidence. Presumption of evidence unless it's overcome by and to the exclusion of beyond a reasonable doubt. State and defense witnesses are not on equal footing. And I promise I won't talk as fast. Go to the question that is actually at issue. It's been proven that 4 people are no longer with us, but let's go to the motive. Motive is where you should start. So he's talking about going to the jury, the jury instructions and the verdicts. Fuchs started off, Henry must have been afraid of jail because of losing license, going to Afghanistan to work, etc. Henry was already a subject to all those elements by Tamiyah Hawkins. Henry was sent to jail. Henry did lose his license. And I'll give him one. Okay, that's where I'll give him one. Henry still was on the hook for Tamiyah Hawkins' child. Right? He was still on the hook. So that's one. I say that's one in the reasonable doubt column. Is he going to go then, delete Tamiyah Hawkins and her child too? His child? I'll guess, obviously, but that's one in the column of reasonable doubt for me. Then he talks about the text messages and the phone calls to Brandi. Talked about his sister, Sean, because she lived pretty close. I think she was within maybe a couple hundred yards. I'm going to pull up the map again so we can look, because he talked about Jack McLean Park. We're going to pull that up. He talks about Brandi's mom left around 5. Both phones were inactive between 5 to 5:25 while they did what they did. And then he goes to Jack McLean Park. So let's pull this up again. We did this yesterday, and I thought this was a fun exercise. Let's do this again. Actually, I think I have to go here. All right, let's go here. Let's look at this. All right, let's look at this again. So this is where Brandi lives, right? So Jack McLean Park is, okay, there's that middle school, and we saw so Brandi's right there, right? We saw the high school is up here, right? High school is right there with the Raiders, and this park is right here. And he said that's a 1/4 mile. So remember, we were trying to figure out how close that high school is with the football team. So 1/4 mile, I think we figured about 3,600 feet. And I think, therapist, I think you said, sorry. All right, so that's where these clothes were found. So Brandi's down here in the corner, or I'm sorry, the bottom, and the park is up there towards the top. Right? So he talked about, Jack McLean Park and the trash bins, the gloves, the shop towels, and the shirt. So we were talking yesterday about, how there's so you can see the middle school is literally right next door, right? Then the high school, which has the football, which would have been Friday night. This happened 6:30, 7:30. Football games usually start. Do they start at 7 or do they start at 9? Probably 7 to 10. And then you got the park over there, right? What do you guys think? Oh, Baca, you're talking about, do we know that he wasn't going to go? Yeah, I don't know. And yes, OnlyFans, Santos is a serial confessor, believe it or not. Brett says, I see both Santos and Avila completely different than the defense, other than the part where the defense says even they think their witness lied about some stuff. Brett says, I hated the way he dissed what you believe. Eliminating reasonable doubt is all about whether you believe the doubt is real or imaginary, after all. All right, let's leave that up for a little while we continue on. And then he said, absence of evidence is not evidence that's absent. And Karen Cole did a whole take on that. So if you guys want to go check her out, I thought that was pretty good. And then he says, I'm not even sure what that means. No DNA under the kids' fingerprints. He's like, what? They can't get scrapings even though they said they were too short? Well, the kids were in the bathtub, right? So I think they explained that away. Here's another one. Slight reasonable doubt. Slight. Perpetrator would have been covered in blood, and thus the vehicle would have transfer in them. And they checked Henry's vehicles. Yeah, I agree. There definitely would have been blood all over, so somebody would have definitely been covered. All right, here's the next one that got me. Here's another one in the column of reasonable doubt for me was the lack of injuries on Henry. What do you guys think about that? And they showed a picture of him. He had a few scratches on his, I think his forearm maybe. But as we heard from multiple, two reconstructionists, crime scene reconstructionists, that this was a prolonged, brutal struggle, right? And there was blood from another outside source, not just Brandi. So, yeah, they showered. Okay, so I was just thinking that, but the kids were drowned. So, do you shower? You drown the kids and then you shower, then you put them back in? That doesn't make sense, right? Those kids were drowned, and you're not going to shower before you go drown the kids. Right? So that sequence doesn't make sense in my mind. Only Fanny showered, hence DNA on the bath bar. But think about that. You drown these kids and then you take a shower after they're drowned? And then you put them back in the tub? That doesn't make sense. Oh, is there widespread panic? You think there's a separate shower and tub? Was it? Oh, well, let's find out. Let us find out. We can see what this was. Is this a is this a two bath? Shoot, how do I get back to? I can't get back to it. All right. It is a 3-bedroom, 2-bath. All right, there you go. It's a 3-bedroom, 2-bath. So, and the master. Yep, you're right. You're absolutely right. Brett says gloves, long sleeve, lack of marks on him doesn't concern me. Okay. Welder workman jumpsuit only fan. And it is, yep. It's a 3-bedroom, 2-bath. All right. Good job, guys. Yeah, I think I recall the shower being to the left of the tub. Oh, there was a shower and a tub in that. And then there's also the master. Yeah. And Pammy says, yes, she had one in her bedroom and there was a communal bathroom. Right. Okay. All right. Fair enough. Okay, let's get back to this. Street view. All right, let's get back to this. Oh, street view. Let's get back to the map. Well, where are the photos? I wish I could scroll through these. Ugh, come on. It's being having trouble scrolling through. All right. Oh, here we go. Kind of kicks in. It's being very squidgy. Let's get to the bathrooms. All right. There's probably the master. I think that's the master. Or maybe not. Okay. All right. So if that's it, there's the shower. There's the bathtub. If that's not the master. But there's the shower. Bathtub, right? Shower. Okay. All right, so there you go. All right, so okay, so still so Brat, you think the lack of injuries, that's not a big one for you? Okay. All right, fair enough. State didn't pull the landline phone records. Questionable. Why didn't they do that? Because Monica, I believe, Monica Peters, who is Brandi's sister, initially said that they had talked around 10 p.m. that night, but they did it on the landline. So why didn't the state pull those records? Right? Why didn't they pull those records? Why do you think the state didn't pull those records? Only fan. I thought hazmat, but he'd have a jumpsuit more likely. So Brad, you think he did a good job personal forensics, but a really bad job with the digital forensics? Yeah. All right, I'll continue on, but think about why didn't the state? Why would the state not pull the records of her phone, of her landline? I mean, why not? Let's see what else. Let's see. Then they talk about Marquise Davis, who talked about another visitor with a black SUV in a driveway around 7:30. Talks about the 9-inch scar, and Henry's not full strength. Lack of follow-up with potential suspects. It's their burden to exclude all reasonable doubt. Conflicts in evidence. Talked about Kelsey Kennard. He was the guy in Oklahoma City. And then this I thought was really interesting. I know I'm covering a lot of stuff, and some of this is really boring. I only get one chance to talk to you. Like that was this really defeatist, right? It was like a defeatist attitude. Like, why would you say that? Okay, then he says, we've reached the last part. I know you're thrilled about that. Then he goes through, there was up to 13 gunshots. And we know Brandi got shot 7 times, and one bullet went through and hit her twice. So she got 7 shots, but 8 wounds, injuries, if you will. So I thought that was pretty interesting. So he counted 13 actual gunshots. So in this horrific scene, this, struggle, we know Brandi started in the bedroom, went down the hallway, she got outside, blood's going all over the place, and then she's in the foyer. That's when she's ended. So 13, and then, and that includes Tamiyah. So that's why he's saying it could have been one person. So then we're thinking, well, maybe it was 2 people. But that means they both had to have the exact same gun, and that doesn't make sense either. So 13 gunshots, but if it was the 7 crew or whatever, why would you shoot? So I'll counter his theory. So if there's a 7-person hit squad, why would they all have the same gun, same caliber gun? And maybe Fuchs will talk about this. Why would they all have the same caliber gun, and why would they not just shoot once or twice? Like, why this struggle? See, that's where I don't think this was a cartel. I don't think this was a cartel hit. I think they would have been in and out, done. They would have made it so messy. Or let me put it this way: I don't think the struggle would have happened. I don't think the struggle would have happened because they put themselves at risk of A, getting hurt, B, getting caught. Why do that? You're not there to get hurt or caught. You're there to do a job and get out. So up to 13 shots to me sounds messy, but also sounds like it was a very dynamic struggle. So how does he get off 13 shots? I have questions. And then this is not baby mama drama. This is the most heinous crime in Tallahassee. More consistent with a cartel hit. Disagree with you on that one. He talks about the letter, death before dishonor. And then Brandi's text to Kalo about being in danger. All right, I could see that. And then he talked about Henry getting up on the stand. He said he told Henry, just get up there and be real. And then he's like, is that your best evidence for him getting frustrated? Who wouldn't pop off? And then I asked you guys, has Mr. Prince changed your mind as to Henry's guilt? 80% of you said no, and 20% of you said yes. I have doubt, but I don't have enough that would make me say he's innocent. I think there's more evidence to show that he's guilty then that he's innocent. In other words, well, let me put it this way. I don't think it was a cartel hit. So if that's the defense saying, I don't think so. Yeah, Pammy, too much anger in the scene, for sure. Brett says, well, defense was right that the state had the burden. They also had the right to request some of those records. They didn't, because they prefer raising doubt over verifying that she made no calls. Good point. And you're right, because Mr. Prince said, you know, I, as a defense attorney, had to, you know, do this. I think he called up Mr. Knox, right? That's Michael Knox, who was the crime scene reconstructionist. He's like, that's unheard of, that, you know, that I would call this guy up. So to your point. Yep, to your point. All right. Let's move on. Now we're going to get back to state's closing rebuttal, I should say. This is going to be Mr. Fuchs, or I think it's going to be Mr. Fuchs again, I'm not sure. But this is just over an hour. And then from there, we have real short clips. So this is the longest one, and then we have real short clips. And guess what? There was a Billy Wagner hearing this morning, so we're going to cover that. We'll have time to cover that, probably around 4 or 4:30 today. So we're gonna cover that, guys. All right. Let us get back to. So this is going to be state's rebuttal closing. All right, let's get back to it. State's rebuttal coming up. Okay, I will see you guys on the other side.
Remain standing for the jury.
Everybody be seated, please.
Thank you, Your Honor. Back it up a little bit to ask a question. Most obvious question that should be asked out of all this. Why? It's an important question. Leads to answers. Why? If all that was said was true in Mr. Prince's argument, why did Henry Segura lie about being at the house on that day that many times? Why did Henry Segura set up an alibi with his phone knowing full well that he was at his house? Why? Why was her cell phone taken? The only thing out of this house that's been taken in this situation is her cell phone. Why? We're going to talk about that because it was incriminating against him. Why? Why is there only one void pattern in the blood spatter? One. A void pattern is a situation in which blood spatter is made and it is blocked by an object, specifically as we're talking about the person that perpetrated this event. There's only one void pattern. If there were more than one person, there would be more than one void spot, and there is not. There is one void pattern. Why is there only one shoe impression? FDLE and Mr. Knox testified that he saw patterns that he believed could possibly be shoe prints for further analysis. That analysis was done by Florida Department of Law Enforcement forensic specialist that is there to identify shoe wear and shoe wear impressions. And what he determined is all those other ones that Mr. Knox should have been processed and were processed were not shoe impressions. They were not footprints. One of them was. One. Why are all the wounds in one area? All of them are on her head and defensive. She has no lacerations. She's got no bruising. She has the gunshots, but she's got nothing from the beating except for in one spot, and that's her head. If you have multiple people doing this, you're going to get it in more than one spot. Otherwise, their hands are going to hit each other. If you get 2 or 3 people trying to beat her in the same spot, their hands are going to hit each other. And that's not what you have. There's going to be glancing blows. Why? And all of that means one person did it. One person, one void, one footprint, one location of the injuries. One person did it. What the attorneys, what I say, and Mr. Prince says, is not evidence. What is said is relevant isn't simply relevant because it said so. Your job is to look through each and every piece of this evidence and make that determination yourselves. Not what Mr. Prince says and not what I say. And one of the most glaring examples of that is the text messages or the emails that you just saw. And you're going to get a copy of these to take back there, and you're going to copy all of them. He left off the LOL in that response. He left off the fact that she wasn't going to do that because he wanted her to cover herself up because she's not Muslim. Ladies and gentlemen, these emails are all being sent by multiple persons, including Kayla. You got an opportunity to read them. They're in there. Including her friend, her boyfriend, Kayla. Mr. Santos got her information from Kayla in prison. Undisputed. And she starts getting random emails, random letters with random sayings throughout the letters. And she's concerned for her kids. Yeah, because she's got a random dude that's crazy in prison sending her emails. And she doesn't even know who he is. On November 12th, she's like, who is this dude? So is she fearful for her life because Santos is saying the stuff he's doing? Yeah. But not because she's in drug debt to him. But because she's a loving mother of three kids. And she's getting crazy person email. And she's getting crazy person mail. And even if you take what Mr. Prince said on its face, and notice he typed it out instead of showing you the actual emails. Even if you take it on its face, when she says, I'm not going to endanger my kid, wouldn't that also apply for all the time that she supposedly was running drugs for Mr. Santos? If she's not going to endanger your kid, is she likely to get involved in trafficking narcotics, driving to and from Texas and back with this person that she doesn't even know? For an email. No, she's not. Because again, the only reason that that is even remotely a piece of evidence in front of you is because James Carlos Santos said so. Dr. Hudson's report. His statement suggests a grandiose sense of self-importance in which he exaggerates achievements and appears to be preoccupied with fantasies of unlimited success and power based upon contentions he can influence from others based upon the contentions he can influence others from prison to continue with their criminal exploits. Based upon a self-report during our interview and what can also be inferred from other information, he may be interpersonally exploitive, taking advantage of others to achieve his own ends. That's what he does. He takes advantage of people. He tries to get them to believe in things. I get y'all to believe in him. But it's just not true. And it's not true, not because I say so, but because the evidence says so. Let's talk about some of the things Mr. Prince brought up. Jack McLean Park. Mr. Prince says, it's important. It's important because it's right there. Well, law enforcement did their job. They went out and they looked at it. They found out that it's cleaned out every day. Holiday fine, Thanksgiving, so the next day it will be. But not a week later. If it's simply proximity, do we also have to look at the trash cans at the fairgrounds? Do we have to look in the trash cans at the houses surrounding it? Do we have to look at the schools? The shirts were tested against DNA from 23 people, including the victims. Nothing. No evidence linking them at all. The investigation indicated it had been cleaned daily. No evidence at all. And finally, he says that there was a fire there, and that could have destroyed the DNA. I am not a fire expert, but I do know when you burn a white shirt, it turns black, and it gets burned. When you burn latex gloves, they melt. None of that was there. There was a fire at the bottom of the barrel, but not at the top where this stuff was deposited. There's nothing that links Jack McLean Park to this particular case. And the DNA testing proved it. And the follow-up investigation as to the relevance proved it. And common sense proves it. Marquise Davis, our dark SUV at 8:30. I saw the kids at 7:30. For some strange reason, there is a murder scene going on across the street from his house. Mr. Prince says he's got no motive to lie. I don't know why. But all I do know is it's not for 9 years, that he comes forward and gives this information. Doesn't tell law enforcement. Doesn't tell law enforcement when they're interviewing his fiance. Doesn't tell law enforcement when they're interviewing his stepson. Doesn't tell law enforcement as they're all over this entire neighborhood that, hey, by the way, I saw a car in the driveway. Somehow 9 years later, he remembers very specifically about what he saw. I don't know why he's coming forward. All I know is they're not fiancé anymore. I don't know. But his testimony doesn't even agree with Archon Timmons. Because he says, I saw him at 5:45. Henry Segura, even through his own admission, says he was there at 8:15. Mr. Davis says, I know the time because I last saw him at 7:30. Then I loaded up my car and I drove all the way across town to give food to my dad, and then drove all the way back. And it was 8:30. It just doesn't make sense. It doesn't corroborate with anything else. Again, 9 years before he makes his claim. Is it possible he's confusing issues, confusing days 9 years later? Absolutely, 100%. I'm not saying he's lying, don't get me wrong. I'm just saying he doesn't know what he's talking about from 9 years ago, as far as a specific day. Maybe he is lying, maybe he's not. But why on earth, if this was true, would you not tell law enforcement when you're in your house questioning your fiance and your soon-to-be stepson? Why don't you believe the murders happened when the dogs were barking? First and foremost, witnesses say sound travels a lot at night. Every one of them. I know firearms. I know gunshots. We have 10 gunshots from this incident at 1 o'clock in the morning, and not a single one of them heard it. What does that tell you? It tells you dogs are barking at something. But there's nothing that indicates that it was involved in this particular homicide. Because if it was, they would have heard the gunshots too. Because that's what the dog would have been going nuts for, is all the problem that was going on at the house. The dog, if you follow the logic of this, the dog is going nuts because of everything that's going on there. And if that's true, this is all going on there, she gets out the door, hear 10 gunshots, and nothing? Reasonable doubt is not an imaginary, speculative, forced, or possible doubt. That is not what reasonable doubt is. And Mr. Prince tried to put an explanation on this, that reasonable outside the courtroom isn't the same as it is inside. Wrong. That is exactly why a jury of peers is chosen to perform the duties that you were chosen to do. Is because you are to bring those same reasonable aspects that you deal with every day that we talked about in jury selection, that we talked about earlier in the first, and to use those same things regarding the reasonableness of aspects and the reasonableness of doubt or not. That's why you are a jury of the peers. And when you apply that reasonableness to this, it is not an imaginary, speculative, forced, or possible doubt. You look at all of the evidence. Is the clothing the kids are wearing consistent with one? Taniyah, yeah. She's in her sleep attire. JaVonte, maybe, maybe not. Doesn't have a shirt on. And we're going to get to this a little bit and what it does tell us in a little bit. But let's take a look at Tamiyah. Fully clothed, just like she would be on a normal basis. Is this consistent with 1 a.m.? Or is it consistent with it's starting to get time for what the kids have to go to bed? And with 3 kids, you take turns giving them baths and getting ready and changing their clothes in order to go to bed. Taniyah would have gone first. She's in her bed attire. JaVonte, I would argue, is in the process of getting ready and getting ready for his bath. And then it will be Tamiyah's turn, who is outside on the couch, because that's where the evidence shows us she was, because that's where she was shot and left her blood on the couch, fully clothed. Maybe the car they just saw was actually Henry Segura's, if he did in fact see one. Remember, we know Henry Segura got rid of a car. 3 days afterwards, get rid of the car. Why? Incriminating evidence. Everything else he got rid of was because it incriminated him. Same thing with the car. Mr. Paramore, 37-minute long recording, in which Mr. Paramore makes one statement. The kids had to die because you can't leave witnesses. It's true. I don't think there's any question that's why the kids had to die. He's got common sense just along with everybody else. He certainly knows that. Greg Washington is Greg Washington. I don't know how else to describe it. You got to see him very briefly. But the bottom line is Greg Washington is a known snitch that just dack. An investigator boss had told you it was a 37-minute long audio in which Gregory Washington was just boom, 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 hammering away at him. Couldn't hear it. It's not audible, that's why you don't get to hear it. But he told you what it was. And finally, Paramore says something to get him to shut up, maybe. I don't know. But it's not an admission. It's not that I killed him. It's the kids had to die because of witnesses. It's common sense. It's true. Read this in the newspaper, I'd say the same thing. But more importantly, law enforcement then went on and they used their investigative tools and they ruled him out as a suspect. They didn't just call him in and say, "Hi, how you doing?" They ruled him out. They investigated him. He's not a witness. Again, just because Mr. Prince says it's the case doesn't mean it's not. What the evidence and the testimony of Sergeant Bossio, I think now Lieutenant Bossio, says, we ruled him out as suspect through our investigative means. Says the motive is not there. It's not there because he knows how to deal with it already because of his other child. But he didn't. 4 months. Didn't do a damn thing. Didn't make a partial payment. Didn't go to court to try and get the settlement that he talked about earlier. The only thing we do know is he contacted Ms. Hawkins about getting rid of the child support on that child as well. And she's worked with him before. And they went to mediation and got it set aside. And keep in mind, he's already struggling for money. With the child support he's already got to pay. And now Brandi Peters is doubling it. So now when I don't have any money, my taxes are already being garnished. I can get the other Ms. Hawkins to settle this thing out, but I can't get Brandi. And now I got to pay more money. The other thing is Ms. Hawkins isn't taunting him like Brandi was. Most importantly, you cannot apply logic to an illogical person. And I say that because Mr. Segura is not logical in the things that he does. A logical person does not climb into a car with a gun, drive to Louisiana, Alabama, wherever it was, and get in a shootout to have his back of his cousin. That is not a logical response of somebody. That is someone who is okay with getting in a gunfight. And that's what he did. You cannot apply logic to an illogical person. And when you break it down, there is no one else that it makes sense committed this crime. There is no one else that has that motive and has a .32 revolver and was there on the day at the time. At some point, 1 + 1 + 1 = 3. He has each and every one of those. Now, the defense does not have to prove anything. Mr. Prince is absolutely 100% correct. They don't have to prove anything at all. It is solely upon the state to prove that Mr. Segura did this particular case. That being said, they did put testimony on about another theory. And when you're evaluating that, it is subject to the exact same weighing of evidentiary factors that you would give all the other evidence in the case. You've got two theories. The state says Henry Segura did it, and here's why. Mr. Santos says that this was a hit for a drug deal and put together an international hit squad. He gets a female to make sure she can open the door. He hires local help because they know the particular area. He gets the Mexican cartel involved, and he gets Mr. Avila to come over from Italy to also be involved in this for some reason. Mr. Santos, from prison, with his grandiose ideas and his narcissistic tendencies, and everything else that I'm not going to reiterate, puts together this international hit squad of 7 people to go over and kill Brandi Peters on the south side of Tallahassee. And in doing so, left one void pattern, one footprint, in one location of all the injuries. Use that common sense, use your intelligence. That does not make sense in any way, shape, or form and defies all logic and reasoning. And keep in mind, he did all of that without speaking a lick of Spanish. Doesn't speak Spanish. Mr. Noppinger, in making his evaluation of that the phone cradle, has to give third donor in order to get the results he did. We did that cross-examination. There has to be a third person in order to do so. There were absolutely no indications of a third donor. None. And I'm not going to rehash all the DNA stuff for the most part. But also keep in mind who you're talking about. Mr. Avila. Mr. Avila is a drug trafficker. But is he a drug trafficker in the manner in which Mr. Prince is putting him forth? Where he's an international part of an international hit squad? Remember, not all these things are saying. He's from Colombia, the epicenter of cocaine. This is where this guy's from. He's a poor fisherman that is out there trying to do and make a living. He's trying to put his kids through college. You heard his testimony. Fishing dries up. He needs money. It's Colombia. Who do you think comes calling? He's a fisherman. He knows how to run a boat. We need you to make this run from 300 miles off of Peru to 300 miles off of Acapulco, Mexico. That's it. Never brought drugs into the United States. Never been part of a drug, narcos, Miami Vice, any of those things. He simply got on a boat and he made sure it got to where it was from one coordinate to another in order to get the money. Not something you should have done. But does that make him part of an international hit squad put together by James Santos to come kill Brandi Peters on the south side of Tallahassee? Keep in mind, Mr. Santos, tall, skinny Colombian. Mr. Avila, 5'6", not skinny. Not fat, not skinny. Doesn't even match. Mr. Santos, I met him well, depending on what story it is, I met him at a strip club outside of Atlanta in 2000, 2001. Mr. Avila is in prison during that time period. Mr. Santos is actually in prison during part of that time period. Mr. Santos says, I also met him in Texas in 2001. Again, Mr. Avila is in prison during that time period. The only reason Santos knows Mr. Avila's name is because it came forth in the hearing that you heard about regarding CODIS. And we'll get to CODIS in a little bit. So he throws the name out there, trying to make sure, see if the court and everybody else will bite on his grandiose ideas. Trying to make a name for himself, make him sound like he's somebody. Yet all of this, if Mr. Avila is in fact, and he's told, we need your DNA because of the scene of Tallahassee, he knows what the crime is, and despite that, he agrees to get on a train and travel from his home in Italy to the U.S. Embassy. The U.S. Embassy, sovereign U.S. soil, where all of the laws of the United States apply. And he's going there as a suspect of murder. And he gives his DNA. But we're not done. He gives his DNA, it goes back and it's analyzed, and we'll get to the analysis in a little bit. He then returns 3 years later again to sovereign U.S. soil after giving his DNA to cooperate further. He provides his documentation about him paying his rent and his students, being a student. Is that someone who's part of an international hit squad? Is that part of the actions of someone who is an international hit squad? Again, going back, Mr. Knopfinger needs a third donor to make Mr. Avila's DNA fit. Miss Brown, 2 donors is her determination back in 2011. You heard from Dr. McElfresh. There's nothing here that indicates there's a third-party donor. Joe Allen Brown determines the 2 donors. You would expect to see a 5th peak if there was, in fact. And you're going to have these electrophorograms. If you want to go back and look at them, fine. I'm not going to do a whole lot here with them. But the bottom line is there wasn't. There were 4 peaks. And when you look at them, she found in 2011 that the minor was a 14-17 at BWA, which is the loci. Minor 14-17, major 15-18. Avila is a 17-18. He doesn't match the 14. Ms. Brown says, oh, well, I included it, the kids in there. They could have been in there, so therefore I went ahead and included them in this. But she also excluded them. You can't rule someone out from being a DNA sample and then turn around and come back and put them back in to get the results you want. Say what you want. There was an issue. She did absolutely correct in doing the CODIS thing and notifying the state attorney's office. She was trying her best to see that we could get any kind of results in a lead. Absolutely 100% correct. Unfortunately, she was then asked last week to do an analysis. And she changed everything. She changed her own recorded notes. And she added back in persons that had been excluded to get the DNA result that she wanted to prove herself right. Because when you look at the raw material, Mr. Avila is not a 14 and neither is Brandi. And there's only 2 people that are part of this. The minor donor, as she said back then, is a 14 and a 17. And Mr. Avila is not. Back then, she said the minor is an 8 and a 9. He's not. It just doesn't fit what her determination as to what the minor was back in 2011. Further, Dr. Kevin McElfresh. I know you heard a lot from DNA people. Dr. McElfresh literally is the person that helped create DNA forensic analysis as we know it, that is used by everybody. He's been doing this for 30 years. He does it for the Department of Defense, Tomb of the Unknown Soldier. He did it for September 11th. He did it for the tsunami in Indonesia. He works with low quantity and complex mixtures as his daily routine, the way that FDLE does the more simple stuff. This is why he specializes in this, and this is why he was contracted. And make no mistake, it wasn't told, hey, by the way, can you see if Henry Segura is in this DNA mixture? It was, what does this DNA mixture tell you? And when he went back and looked, he looked first and foremost, of course, at that Avila DNA. He's not there. He's not there because there's no sign of a third donation, and he's not a 14, he's not a 7-8 at all those other loci. You cannot, and he went on to tell you, you cannot exclude somebody in an analysis and then go back and include them at a later time in order to try and mess with the DNA data. And that's what was happening. That's what Mr. Knopfinger and that's what Ms. Brown said. Fine. I'm also well aware, good Lord, we've heard all this stuff about DNA. I'm not going to believe anything they say. Fine. Don't believe anything they say. If you don't believe anything they say on this particular piece of evidence especially, that means that Avela's not there. Because you're certainly not going to believe Mr. Santos. But if you are going to believe it and use your own skills and those things that you were taught about DNA, and look at those electropharograms if you want to, Mr. Avela's DNA is not there. Dr. McElfresh went one step farther. He was asked to look at that grab bar. And that grab bar, you do know, is in fact an integral part of this crime. And you know that because right next to it is Brandi Peters' blood. That means whoever beat her put their hand or some other object right there, right where we're doing this analysis. We also know it because the kids are found at this location. So this isn't a question about DNA that was left at some other time by some other persons that are mixtures, complex mixtures. We talked about DNA can be left at any particular time. Sometimes DNA is mixed 2-3 days beforehand, can mix with one that's done right away. That's just the way these things mixture. You can get through touch, you can get through sweat, you can get through all different ways for this DNA. But we know this right here is left at the time that these kids were killed and Miss Peters was killed. We also know that Henry Segura wouldn't be touching this. And he said Henry Segura is there and part of that mixture. And the one thing that sets this aside from a telephone cradle is, when asked, Joe Ellen Brown, both on the stand and in 2011, said, I cannot exclude Henry Segura from this DNA sample. Because FDLE protocols do not let me. Mr. Noppinger, I cannot exclude Henry Segura from this DNA sample. Mr. Bundy, I cannot exclude Henry Segura from this DNA sample. Dr. McElfresh, the specialist in this field, the father of this science, who was involved in all the studies that started this, can do DNA analysis that, quite frankly, they can't because of his knowledge and his abilities. And he says it's him. It is entirely consistent with all of the DNA persons. Mr. Knox goes back with 20/20 vision. He looks at stuff and says, TBD should have done this, TBD should have done that. Yet even he still misses stuff. And we talked about one of the first things he said out of the box was nobody swabbed or nobody went and checked for fingerprints on that window that's there in the master bathroom. But it was. So even he misses stuff. But let's talk about what it is that he did find. He did say yes, a revolver with all the different shapes and all the different areas on it could have caused each and every one of these injuries. Dr. Flanagan, the medical examiner, said the same thing, that these wounds could be caused by a revolver with all the different trigger guards, hammers, barrels, end of barrels, sights. You have a picture of one. In the butt of the gun could have absolutely 100% caused that 1-inch indentation. That's what they said. That's what the evidence said. That's what the testimony of every one of these persons said. Mr. Knox says you can't make a determination of one person versus multiple persons. And I went through stuff. If there are a hit squad, international hit squad, remember what we're talking about is Henry Segura, international hit squad, 7 persons. If there's an international hit squad, how on earth does Miss Peters get out of the master bathroom? Then, even after getting out of the master bathroom, How does she get out of the master bedroom? You're telling me one of those 7 persons can't block either one of those exits? If that's true, how on earth does she manage to get all the way down the hallway, through the living room, and out the front door if you've got 7 people there to commit this crime? And what he told you is there's one void pattern. One. Not 6, not 5, not 4, not 3, not 2. One. Consistent with one person. There's one footprint. He saw all those other 5 spots there that could possibly be shoe impressions. All he knew was they were a pattern of indiscriminate origin. And there's one motive. And finally, there's, again, all the wounds are in one area. Impressions of an unknown origin. That's what we're talking about. He said there's 5 of them there. They need to be further analysis. His expertise is not identifying footprints. Remember that. Your instructions say an expert can testify and give their opinion on that in which they are an expert in, and that alone. What he is an expert in is crime scene analysis and developing things for further examination by Florida Department of Law Enforcement or whatever expert it is that can testify as it relates to that analysis. And what he said is that's stuff that I probably would have processed, which TB did. And when they did that processing, and they sent it to Florida Department of Law Enforcement and the shoe print analyst, Mr. Mamoni, and he did that comparison, what did he determine? One shoe print. All the other ones were a pattern of indiscriminate nature. And keep in mind where this is found. It's the entryway of the home. People are going to walk through there. These weren't shoe prints that were found and you can just see right in here. They were developed because they had to do extra light stuff and the purple stuff. And it brought out footprints that were there. So these weren't bloody footprints that Mr. Knox tried to identify. These were things that were found and footprints that were identified through further analysis in order to bring these footprints out. And shockingly enough, they found footprints, potential footprints, in the foyer, where everybody walks through to get into the house. Not anywhere else, just that one spot. And again, they weren't shoe prints. One of them was. They were impressions that could possibly be shoe prints, but they were undetermined as to what those origins were. That's what the expert said. And there's one void pattern right here where he is beating her. And he is beating her right here and casting that stuff off as he's beating her. And it goes up underneath the drape, which is right where you saw where the pictures are. So when you take that and you take those 2 theories and you look at how it actually applies to the evidence and you analyze it and you look at Mr. Segura's testimony, lied to his wife, lies to the kids, lied to Tallahassee Police Department, lied to his girlfriends, lied to God. I'll never cheat on my wife again. Months later, he's doing it already. Yet he wants you to believe he's going to tell you the truth. We're back to that first question. Why was the cell phone taken? The only thing that's taken out of the house. Why the cell phone? There is no other reason to take that but to hide the information that is on it. Because It's taken off nobody's taking it to use it later on. Shortly after the murders, 8:21, it's off the grid. Why was the cell phone taken? Because it gives indications and tells who she's talking to the day of the murders. It's got. This is a person that is well aware of the incriminating aspects of these cell phone records. Hides his phone from him. Doesn't tell him about that number. Star 67s her to keep her from knowing where it is. He's gone back and deleted each and every one of the incriminating emails so that law enforcement can't see them. Why was the cell phone taken? Because it would have pointed the finger and showed that the person that she was talking to immediately before the murders and talking to on that day was Henry Segura. It's the only reason and the only explanation as to why it would be that that phone was taken. Mr. Segura gets up there and says, she was cool with it on Wednesday. Again, Mr. Segura says that. If that's the case, why is she calling Department of Revenue hotline on that same day? So the testimony was. Why is she calling Department of Revenue hotline on that day trying to find out where her money was? So on Wednesday she was cool. We know that's not true. I was at her house for sex. Why? We're back to that question. Why is he coming in and telling you? Because he knows what the evidence is. He's listened to the same testimony you have. He's reviewed all the evidence. They had John Sawicki. And he knows he has to have an explanation. So he comes in and tells you what he tells you. And he tells you, I didn't say it because I didn't want Malika to know. Yet he also tells you, I love those girls. Tamiyah and Taniyah. He loved them so much he couldn't set that aside on a homicide investigation? Doesn't make any sense. He didn't have a problem confessing his Wednesday visit to Brandi. He didn't have a problem telling law enforcement officers about his other girlfriends. Second video, they confront him with him. He's like, yeah, I've got girls all over. I used that second phone. I don't remember the name of it. I got rid of it before Brandi Peters was killed. I use that to talk to him. Yet he doesn't say, oh yeah, by the way, I was also at her house before we had sex. She was alive when I left. No. The only time that comes out is because he's awaited trial and he knows he can't stick to that story because the cell phone analysis blows that entire story out. Mr. Princess eviscerates his argument. Compare his statement to the other evidence. No condom wrapper. People flush condoms after they're used, yes. Typically not a condom wrapper. Same kid. No DNA there, no indication of sex. Maybe he did use a condom for the first time. Said he waited at the church for Mom to leave and he walked down the street, but then back through the yard. Kids were playing outside, they didn't see him. Cece didn't see him. Archon, when he went over to go get the kids, didn't see him. Remember, Archon went over to the house to get the kids out of the house to bring them over for oxtail soup. He didn't see him. But he was inside having sex with Brandi, is what he's telling you. His information doesn't comport with what the evidence is. Mr. Segura says, in his testimony, he never really even referred to JaVonte as his kid. I don't know if you noticed that or not. He says, I would have stayed and waited 4 hours to have sex with her. I would have waited all night long. Yet he can't drive across town to see these kids that he supposedly loves so much? He says he left around 8:30, 8:15. When I was getting ready for this case, I was reading a book, and it's one of my favorite authors, named John Sanford. He's got a hero in this particular book that talks about, and he's obviously a cop, and he goes out and he's involved in this investigation, U.S. Marshal, and he arrests somebody based upon cell phones. And I'm reading this as I'm getting ready for this case. It says, if you're a crook and you leave your phone at home while you're sticking up a bank, but you carried it all the other times, you automatically look suspicious. You always carry a phone. And the one time during that bank robbery, you left it at home, sooner or later some prosecutor will convict somebody of something because he didn't have a phone in his pocket. That was interesting. Because that's what we have. When we look at these cell phones, Brandi Peters always has her cell phone on her. There are no more gaps where she's let the phone die, where she's let the phone leave the network, where she hasn't plugged it back in for charging, where it hasn't been utilized in one way, shape, or another. There just aren't. For a week prior, it's constant communication. The phone is always charged, it's always on, and it's always being used. Always on, always charged, always being used, except for that time when not only did the cell phone analysis of Henry Segura's phone that he did not tell law enforcement about, and now it's coming and admitted to you. That's the time that it stops. So what did happen? No way to truly be sure about how things went down in the house. But I ran through a scenario with Mr. Knox. He begrudgingly, he's a defense witness, begrudgingly admitted that it was fully within his analysis that it went down this way. About halfway through, his demeanor kind of changed a little bit, and he kind of realized where we were going with this line of questioning. True to his integrity, he admitted it was there, but you could see the look on his face. Y'all witnessed it. As I talked to him about the way that this could happen. So you follow the evidence. You use your common sense. You use that education. Use the education that you've got over the last 2 weeks. And look in the facts and come to a reasonable conclusion. And what they tell you is that Brandi Peters is harassing Henry Segura. I want the DNA, I want the child support money. Give me the child support money. I'm going to take the money out of your taxes. I'm going to garnish your wages. He forwarded them on to Malika, his wife. Understandably, she's getting frustrated too. is a child he does not believe to be his. He's repeatedly requested on 2 different occasions to have Department of Revenue do a paternity test because he doesn't believe the kid is his. Does not believe JaVonte is his. And she is pestering, Department of Revenue is pestering him. And they are hitting him with letter after letter after letter after letter after letter. So now he's got his wife upset with him because he's got another kid and cheated on her again, despite his promise to God that he wouldn't do it. He's got Brandi hitting him hard. Where's my money? He's getting letter after letter after letter. We saw the first one earlier, June 22nd, 2010, in which he filed for that petition, not believing that he was his child. And now we are here on November 3rd, 2010, 2 weeks before the homicide occurred, with this last letter from Department of Revenue. And they give him a response. November 3rd, 2010. You must respond within the next 14 days. Which happens to coincide with that Wednesday visit on November 17th to Brandi Peters, and happens to also coincide with her phone call to Department of Revenue inquiring where the money is that he says she's cool with. And what we know is that week he goes to Tyra Wilcoxon and he asks for a gun. And what we know is he did in fact go to see Brandi on that 17th day. Why? Same thing you did with Miss Hawkins. Hey baby, get rid of the child support. I can take care of you, get rid of the child support. But she's not having enough. She's not having it. She says no. And he goes back on November the 19th with his 32 that Calvin Moore seen him with, that he even admits he had. He says he got rid of it, but he says he had it. And he's got enough ammunition to actually reload the gun. And he goes, and he probably parked up here at the church, just like you said. It's how you hide lies. You mix truth in. And he parks up at the church, and he walks down to 908 Saddle Creek Run. And he knocks on the door, or even maybe even opens the door. He's been there before. They know who he is. And he walks in, and he finds Tamiyah on the couch. Nobody's alarmed, it's Henry. She sits there with her back to him, doing her studies, or whatever it is she's reading here. Maybe he expects the children to be there, maybe not. We heard from Monica Peters that they normally aren't there on that Friday night, but they were. And he pulls out the gun, and he shoots her in the back of the head, and she falls right there where she sat. Brandi in the back bedroom watching TV. We've seen the video. All the lights in the house are off, remember, with the exception of the bathroom and the couple of TVs. The house lights are off, would indicate it's probably daylight outside whenever all this stuff goes down. But what we know is Brandi probably sticks her head out the door and says, "What the hell was that?" Sees Henry Segura, runs back into her bedroom, and he gives chase. And we know there's a struggle for the gun. I would argue that it happened right in this area. Struggle for the gun, gets a shot downward through her breast. Another shot goes out the window. There's a further struggle. She retreats into the bathroom. Shoots twice into the bathroom. One through the doorway, right here, and one that hits the shower stalls. We talked a little bit earlier about this. About these two trajectory lines and how close that was to the wall. And you can look at the trajectory rod, and it's pointing this way back towards the wall and upwards. Can we say determine somebody was left-handed or right-handed? Not necessarily, but for that to be shot with a right hand, the person would have to be up against the wall shooting along these lines, or like this. Or left-handed. Up against the wall, bang. Running out, pivots, and shoots. We have 2 shots in there. The shot out the wall. Again, it's consistent with someone being left-handed. Mr. Segura is left-handed. So she's able to escape both the bathroom and the master room out into the hallway. At this point, the gun's probably out of ammo. She's been shot at least one time, probably more than that. Other shots have been taken as well. He's got to stop and reload. She runs out this doorway. She collides with the doorway right here from that injury that she got on the left shoulder, leaving the blood. And she runs down the hallway while he's reloading that gun. He reloads, gets a shot at her. She manages to get outside. Not really plausible if there's 7-person hit squad there. Keep in mind, this 7-person hit squad was Mexican cartel. Mexican cartel 1 likely to use a .32 caliber gun, which is an old police gun, or are they more likely to use a semi-automatic gun like a 9mm 45, something much more common? Are they likely to put the wrong ammunition in the gun? If this is an international hit squad that knows how to kill people, what's the likelihood of them not knowing how to kill people? So she's able to get outside, and he pulls her back in. And he beats her to death. Now Taniyah and JaVonte, during all this domestic situation, they went into hiding. JaVonte, with the clothes that he had on, consistent with Taniyah already being the person that has taken a bath and getting ready for bed. JaVonte's next in line, and he's taken off his shirt. He's got his pants still on, but he's next in line for the bathtub. So the bath has already been run. And he's in there, and that's where they hid. And that's where Henry Segura found him afterwards. He drowned him. And he held him under there for 10 to 20 seconds after they breathed in the water. Once they're dead, he then goes back out in the living room, takes Tamiyah, carries her into the bathroom, and puts her there with her sister and brother. Mr. Segura realizes the phone has incriminating information on him, and he goes back and gets it, and he leaves to the back door, locking the bottom lock only and not the top. Gets to his car, then he starts erasing the evidence. Gets rid of the emails, he gets rid of the bloody gloves, the bloody, remember what Silas Thornton told you about the clothing that they wear is protective. Sticker stuff is what they have as welders. He gets rid of all of that stuff as he goes down to Silas Thornton's house the next day, totally out of the blue. Hey, by the way, I'm in the neighborhood of Sop Chopping. I'm gonna swing by. Mr. Thornton told you that was out of the ordinary. What's down there? Sop Chopping River. A whole bunch of woods. A lot of places to dispose stuff. So he goes down there and he does that. And he destroys the evidence. both the electronic as well as the other pieces of evidence that he had that would incriminate him. Law enforcement, where's your phone? I was home all day. And when you look at all the evidence and you apply that common sense and that intelligence and you look at those two theories that presented to you, only one of them makes sense and only one of them has the motive, the means, and the opportunity. And the other one is James Santos. And based solely on James Santos. And you have the reports back there. So when you do all of that, I'm confident that you'll take a look at this and you'll find that he is in fact guilty of the murder of Brandi Peters, Tamiyah Peters, Taniyah Peters, and JaVonte Segura. And ladies and gentlemen, it cannot be lost that today is the 9th anniversary of these murders. It has been a long, frustrating procedure. Make no mistake, the family members are asking you, and everybody's asking you to return a verdict of guilty and seek justice for these children on that night.
That's not an appropriate comment. The jury disregarded that comment.
Thank you.
All right, so excuse me. So that's the 9th anniversary. So this oh wow, yeah. So the retrial was from November 6th to November 19th. So that was that. Wow. So that was the 9th anniversary. Huh. Didn't realize that. So that was the state's rebuttal. That was Mr. John Fuchs. Came back in, talked about John McLean Park, talked about Marquise Davis. Then he said something, 10 gunshots at 1 a.m. And a lot of us in the chat were like, wait a minute. This was supposed to happen between 6:30 to 8:20, 6:50 to 8:20. Why did he? And there were 7. I thought there was only 7 gunshots, so that was a little confusing. I don't know why he said 1 o'clock. That was very confusing. Then this was helpful. Then he said, look at the kids' clothes. Taniyah was in bed attire. JaVonte was in the process, and Tamiyah was fully clothed, and she was on the couch where she was shot. So that he was making the case of Taniyah had a bath. JaVonte was in the process because I don't think he had a shirt on. He had his pants on but not a shirt on. And Tamiyah was fully clothed. So he's talking about they were all going to take a bath. 3 days later, Henry got rid of the car. And he talks about the 7-person hit squad. And he goes over Angel Avila. He says, if it's an international hit squad of 7, how does Brandi get out of the bedroom, down the hallway, and out the front door? Excellent point, And I think this is about when I asked, should the defense have put forth their cartel hit squad theory? 54% of you said 54% of you said yes. 45% of you said no. I think I don't think they should have, because I think it just is too fantastical. I think it just doesn't make sense, right? Because then now you're comparing Henry Segura to a 7-person hit squad, international hit squad, right? That just doesn't, right? It's just not making sense. So I don't know why they would have done that. I guess the first time they didn't have that, so maybe they were, at least I don't think they did. So maybe they were just trying to, I don't know. I don't know why they did that. He says he lied, Henry Segura lied to his wife, his kids, law enforcement, his girlfriends, and God. Remember, he said, I take an oath. I'll straighten out my ways. Why was Brandi's cell phone taken out of the house? And then here's this was a zinger. Maybe he did use a condom for the first time. He's talking about the condom that he says that he used. They showed Brandi's cell phone, and he did this during the trial. So he showed Brandi's cell phone usage, and it just scrolls and scrolls and scrolls. I should have timed it, but it was probably at least a minute or two. And the court is just quiet. We know Bev would not have. She would have said, "Nope, that's too performative." Henry is left-handed, so he was talking about the bullets, I think, going into the bathroom closet or hallway closet that would have had to have come, more likely, would have come from somebody shooting left-handed versus right-handed. He says, so it starts in the bedroom. There's 3 shots, at least, I think, 3 shots fired in the bedroom, 1 or 2 down the hallway. Actually, I think 4 down the hallway. So Brandi's running down the hallway trying to get out. Henry reloads. Brandi gets outside, brings her back inside, finishes her off in the foyer. The kids go into hiding. Taniyah's already taken the bath. JaVonte has his shirt off, but pants still on, ready to take a bath. And then it was the 9th anniversary, and they showed the kids there quickly. That was sad. All right, what do you guys think? Mandy Strong says, who said 10 shots at 1 a.m.? Mr. John Fuchs just said that. I think he said nobody heard shots at 1 a.m., just a dog barking. He said something about 10 shots at 1 a.m., and then he did say something about a dog barking. All right, I'll leave that up to you. Or somebody go back and double check and listen to that. But I'm pretty sure he said, because we're like, what? 10 shots, 1 a.m.? Chad, I mean, like 4, 5, 6 of us said that. Curviel, and thank you for becoming a Patreon member. Appreciate Curviel. Tons of activity every minute. Ken Rosenberg says, it's called the golden rule for prosecutors. Can't ask them to send a message or put themselves in the place of victims. Oh, that was at the ending? Gotcha. Ken says, how would you feel? Things like that. Yeah, Judge was on him too. Judge Hankinson, he was on him. Nanar says, I think so too, Mandy. He knows he's not supposed to say it, but it was powerful. Brat says, I must say I agree with the rebuttal part of the closing on almost every point he made. Yep. Nanar, yes, inappropriate comment about family asking rather than follow the law. I wouldn't forget that comment, though. Yeah, how can you? Cajun Bayou Queen, the 1 a.m. thing was confusing. Yeah, somebody go back and check that out. OnlyFan, what kind of poll do you want? Just, is he guilty or not? We've taken a few, but we can take another one. And since we're on a rewatch, I can't really do how long. Well, I could do how long will it take the jury to come back with a verdict. What kind of poll? Tell me what kind of poll you guys want. Yeah, Mandy. He knew he would get an admonishment, but said it anyway. I support that statement. Yeah, of course. JM says, hey, he got it in. Ken Rosenberg, yep, totally agree. Sometimes you got to take one for the team, right? Is that how it works? Brett says, Mandy, defense introduced the dog barking at 1 a.m. as their suggestion for when it happened. The point was that if they heard the dog barking, they'd heard the noise of the missus. So is that what he said? Why did we all hear 10 shots at 1 a.m.? Because the dog was barking at like 2. Dog barking forces, let's see. Barking around 2 a.m. 1 o'clock, 2 o'clock. I guess close enough, right? 1 a.m. could have been people coming back from the game. It's a high school game. It's probably done by 10 or 11. Could have been, though. I mean, could have been. You want to do who here watched Henry police interview poll. Ken Rosenberg, honestly, prosecutors shouldn't have said it, but Mr. Prince kind of set himself up for some snark on rebuttal. The blue collar comment, a few others. Therapist, pretty sure he did say that. Shots in 1 a.m. I thought so too. 3 o'clock rock, right? 1, 2, 3 o'clock. 1, 2, 3 o'clock. 4 o'clock rock. I think it's 4 o'clock. 1, 2, 3 o'clock. 4 o'clock rock. Yeah. Julie says, shot 2, 1 a.m. has me really confused. Trial Junkies United. The poll should be, is it too early for a whiskey shot? That's funny. Brad says the state was arguing for their timeline instead of the defense timeline by arguing that there was no noise from the weapons when the dog barked. Yeah. Yeah, if the dog, well, was the dog inside? Maybe the dog was inside. Because they didn't get home. That family didn't get home. Her now ex-husband didn't get home till like 4:30. She got home at 2. Or no, 1 or 2. So maybe the dog was inside. That's why the dog wasn't barking. Right? All right, what kind of poll? Who watched the interview? I think we should, well, let's see, why not? All right, new poll for you guys. Who watched Henry's interview? I hope you all say you did. When you are bored, go watch it. You will know he was guilty right there. All right, I just put up the poll. Mandy, who watched it? Nanar, I didn't watch it. It happened during Henry's testimony, which was day 4. It's right after the state rests. He was the first. Pretty sure that's when it came up. No, it wouldn't have come up then. It came up before. Sorry. Maybe it came up in day 2, Mark Lewis. I think it was Mark Lewis. Oh yeah, initial interview. So Nan, it was Mark Lewis, day 2. It's about middle of the day. Or they had 7 that day, and he was the 5th one. So it's on day 2, if that helps. JM, I watch. Oh, wait a minute. JM says I watched some. Does it count? Of course it does. All right, yeah, we'll do. Okay, Mandy, that's better. How would you vote as a juror? A juror. All right, we've done a couple of those. All right, I'm going to end this poll. 46% said no. 53% said yes. Let's see. All right, let's get. I'll put it up. Let's watch the jury charge. Jury charge is coming up next, so we'll get to that. All right, let's get to the next section, which is the jury charge. Jury charge, and this is only like 10 minutes, so pretty short.
Hey.
And I'll put that poll up of like, how would you vote? Okay, see you on the other side.
All right, let's go back to the jury instructions, page 11. Before I start into the written jury instructions, since Mr. Prince mentioned read back a couple of times, let me comment on that. Yes, it is possible to get a read back of testimony, but I don't want you to think that's a simple process. That is a laborious process for the court reporters. If you are going to ask some part of a testimony to be read back, you need to be as specific as possible, and you do need to allow, it takes the court reporters hours to prepare to do that. So it's not, made it sound like it was something very, very simple and commonplace. It can be done, but don't take it lightly. I will tell you, transcripts are not available. They do not have transcripts done. That's something they do over a long period of time in preparation for an appeal. So sometimes we get a request for a jury of transcripts. You will not be provided transcripts. So let's go to submitting case to the jury. In just a few moments, be taken in the jury room by the bailiff. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict form when all of you have agreed on a verdict, and to bring the verdict form back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. You are not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication, such as a blog, Twitter, email, text message, or any other means. Do not contact anyone to assist you during deliberations. These communication rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I have given in this case, you must tell me by giving a note to the bailiff. Many of you have cell phones, tablets, laptops, or other electronic devices here with you. The rules do not allow you to bring your phones or any of those type of electronic devices into the jury room during deliberations. Kindly leave those devices with the bailiff while you deliberate. If you need to communicate with me, send a note through the bailiff signed by the foreperson. If you have voted, do not disclose the actual vote in the note. If you have questions, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions if I can in writing or orally here in open court. During the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. The exhibits will be sent into the jury room with you when you begin to deliberate. In closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate rules we all share. Let's go side, Berkeley. All right, Mr. Beasley and Ms. Adams, you need to remain here with us. The rest of you may step out. Take your notes with you. Even if you didn't make any notes, take your notepad and your pen. You may want something to write on. We will be sending the evidence to you. You may step out. Everybody have a seat, please. No, it's tough at this point in time, having sat all this time and then get told that you're not going to get to go back and deliberate, but we do have alternates in these cases. A lot goes into getting one of these cases going, and if we lose a juror, we don't have alternates, we have to start all over again. Obviously, you understand that would be a big problem. Truthfully, I'm pretty surprised we got this far without using any of the alternates. Usually in a case this trial, this length, we'll use one, if not both of the alternates. But you were our alternates. You cannot be involved in the deliberations at this point in time. However, we are in a little bit of a unique situation there. If the jury comes back with a first-degree murder verdict, we are going to have another proceeding, a penalty phase proceeding, and we will need to have you for that. Because of that, I would ask that you do a couple of things for me. One, I would ask that you not discuss the case with anyone. You may get inquiries from the media, you may get inquiries from the friends, family. Please don't discuss it until we let you know that the case has been concluded. If there's not a first-degree murder conviction, we will call you and let you know what did happen. If there is a first-degree murder conviction, we need to have you back for that proceeding. We'll have to talk to you about exactly when that will be. I don't know for sure whether that'll be tomorrow or Thursday. It'll be one or the other. We do intend to conclude it this week. It won't go beyond this week, but there is that possibility. You don't have to stay here, although you're welcome to stay here. If you want to stay here just to see what happens, you're welcome to do that. Let Deputy Granger know that, and he'll find a safe place for you to sit. But if you want to go about your business, just give him a phone number where we could reach in an emergency. Some juror were to get sick before we get a verdict, we might have to call upon you for that. If we get a first-degree murder conviction, we definitely going to call upon you for that. So we'll keep you apprised of what's going on. We do appreciate the time and the attention. I understand that given 3 weeks of your time is a major commitment and probably feels a little bit of a letdown now at this point in time. But we do appreciate the time and the attention you've given us. You can't go back in the jury room, but Deputy Granger will retrieve any personal effects that you have for you, and he'll retrieve those for you. And I'll let you step out with him, and if you'll take them and see that they get safely on their way. Have a good afternoon. You can just leave your notes where they are, and we'll take care of them. All right, so on the evidence, everybody be seated. Y'all looked at me a little funny when I mentioned this distinction between perpetuated testimony and evidentiary statements. Are we clear that none of the perpetuated testimony is included in the evidence?
Yes, sir.
Yes.
All right, okay. The defendant's statement can be submitted to the jury. The rest of the evidence, I believe y'all went through and made sure that what's being sent to the jury is what was properly in the evidence. The clerk is held on to any things that were simply demonstrative or court exhibits, correct, Barbara?
Correct.
All right, any issues on the evidence?
No, Your Honor.
No, sir.
All right, it can be delivered to the jury. And the evidence list has been approved, that can be included. All right, anything else from either side?
No, Your Honor. No, Your Honor.
All right, well, thank you all. It was well tried on both sides. I appreciate the fact that y'all worked together professionally, even though hard fought. There was good cooperation to make things work. Makes the court's life a lot easier. I do appreciate that. We'll be in recess till we hear from the jury.
Okay, I have.
That's the street, this is the street.
Get it together, Barbara. All right, so we're gonna go. We're gonna go straight into. They come back with a verdict. Imagine that. Should I end the poll or should we keep the poll going? What do you think? 13 votes. Should I keep the poll going? Has everybody had a chance to vote? Mandy, you're getting sad watching His Honor, knowing he is no longer with us. I know. I know. Widespread panic. Well, I forgot. There may be a prison guard he could sweet talk. Don't they have conjugal visits? I thought they have that. Nanar, I had to pull this one up. Oh, I got cat fur in my nose. Ugh. Nanar says, I've noticed that and I'm enjoying my time with you all. I love how Squeegee does recaps after each portion in case anything was missed. You have a great group here. Aw, thank you. We do know the time for deliberations, Julie and Brat. We do. Do you want me to poll you guys or do you want me to tell you? 2 questions. First of all, should I end the poll for how would you vote? And second, should I do a poll for how long it took them to deliberate for? Brat says, don't get to bring the video evidence from the prior trial back with them, just like the in-person testimony doesn't come back with them. And Widespread Panic says, Nan R, we hope you come back. Oh yeah, wait, why would you not come back with us? Hold on, what did I miss? Poll, please, okay? Or just tell us. Wait a minute. Okay, so end the poll and then tell. Okay. Are we cool with that? I think we're all pretty much in accordance here. 19 votes, 100% guilty. 100% guilty, 0%. Okay. All right, let's do a poll. How long do you think it takes? New poll. How long will the jury take to come back with a verdict? Okay, new poll. I'm not going to vote on it because I know. New poll chat for those that do not know, that are just reading. New poll. Till the cows come home option, please. Oh, sorry, I missed that. Mandy, no more suspense. Reveal. Verdict. Aw. Dreamer Landry, thank you for that. Appreciate that. I'm glad that you guys are here. We really appreciate that. Now we just have to get YouTube to see that we are worthy of being monetized again, because it's not just about us making money. I mean, yes, that helps. Trust me, it helps. But it's also, it gives you guys a lot of options that you don't have otherwise. You know? We get to upload videos to our members. We get to, what's the other thing is, I'm drawing a blank right now. Oh, stickers, right? We get to have stickers. We get to have emojis. There's a lot of fun stuff. Dreamer Landry NR, I was very excited when I saw you in the chat. Cool. Mandy Strong says, here's a poll. How long will it take Squeegee to give us to give us the verdict? Therapist, me to YouTube. Get it together, Barbara. All right, have you guys all voted? All right, let's, yeah. I want to see the Sarah Boone emoji back too. Yeah, and the yellow jumpsuit and the Jason. Get it together, Squeegee. Spill it. Well, let's hear the verdict. All right, how about that? Let's get the verdict. Let's get to the verdict. We're going to the verdict. Verdict time, verdict time, verdict time.
Back in session.
Yikes. All right. How many of you have voted? 17 votes? All right, I'm going to end it, and then I'll tell you. Ending the poll. Let's see, 0 to 2 hours. You guys said 35% of you. 2 to 4 hours. You guys said 41%. 4 to 6 hours. You guys said 33%. And hung. So 0% of you said hung. Okay. Let's see. All right, let's go back. Let's get back in. Get it together, Squeegee. It took the jury. Now remember the first one. After 19 hours of deliberation over 2 days, jurors in the quadruple murder trial of Henry Segura could not reach a verdict. However, in this one, it took the jury about 4 hours to issue its verdicts. 4 hours. So whoever voted 2 to 4, 41% of you guys got it right. Took them 4 hours. All right, let's do it. Let's get to the verdict. Here we go. Here we go.
Be seated.
Now we've emotional experience, everybody, gone on a long time. We shouldn't have any reaction from anyone. We need to take the verdict from the jury in silence, and we'll deal with whatever it is. We ready for the jury?
Yes, Your Honor.
All right, let's have a jury, please. Mr. Brill, I see you with papers in hand. Are you a foreperson?
I am, sir.
And have you arrived at the verdict?
We have, sir.
Is it as to each of the 4 counts?
I'm sorry.
As to each of the 4
Yes.
counts? All right, would you hand it to the bailiff, please? State of Florida versus Henry Segura, we the jury find as follows: as to count 1 of the indictment concerning the murders of Brandi Peters, the jury finds the defendant is guilty of first-degree murder. As to count 2, we the jury find as follows: as to count 2 of the indictment concerning the murder of Tamiyah Peters, the defendant is guilty of first-degree murder. As to count 3, we the jury find the defendant is guilty of first-degree murder. As to count 4, we the jury find the defendant is guilty of first-degree murder. It's been dated and signed by the foreperson. We wish to have the jury polled.
Yes, sir.
All right. Polling means I need to confirm with each of you that this is your individual verdict as well as the verdict of the jury as a whole. Juror number 1, is this your verdict as well as the verdict of the jury as a whole?
Yes, it is.
Number 2 juror?
Yes.
Number 3 juror?
Yes.
Number 4 juror?
Yes.
Number 5 juror?
Yes.
Number 6 juror?
Yes.
The jury has unanimously confirmed the verdict. It appears to be in order. It will be filed. I know y'all are ready to go, but I'm gonna ask you to go back into the jury room for just a few moments. I need to discuss with the attorneys exactly how we're gonna proceed forward, so we can give you instructions before you leave. If you retire to the jury room for a moment, please. All right, everybody be seated. So, how do y'all wish to proceed as to the penalty phase timing?
Your Honor, Dr. Pritchard will need to examine Mr. Segura. He has indicated to me that he is, tomorrow morning, he is supposed to be testifying in our Ocala case, but he's going to do it telephonically, so he should be free tomorrow afternoon. So at some stage, we'll need to have him interview Mr. Segura, but he will be a rebuttal witness, so he will need to go after. I don't, quite frankly, anticipate putting on any additional witnesses for my part, the penalty phase. I will do a rebuttal witness, but I don't know that there's any need to call any additional witnesses. So.
Well, when would you be prepared to proceed?
Probably tomorrow afternoon. We could go tomorrow morning, but I don't know if Mr.
Prince, Ms. Baker's in charge of this part of it, or are you doing it?
Yes, sir. I honestly don't know. We need to kind of regroup, and we wouldn't be ready to go tomorrow morning. I guess I can say that.
All right. Want to sound like maybe, how long do you think y'all are going to take?
Not long. Not
Right.
long at all.
We'd start Thursday morning.
Yes, sir. Wednesday afternoon, or Wednesday evening, Dr. Pritchard can see Mr. Segura, and we should be ready to go Thursday morning.
Mr. Prince?
That'd be fine, Your Honor.
And should be able to get it done in a day.
Yes, sir.
Yeah.
I would think so, sir, depending how long the process and directs are, the experts.
Right. Okay. Let's have a jury back in. As you're aware, that we need to have one more phase of this trial. I've talked with the lawyers. They anticipate we could conclude all that in a day. I don't think at this point there's going to be an extended amount of testimony presented. So what we're going to do, because of some witness issues for tomorrow, is we're going to reconvene Thursday morning, 8:45. You're still subject to the rules not to discuss the case or let anyone discuss the case with you. We've come a long ways here. Let's not have any slips at this point in time. So Thursday morning, 8:45. I'm hopeful that we can conclude all matters on Thursday. We'll probably know that a little more clearly tomorrow, but that would be my belief for now from talking to the attorney. So give you tomorrow off, regroup, relax. I know this is stressful for everybody, including y'all. So maybe good to have a day away from us. Thursday morning, 8:45, same plan we've been under. Anybody have any questions about what's expected of you? We will see you Thursday morning, 8:45, and you're going to see that they're safely on their way. Deputy Granger, y'all have a good evening. Probably we should have some proceeding tomorrow to kind of get a little clearer idea where we stand. When would y'all propose?
We could convene in the afternoon, Your Honor.
say 1:30 tomorrow.
Yes, sir.
And do I need to do anything to facilitate Dr. Pritchard's meeting with the defendant?
No, sir, we discussed it, and the defense is got access, so we'll be able to get it set up. So,
All right, so now he's going to be here at 1:30, so is that going to mess up the scheduling?
no, sir, it shouldn't, because like I said, the doctor thought he'd be there tomorrow morning on telephone, and he said he should be concluded by the afternoon, so he can do it after our proceedings
Okay.
at 1:30. I'll text him to make sure everything's good.
Okay, because I mean, we can adjust the time on our meeting tomorrow if we need to.
I'll contact and talk to him tonight to confirm, and then I'll let y'all know in the morning if there needs to be a change, otherwise we can do 1:30.
All right, we'll plan on 1:30 tomorrow. All right, and Mrs. Segura will need to be present. All right, 1:30 tomorrow. Anything else we need to take up at this point?
There.
All right, we'll see y'all in the morning.
All right, so there you have it. Henry Segura found guilty on all 4 counts, first degree. Don't go anywhere because we've got about another 2 hours of his penalty phase. And I agree with you guys. I didn't think DPs in Florida were 6-person, but I'm pulling this from the Tallahassee Democrat, which is the local news outlet there. And they're saying on Tuesday, the 19th anniversary, was convicted by a 6-person jury. So, yeah, I don't know. I don't know why they said that. I don't know, unless they got it wrong, but I'm pulling that right from their website. So, all right, so it took them 4 hours, and 35% said 0 to 2 hours, 41% of you thought 2 to 4 hours, 33% thought 4 to 6 hours, and 0% thought hung. Hey, Joe Schmo, good to see you. Glad you made it into our and NR. Good to see you guys. Got some new people. Yes, you're finally here. You're starving, craving some rectangle school lunch pizza for some reason. That sounds pretty good. NR, how are you? Good to see you. Don't recall seeing you in the chat, but that's cool. Am I muted? No, am I muted? No. Yes, it is a DP case, but I don't know. I'm just pulling that from a news source. So if you guys find something different, go ahead. Yeah, Mandy, go ahead and research it if you have time. Do a quick research. Type in Henry Segura sentencing. Help me find out that was incorrect. Yeah, right on Tallahassee Democrat. November 20th, 2019. On Tuesday, 19th anniversary of the murders, 41-year-old Segura was convicted by a 6-person jury of 4 women and 2 men. So, all right. So let's go to... all right, let's go to... Oh, friend of you. All right, cool. All right, very good, Hellcat. Welcome, welcome. NR, not you, Hellcat. I know you're here. All right, cool. Let's get to. All right, let's go on. We've got more to watch of Mr. Segura. Then I've got I have something at the very end too. So let's continue on. This next clip is 18 minutes. This is his charging conference coming up. And thank you, Hellcat, for bringing your friends. Any friend of Hellcat is a friend of mine. All right. There you go. Dream Landry. Hellcat, if he is a friend of yours, he is a friend of ours. Exactly. All right, let's get to the next phase. Let's continue on.
Be seated, please, sir. We're here in the state of Florida versus Segura, 2011-2751. Let the record reflect Mr. Segura is present with his attorneys. I guess the first thing we just kind of lay out some groundwork. I've had the deputy pass out an order of presentation. We don't do this very often, so just to make sure everybody's on the same page, that would be our order of presentation. Anybody have any questions or issues about that?
No, sir.
All right. I've sent you the preliminary instructions, which are just standard instructions, and the draft of the jury instructions. I was working on the verdict form. It gets a little complicated because we've got so many counts. But I have roughed out a verdict form. I'll have that sent to you, but would you give each of them a copy of that? So, a couple of things that we need to resolve. I guess first would be, what aggravating factors is the state going to be attempting to assert?
I think we have listed 6, Your Honor. One would be the defendant was previously convicted of another capital felony. That the murder was committed for the purpose of avoiding lawful arrest, effecting escape from custody.
Which it doesn't involve escape from custody, obviously, so we strike that out.
Was committed for financial gain. Was heinous, atrocious, and cruel. Committed in cold, calculated, premeditated manner, and that 3 victims were under the age of 12.
Okay, and the state intends to proceed or assert as to all 6?
Yes.
Okay, all right. There were a couple of, I received a request for jury instructions. 3 jury instruction additions was first related to the contemporaneous conviction. Defense have any objection to that instruction?
No, Your Honor.
Appears to be an accurate statement of the law. You have case law on your second request, Mr. Evans,
Yes, Your Honor.
relating to the witness elimination.
Yes, sir.
What's that?
Yes, sir.
All right. Let me.
Carrie, bring up the cases to you. And Your Honor, there's one thing I think I need to do right off the bat.
Okay.
Is on the first sentence where we're requesting the aggravating circumstances applies where it says A, but actually should be a D.
Where are you talking about?
On number 2, on special requested jury instructions, number 2,
Right.
that first sentence says the aggravating circumstances applies where, instead of the A, that should be D.
Where the dominant mode for the murder was to kill a witness.
Yes, sir.
Yeah, I don't think there's any question as to the first sentence. I guess the second sentence is, where are you getting that from?
I'm getting it from the Howell case, Your Honor.
The what?
Paul Howell, which is 707 Southern 2nd, 647, Florida Supreme Court case from 1998. And the around footnote 8, the language, I'm sorry, I have it printed out upstairs, but and I'm looking on page 7, Your Honor, and it starts talking about where asserting that the Howell asserts under headnote 5 on the right-hand side, it talks about him that the error in finding the arrest was committed to avoid, prevent arrest, and there was also presented in that case that, and I'm looking at the paragraph close to the bottom, says Howell argues that in order for the aggravator to apply, that they're talking about Howell asserted that basically that there were other motives, that because there was some financial motive that was intended, that this should only apply if witness elimination is the dominant motive for the crime, but there were some other reasons that there should be. The court went on and held that it was permissible. It doesn't have to be the only motive. I'm looking on page 8, toward the bottom of the page. I guess it would be on page 682 of the fifth instructor. It says the fact that Howell may have other motives for murdering Bailey does not preclude the application of this aggravator. And it cites Fotopoulous, which is Fotopoulous versus State.
I see where you're referring to.
Yes.
Defense have any other authority on that issue that they want to assert?
No, when I saw that instruction, I thought it was an accurate statement.
Right, it would appear to be. All right, the third thing they've requested is a little bit confused. The statute says pecuniary gain, but the jury instructions approved by the Supreme Court talk about financial gain. And you've asked me to tell them pecuniary gain includes financial gain. I think they're probably synonymous. Seems to me it'd just be simpler to wherever we have the term that we use, financial instead of pecuniary, save us from having to define it, and that's what the standard jury instructions provide. Anybody have a problem with that?
No, sir.
No, that's what I was going to.
Okay. All right. I'm going to have to make some changes because I do have pecuniary gain in a couple of places. I have financial gain in most cases. So I'll grant the state's requested jury instructions. Number 3 will be done by just using the term financial gain instead of pecuniary gain. All right. So what other legal issues do we have?
We have the victim impact statement, Your Honor. Sorry I didn't get a chance to give it to him before we started, but I've got a copy for the court also to review. I
Okay.
think it's probably all in order.
Who is going to deliver it?
Monica Peters.
She's going to deliver it personally.
Yes, sir.
All right. So we need to be careful that she is cautioned that this is exactly what's to be said, and we don't need any emotional outbursts included in it. If she doesn't think she can read it without breaking down, then we need to make some other arrangement. I don't want to get into a, big emotional outburst as part of the victim impact statement. So, she's welcome to do it if she can abide by those 2 things. I'm not sure that she can, but y'all need to discuss that.
Yes, sir.
All right. I'll read over this later. I assume you've reviewed it and it's appropriate. But with those 2 caveats, assuming I don't find anything problematic in there, we'll allow you to do that one way or another. Is that going to be the only part of the presentation you make initially?
Your Honor, I was also going to seek to admit and I don't recall if the complete autopsy report from Dr. Flanagan had been entered or not. I know some diagrams had been, but I don't know if her complete reports have been entered.
Well, I'm sure the report was not entered.
And so that would just basically, if the defense doesn't have the objection stipulating the entry of those reports, then we would not, there'd be no necessity for calling Dr. Flanagan. I know hearsay is admissible and perceived to some extent, but
it's kind of admissible, but anyway, it's kind of not admissible too. But anyway, certainly she can testify to it, or we can put the report in. Do you have a position, Mr. Prince?
No, Your Honor, I'd like to talk to Mr. Evans about it. I didn't know they were going to make that request, so I'll talk to him about it, and probably we'll be able to work something out either way.
All right. Well, let's resolve this afternoon, because if they're going to object, we need to have Dr. Flanagan here.
yes, sir.
Okay. And that'll be the state's presentation, initial presentation.
Yes, sir.
Okay. In the aggravated factors, I started thinking, they have to be divided out by each count. So where we've got a count on count 1 involving Brandi Peters, I would think that I would take out reference to her being a child, essentially, since she's not. But I think the only place that would need to come out would be in the verdict form. Anybody have an issue with that?
No, Your Honor.
No, sir.
Okay. Looks like maybe I already did that, actually. Yeah, I already did that in the draft that you've received. What does the defense want in terms of instructions on mitigating circumstances? Have you decided that, Mr. Prince?
For the most part, Your Honor, I don't anticipate requesting anything other than the 2 the court looked at and identified and put in the proposed instructions.
I think those were the 2 you requested last time.
Yes.
And that's still satisfactory at this point?
Yes, sir.
Okay. All right. So what else do we need to resolve legally?
The only thing I would request is that, I know residual doubt is not a mitigating circumstance, so that it not be mentioned during opening or any reference made to it by anyone who is presenting evidence or testifying, questions being asked about it.
Well, certainly lingering doubt is not a proper subject of argument. I don't know how it would come up as to a witness, but we'll have to deal with that question by question in terms of witness. But that's certainly an accurate statement that lingering doubt is not a proper subject of argument.
And the other two was the cost of the death penalty versus the cost of the death penalty versus life imprisonment. You know, financial factors on the state of how much it costs to impose the death penalty versus life imprisonment isn't a proper basis for arguing mitigation.
We're not going to put on any evidence or make any argument pertaining to either of those things, Your Honor.
Cost, okay.
And the other would be the impact of the defendant's execution on the defendant's family. I don't think it's a proper basis to argue.
Mr. Prince?
We're not going to put on any evidence or argument excuse me, about that either.
Okay. All right, so grant those motion and limines. What else?
Nothing else, Your Honor, I can think of at the moment.
Okay. Mr. Prince? Any other issues?
No, sir, I don't do it, sir.
How long do you think your presentation will be?
Not long, Your Honor. We'll finish tomorrow.
Okay. Has Dr. Pritchard seen Mr. Segura now, or have we worked that out?
We've worked out 4 o'clock today is our goal for it to take place. Dr. Pritchard had given us that time, and Ms. Carruthers with the defense team is working to make that happen at the jail.
Okay.
Well, it's set up, Your Honor. She's providing instructions to Dr. Pritchard's office. He can contact Captain Williams when he gets there, and he'll arrange a contact visit between Mr. Segura and Dr. Pritchard.
Okay. All right. So, any other issues?
Not from the state, Your Honor.
Not
Brent. All right. So we'll resume at 8:30 tomorrow and proceed from there. Please, I mean, we don't have to have the instructions final now, but please look over them because they are, we're not real used to dealing with them, and I've tried to, as closely as possible, follow the standard jury instructions there. But anyway, make sure that you don't find any mistakes or any issues there, please. We'll see y'all at 8:30.
Your Honor, I did want to add something for scheduling purposes. When Mr. Prince said he should have his case wrapped up tomorrow, are we anticipating giving it to the jury tomorrow?
Absolutely. We're going to finish it tomorrow.
That's what I just wanted to make sure that we were all on that same page.
Okay.
And Your Honor, just for record purposes, I have 4 discs here. Of course, we talked yesterday about supplementing the record. They are the testimony of Angela Vila, Kelsey Kennard, Officer Bossio, and then another disc containing the 2 state closing arguments.
Okay. Thank you.
Do we have any number on those?
3, 4, 5, and 6.
This will be court exhibits.
Court.
Court exhibit 3, 4, 5, and 6. Okay. All right. Anything else? If not, we'll see y'all in the morning.
All right, so that was a charge conference. I'm trying to find out who that new prosecutor is, I guess, and I guess it's somebody different because it's It is a death penalty. Like I remember with Chad Daybell, you have to be specifically licensed. I think it's called licensed to argue death penalties. You can't just be a regular lawyer. You have to be special. I'm sure Florida PI Sam would be able to assist us on that. So let's go to the next clip. This is the judge handles jury issues. Judge handles jury issues. So let's check this out.
So I was just kind of running through the jury to see who was in what group. Our first 5 jurors were in group 1 through Ms. Cave, and then the last 3 were ones that were in group 2. They're related here according to the clerk's records. So who do you want me to talk to, Ms. Prince?
I would request, Your Honor, that you do individual whatever on each of the jurors, even the ones that weren't down there in the afternoon may have spoken to another juror who was. I just think there should be a clear record of whether any of them heard that and what, if any, impact it may have had on the deliberative process.
What's the state position?
Your Honor, the state's position is a non-issue. It's a general statement that was there. I don't think that it is beyond anybody to think that if parties actually negotiate for cases and plea negotiations in some way, shape, or form. It was a statement made as a whole as to 6 different cases. As it regards to, obviously it was not directed at this particular case. I think an overall aspect is when somebody hears plea deal, they generally think that it's a slap on the wrist type situation. Most people don't realize that plea deal can be for the kind of things that we obviously see in court, but the general public's impression of a plea deal is that this case is weak and therefore they're pleading out a case, is typically the way you hear it. Again, it doesn't seem like there's an issue here in any way, shape, or form as it relates to the specifics of the case, and I don't think it's an appropriate thing. I think as a practice, it probably shouldn't be done anymore for that manner, but I don't see how it's prejudicial and how that would affect. Further, we specifically went through individual voir dire with each one of these persons after this occurred. So they would have come in and we would have talked to them about what they knew about the case, what they've heard about the case, and all the other individual voir dire that we did, any press coverage, all the other stuff that we did outside, plus the full voir dire process that we did in the courtroom after these statements had occurred. Might be a different story if they heard it mid-trial, but this is before jury selection happens. This has already been vetted for the most part. So.
I don't think it hurts to ask them whether they have recollection of such a statement by the clerk, and if they did, whether that had any impact on them. Frankly, I would think that most jurors would assume that plea negotiations go on as to all cases, so I'm not sure that it has great significance anyway, but I don't think it hurts to have a record of whether that was said or not. So let's just bring them one at a time. Just put them in the first seat there, and we'll just inquire of them real quickly. Right, Mr. Radulski. You're not in trouble. It's just something we need to clarify. I know this is a little intimidating, but some issue has come up that maybe the clerk of court in her opening comments to y'all when you were first gathered up here on Monday, long time ago, when you first came here, may have said something about plea negotiations going on. Do you remember anything like that being said?
No.
And nobody said anything to you about plea negotiations in this case? All right. All right. Don't talk to the other jurors till we have a chance to talk to everybody. Okay? All right. Thank you. If you've done anything wrong, don't be nervous. We're just trying to make a record of it. There's been a suggestion that during your initial time when you were all brought here as a group downstairs with the clerk of court, that maybe she said something about plea negotiations going on in this case. Do you remember anything like that? What's that? Okay. So nobody said anything to you about plea negotiations in this case?
No, sir.
And nobody's, even other jurors said anything like that to you?
No, sir.
All right, thank you, ma'am. You haven't done anything wrong, so we're just trying to clarify a record issue. There's been a suggestion that in your initial gathering with the clerk of court, Ms. Marshall, that maybe she said something about plea negotiations going on in the case. Do you have any recollection of anything like that being said?
No.
And nobody said anything like that to you?
No, sir.
All right, thanks, sir. Just have a seat there. No reason for alarm. You didn't do anything wrong. We're just trying to clarify an issue that's been raised. A suggestion has been made that during your initial gathering downstairs, that the clerk of court, Ms. Marshall, when she was talking to you, may have said something about plea negotiations going on in the case. Do you remember anything like that being said? No? All right, and nobody said anything to you about plea negotiations, either her or some other juror?
No.
Okay, thank you, ma'am. And you're not in trouble or anything, we're just trying to clarify an issue. There's been a suggestion that when y'all first came in downstairs, you were gathered up as a big group when the clerk talked to you, that she said, she may have said something about plea negotiations going on in the case. Do you remember anything like that being said? Anybody, any other juror said something to you like that? No. All right, thank you, ma'am. So those would be ones who are in the first group. Good morning. You're not in any trouble. We're just trying to clarify an issue that's been raised. There's been a suggestion that in the gathering when y'all were first brought in downstairs in the big group downstairs, that when the clerk talked to you, Miss Marshall, she said something about plea negotiations were ongoing or something of that nature. Do you remember hearing anything like that?
No, sir.
And nobody said anything to you like that, another juror or anything like that?
No, sir.
All right, thanks, sir. And thank you for being back here, Mr. Beasley, this morning. There's been a suggestion that when y'all were first gathered downstairs and the clerk was talking to you when you first came in several weeks ago at the beginning of that the clerk said something about plea negotiations going on in this case. Do you remember anything like that being said?
Not specifically, no.
Okay. But do you have some recollection of plea negotiations?
There's been so much legal talk in the past 3 weeks, I wouldn't doubt somebody said please something or another, but no, I can't.
You don't have any recollection of that?
No.
It's not, if nobody, other juror or anything like that's discussed plea negotiations with that. If that's come up, is that something that concerns you about the case, that plea negotiations going on or not?
Hadn't crossed my mind.
Okay, thanks, sir. And we do appreciate you being back here this morning. Good morning. And thank you for being back here today. And you're not in any trouble. We're just trying to clarify an issue. There's been a suggestion that when y'all were gathered up downstairs when you first came in that Monday afternoon, when you were first, that's been a long time ago now, that the clerk said something about plea negotiations going on in the case. Do you remember anything like that being said? Do you remember anybody talking to you anything about plea negotiations in this case? Can't think, don't have any recollection of that. All right, thank you, ma'am. So, further, Mr. Brent?
No, Your Honor.
Anything from the state?
No, Your Honor.
All right. So you need a few minutes to, how long do you want?
Yes, sir.
15 minutes?
Yes, sir, that'd be fine.
All right. And then we'll start the presentation. All right, tell the jury we're going to be about 15 minutes. We'll be in recess.
All right, I thought that was interesting. So he said there was a jury issue. So Mr. Prince brought up an issue with the jury about a statement made by the clerk. The jurors were brought in and questioned. He said there was 5 jurors in group 1 and then 1 juror in another group. And it was the clerk of courts made a comment about a plea negotiation. So the first group, group 1, there was 5 jurors. Then group 2, there was another juror. Then Mr. Beasley came out and said, there's been so much legal talk these past few weeks, nothing specific hadn't crossed my mind. And then there was another juror. So if that's 5, 6, 7, 8, that would be 8. And yet, Segura requested a 6-person jury in the hopes of cutting down deliberation time and getting a unanimous decision. So I'm not sure why they just questioned 8 people. Interesting. Yeah, who brought this to the attention? It was definitely Prince. It was definitely the defense, I'm sure. But how do you find out? I don't know. Mandy, no juror said yes. If they said yes, oh my gosh, that would have been like, bah. All right, so after this, we still have a little bit to go. We've got, let's see, 20, we've got about another hour or so, hour and a half still to go. And then we're going to do Billy Wagner. He had a pretrial hearing. So we'll cover that after this, so stick around for that. So it was before the case started. Yep, if so, would that lean the jury towards guilty for sure? If there was a plea negotiation going on? I guess that could be prejudicial, sure. If I heard that the defendant was looking at a plea deal, I'd be like, well, why are you looking at a plea deal? But what's the significance if they were? Because I think if you're a juror and you're hanging out and you hear, oh, hey, the guy's going to take a plea deal, doesn't that kind of implicate or imply that they're guilty? Lily Wayne, were they questioning this during deliberation or after verdict? After the verdict right now. Oh, Lily Wayne, you asked. Okay, so yes, he came back. They came back guilty, all 4 counts. We are now in the sentencing phase. So this is actually, I think, like 3 or 4 days later. So the verdict came down on the anniversary of the deletions of Brandi and her kids, if you can believe that, right? 9 years they came back with a verdict. Pretty crazy, huh? Ooh, they were saying it was before they deliberated. It was before they even chosen, I believe. I think it was before they were even chosen. Mandy says, requesting a 6-person jury and getting a 6-person jury are 2 very different things. He said that this is on WTXL, channel 27, ABC, Tallahassee. This time, Segura will have a 6-person jury. Hopes of cutting down deliberation time and getting a unanimous decision. He also requested a 6-person jury instead of 12. If found guilty, Segura could face the DP. So this is from ABC 27 WTXL, their website. Okay. Brad says, assumption is that only guilty people would plea out instead of fighting it, but in the real world it's messier. That's what I would, that's exactly what I would think. I'd be like, why is this person trying to plea out? Why don't they just take it? If they're truly innocent, why are they taking a plea? That would sway my decision 100%. Mandy Strong, that would tell the jury the defendant was going to plead guilty to spare the DP. I would definitely be, I would be swayed if I heard that. I would definitely be swayed if I heard that. I'd be like, why don't you just, if you're innocent, why don't you fight it? All right, let's move on. So now we get to, next up is jury instructions for the penalty phase. So we're going to hear jury instructions for the penalty phase. And this is 12 minutes. Yeah, these next clips are real short, 12, 6, 5, 22, 32. Oh, closing arguments are going to be, oh wow, there's opening statements and closing arguments. Cool. All right. It's kind of like a mini trial, if you will, but just with openings and stuff.
You're not trying to give me a fair chance.
No. Do not want that. Definitely do not want that. Oh, come on. Serious? Sorry. Bear with me. I'll see you on the other side.
The order is back in session. The order is back in session. Be seated, please. Lord, we stand, friend.
Your Honor, after further discussion, Mr. Segura has indicated he does not wish for us to put on any witnesses or argument. He's also instructed us that he doesn't want to do a Spencer hearing, request a Spencer hearing at all. So I think we need to proceed with the colloquy if that's his decision.
Okay. Stand up again, please, Mr. Segura. What Mr. Prince indicated, is that correct?
Yes.
All right. Now, the second part of what he talked about, I want to make sure you understand that's not waivable. The court is required, let me start over again on that. Whatever the jury does, if they recommend the death penalty, which of course is much more likely if you don't present anything and you don't make any argument, I still have to make an independent determination whether the death penalty is appropriate or not. And Mr. Prince called that a Spencer hearing. I would require the attorneys to present to me whatever evidence they have gathered. That it's your decision here today, but at the Spencer hearing, that will not be your decision. I will require them to present the evidence to me. So if what you're trying to do is avoid it being presented in court, it's going to be presented at some point in time, because I have to make a decision also, not just the jury. Do you understand that?
Yes.
Does that change your mind about what you want to do here today?
No.
So you instructed your attorneys not to present any evidence, is that correct?
Yes.
And you've instructed your attorneys not to make any argument contrary to the death penalty, is that correct?
And or call any witnesses.
Right, and that's what you want to occur here today?
Yes.
And do you have any questions about what you're doing?
No.
Anybody pressured you into doing this?
No.
Anybody kind of made any kind of threats against you to try to make you do this?
No.
This is your own personal decision.
Yes.
State, wish to make any further inquiry?
No, Your Honor.
All right, thank you, Mr. Segura. All right, so with that, I will find that his waiver of mitigation is freely and voluntarily made. We will proceed with the jury. What do you anticipate saying to the jury in terms of a opening statement or a closing argument? What's going to be said?
That we will not present an opening statement or a closing argument, Your Honor.
You're just not going to say anything at all?
Correct.
Okay. Okay. State, have any issues we need to raise before we start with the jury?
Your Honor, I guess procedurally, how we need to address it we need to introduce these exhibits, and I don't know if we're going to do an opening, do we need to close it, or just do one argument that is?
Well, that'll be up to you. I'll offer you an opening. You can make it or not. I'm going to offer it to the defense. Apparently, they're going to decline. Then you present any evidence you wish to present. They're going to be offered the opportunity to present evidence. Apparently, they're going to decline. Then you're going to be offered an opportunity to make a closing argument. You can make it or not as you see fit. They're going to be offered opportunity. Apparently, they're going to decline. And then I will instruct the jury. That's how it will proceed. Now, of course, before we move to that, we need to have a little more discussion about jury instructions on the final part of it. But that's how things would proceed. Do you have an issue with any of that?
No, sir.
Defense have an issue with any of that?
No, Your Honor.
We're ready for a jury.
Yes,
Ready
Your
for
Honor.
the jury?
Yes, Your Honor.
Okay. All right. Let's have a jury, please.
All rise for the jury.
Everybody be seated. Thank y'all for being back here today. We appreciate you timely returning. I'm sorry we were delayed. We've been working. Don't want you to think we've been goofing off. We've had a couple of issues to deal with. I think you'll see this thing's going to move pretty quickly from here on out. I'm now going to give you some preliminary instructions as to the penalty phase. Members of the jury, you have found the defendant guilty of 4 counts of murder in the first degree. The punishment for this crime is either life imprisonment without the possibility of parole or death. The attorneys will now have an opportunity, if they wish, to make an opening statement. The opening statement gives the attorneys a chance to tell you what evidence they believe will be presented during the penalty phase of this trial. What the lawyers say during opening statements is not evidence, and you're not to consider it as such. After the attorneys have had the opportunity to present their opening statements, the state and the defendant will be given an opportunity to present evidence relative to the nature of the crime and the defendant's character, background, or life. You are instructed that this evidence, along with the evidence that you heard during the guilt phase of this trial, is presented in order for you to determine, as you will be instructed, whether each aggravating factor is proven beyond a reasonable doubt, whether the aggravating factors found to exist beyond a reasonable doubt are sufficient to justify the imposition of the death penalty, whether mitigating circumstances are proven by the greater weight of the evidence, whether the aggravating factors outweigh the mitigating circumstances, and whether the defendant should be sentenced to life imprisonment without the possibility of parole or death. At the conclusion of the evidence and after argument at counsel, you will be instructed on the law that will guide your deliberations. An aggravating factor is a standard to guide the jury in making the choice between life imprisonment without the possibility of parole or death. It is a statutorily enumerated circumstance that increases the gravity of a crime or the harm to a victim. You must unanimously agree that each aggravating factor was proven beyond a reasonable doubt before it may be considered by you in arriving at your final verdict. In order to consider the death penalty as a possible penalty, you must determine that at least one aggravating factor has been proven beyond a reasonable doubt. The state has the burden to prove each aggravating factor beyond a reasonable doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to disregard an aggravating factor if you have an abiding conviction that it exists. On the other hand, if after carefully considering, comparing, and weighing all the evidence, you do not have an abiding conviction that the aggravating factor exists, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the aggravating factor has not been proved beyond every reasonable doubt, and you must not consider it in providing your verdict on the appropriate sentence to the court. A reasonable doubt as to the existence of an aggravating factor may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt as to the existence of an aggravating factor, you must find that it does not exist. However, if you have no reasonable doubt, you should find that the aggravating factor does exist. Before moving on to mitigating circumstances, you must determine that the aggravating factors are sufficient to impose a sentence of death. If you do not unanimously agree that the aggravating factors are sufficient to impose death, do not move on to consider the mitigating circumstances. Should you find sufficient aggravating factors do exist to justify the imposition of the death penalty, it will then be your duty to determine whether the aggravating factors that you unanimously find to have been proven beyond a reasonable doubt outweigh the mitigating circumstances that you find to have been established. Unlike aggravating factors, you do not need to unanimously agree that a mitigating circumstance has been established. Rather, whether a mitigating circumstance has been established is an individual judgment by each juror. A mitigating circumstance is not limited to the facts surrounding the crime. It can be anything which might indicate that the death penalty is not appropriate for the defendant. In other words, a mitigating circumstance may include any aspect of the defendant's character, background, or life, or any circumstance of the offense that reasonably may indicate that the death penalty is not an appropriate sentence in this case. A mitigating circumstance need not be proved beyond a reasonable doubt by the defendant. A mitigating circumstance need only be proven by the greater weight of the evidence, which means evidence that more likely than not tends to prove the existence of a mitigating circumstance. If you determine by the greater weight of the evidence that a mitigating circumstance exists, you may consider it established and give that evidence such weight as you determine it should receive in reaching your conclusion as the sentence to be imposed. Next thing will be offered is an opportunity for the attorney to make an opening statement.
Well, that was fast. That caught me by surprise. Okay, so that was jury instruction. We're going to go just straight into prosecution's opening statement. Actually, before we do that, I do want to say, okay, so no witnesses or evidence, or there was going to be no defense that was going to be presented. The Spencer hearing is required to be read by the judge and can't be waived. So Segura basically just said he's not going to put up a defense. No opening argument from the defense, and then he reads the jury instructions. So, wow. All right, so let's get to the opening statements.
Ladies and gentlemen.
Dang it! Come back here, you. All right. This is state opening statements. State opening statements.
Ladies and gentlemen, it is my responsibility to present the state's case for the penalty phase. The state of Florida is going to ask you at the conclusion of this phase that you impose the death penalty for the murders of Brandi Peters, Tamiyah Peters, Taniyah Peters, JaVonte Segura. The evidence of the guilt phase that we went through can be considered by you as evidence in the penalty phase. And the state will primarily rely on it to prove the aggravating circumstances that are alleged to be present in this case that warrant the imposition of the death penalty for each of the murders in this case. The only additional evidence that will be introduced are complete copies of the medical examiner's reports on each of the victims. The aggravating circumstances the evidence will prove are: 1, the defendant was previously convicted of another capital felony in this case. And what that basically means in the context of this case is a contemporaneous conviction. That means as an aggravating circumstances for Brandi Peters, you can consider the fact that at the time she was killed, that also Tamiyah Peters was killed, that Taniyah Peters was killed, and that JaVonte Segura was killed by the defendant. And that would apply for the same for Tamiyah Peters. As an aggravating circumstance in her case, you can consider that the deaths of her mother, her sister, and her brother also occurred at that time. The same for Taniyah Peters, and the same for JaVonte Segura. The second aggravating factor in this case is that this capital felony, this murder, was committed for the purpose of avoiding lawful arrest or effecting escape. And what that means, and the court will instruct you, is that includes the elimination of a witness. That means that, in this case, the defendant's child support didn't involve the twins. The only reason to eliminate them was because there were potential witnesses in the case. Same could apply for JaVonte Segura, that while he may have been the subject of the child support, it was it was Brandi Peters who was in fact the one seeking it, and that the money would have been paid for it all belonged to the state. With her out of the picture, with Mr. Segura being the listed father, he would have had custody of the child and there would not be any child support. So there was no reason to kill that young man either, except to eliminate him as a witness in this case. That leads me to the third aggravating circumstances, that this crime was committed for financial gain, for some financial benefit for the defendant. The fourth, and a very weighty circumstance, would be that the crime was committed in a heinous, atrocious, or cruel way. You looked at that brutality of the murders. We will be relying on the evidence that you heard from the crime scene, people who spoke, the medical examiner, and the photographs. So you've heard and seen that evidence. There will be a little bit more discussion after the judge instructs you on what the elements of what heinous or cruel are, how that ties into the evidence in this case. And we'll do that at closing. The fifth will be that this crime was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Again, the judge will give you more instructions on what those terms mean, and at closing argument, we will have a discussion as to how the evidence plays into the evidence in this case plays into that instruction, and what that means and how it applies to each of the deaths in this case. That capital felony was committed on a person less than 12 years of age. Tamiyah, Taniyah, and JaVonte were all less than 12 years of age. They were 6 years old, 6 years old, and 3 years old, respectively. And that will be the final aggravating circumstance that we will be asking you to consider. At the conclusion of this penalty phase, the state will be asking you to determine that the death sentence is the appropriate sentence for the crimes Mr. Sueur committed against Brandi Peters, Tamiyah Peters, Taniyah Peters, and JaVonte Segura. Thank
you. Your Honor, the defense declines to make a statement.
Okay. All right, at this point, we'll allow the state and the defense an opportunity to present evidence. We'll start with the state.
Your Honor, prior to, as pursuant to the stipulation, the state would introduce State's Exhibit 159, which is the complete autopsy report of Brandi Peters. State's Exhibit 160, which is the complete autopsy report of Tamiyah Peters. 161, which is the medical examiner's complete report of Taniyah Peters. And 162, which is the complete autopsy report of JaVonte Segura.
It's my understanding they'll be admitted by stipulation.
Yes, Your Honor.
All right, they are admitted. Further testimony, Mr. Evans?
No, Your Honor.
All right.
All right, so that was quick. Like I said, these are going to come fast and furious. So that was Assistant Eddie Evans. The evidence already presented can be used at this phase. He talked about aggravating circumstances. Defense got up and said they declined to present evidence. And then the state's evidence was the autopsy reports of Brandi, Tamiyah, Taniyah, and JaVonte. So what do you guys think of that? Lily Wayne, the jury will definitely be discussing the fact there were no defense statements. Lily Wayne reminded me of Ted Bundy's lawyer. That I don't remember what his lawyer looked like. His hair is impressively uniformly white. All right, so that is that for the opening. Now we go to jury instructions. Mandy Wayne says the jurors were not told this was the defendant's choice. They may feel bad for him. Reverse psychology. Maybe, right? All right, let's go back. Let's get to the next part.
The defense wish to present evidence.
We do not, Your Honor.
Okay. All right, so that's going to be the evidence that you're going to hear. I need to meet with the attorneys briefly, and I say briefly, it may take a little bit of time to discuss the jury instructions. We've got a draft of those prepared, but it's going to take me a few minutes to get those done and to make copies of that. So, go back in, have a cup of coffee, relax. We'll be with you as quickly as we can. All right, everybody be seated. Mr. Segura, your attorney has now announced that you do not desire to present evidence. You still have the opportunity to change your mind at this point in time if you wish to present anything. Do you wish to present anything at this time, Mr. Segura?
No, Your Honor.
All right. All right, let's talk about jury instructions. I found a typo in the aggravating factor number 2. Just was an extra Y in there. What else have we found as to the jury instructions?
Your Honor, I did have a question about the draft. We had the special instruction to number 2, purpose of avoiding arrest. I don't know if we received a final copy which included the additional language that the state had requested and the court had granted.
No, I need to add that in. About the primary motive.
Yes, sir.
Right. Frankly, I forgot that. Thank you for that. I will have that added in. What else?
Other than that.
Okay. As to the instructions, the defense have any issue with the instructions?
No, Your Honor, it's acceptable.
All right. The verdict form gets very complicated. We need to discuss that. As to aggravating factors, as to Ms. Peters, I don't see where the state has a basis to do the void or prevent lawful arrest as to Ms. Peters. I understand the theory is the children were killed to avoid that, but avoid them being able to testify against her being killed, but I don't see any theory by which she's killed to avoid lawful arrest, but I'll let you be heard on that if you desire.
No, sir, except for being removed.
I'm sorry?
We don't have any objection to it being removed.
All right, so I'm going to strike that. As to the children, I have a question whether the financial gain aggravator is applicable. I understand your argument as to Ms. Peters, but I don't see how that establishes committed for financial gain as to the children, but I'll let you be heard on that if you desire.
To the twins, we would agree to it being removed.
Okay. What's your argument as to JaVonte?
Well, the fact that child support, at least continuing child support, would cease upon his death. What we argued to the jury that, you know, if he took custody of
He what?
If Mr. Segura took custody of JaVonte Segura, then he would in fact be owing any child support to himself. So there wouldn't be, he wouldn't have to deal with Brandi Peters and have to pay outside child support.
Defense?
Your Honor, from my understanding, the judgment would have caused Mr. Segura to owe the state of Florida, not JaVonte Peters.
I'm going to strike it as all three children. I think it's a stretch to say. I mean, I think it is a fact. One of the witnesses did say it would cease upon his death, but I think it's a stretch to say that's what motivation was. So I'll strike those matters. Anybody found anything else in the verdict form? And they're quite complicated, so I hope everybody's read them. And if I've got something out of place or mixed up, let's deal with it now.
Nothing that I observed, Your Honor.
Defense?
Nothing, Your Honor. It's acceptable.
What's that?
It's acceptable.
Okay. All right. All right. Anything else from either side?
No, Your Honor.
All right. We'll go get those finalized and we'll be prepared to move forward.
Your Honor.
All right, so they finalized the jury instructions. Next up is going to be those jury instructions. And then we get into closing arguments. So this is the jury instructions coming up. Jury instructions coming up.
I realized after I sent the instructions into you, I had not taken out the victim impact paragraph. I've now taken that out. Other than that, it's what I sent in previously. Any issue as to the jury instructions from the state? It's the same as what I sent in before, Mr. Evans. Other than I took out the victim impact statement.
Yes, sir. It's fine.
What's that?
It's fine.
All right. Defense?
No, Your Honor.
All right. So we're ready for jury. What I'm going to do is I'm going to instruct them down to the part where it says in just a few moments of the last page. I'll stop there. Then we'll give you an opportunity to make any closing you desire to make. All right? Have a jury, please. All right, come on.
Jury's in the courtroom.
All right, everybody be seated, please. All right, next thing I'm going to do is instruct on the law that applies to this part of the case. Members of the jury, you've heard all the evidence and argument of counsel. It's now your duty to make a decision as to the appropriate sentence that should be imposed upon the defendant for the crime of first-degree murder. There are two possible punishments: life imprisonment without the possibility of parole, or death. In making your decision, you must first unanimously determine whether the aggravating factors alleged by the state have been proved beyond a reasonable doubt. An aggravating factor is a circumstance that increases the gravity of a crime or the harm to a victim. No facts other than proven aggravating factors may be considered in support of a death sentence. The aggravating factors alleged by the state are: 1, Henry Segura was previously convicted of another capital felony. A contemporaneous conviction for a capital felony may qualify as a prior conviction under this aggravating factor. The crime of first-degree murder is a capital felony. 2, the first-degree murder was committed for the purpose of avoiding or preventing a lawful arrest. The aggravating circumstance applies where the dominant motive for the murder was to kill a witness. The existence of other motives for the killing does not preclude the application of this aggravating circumstance. 3, the first-degree murder was committed for financial gain. 4, the first-degree murder was especially heinous, atrocious, or cruel. Heinous means extremely wicked or shockingly evil. Atrocious means outrageously wicked and vile. Cruel means designed to inflict a high degree of pain with utter indifference to or even enjoyment of the suffering of others. The kind of crime intended to be included as especially heinous, atrocious, or cruel is one accompanied by additional acts that show that the crime was conscienceless or pitiless and was unnecessarily torturous to Brandi Peters, Tamiyah Peters, Taniyah Peters, or JaVonte Segura. 5, the first-degree murder was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Cold means the murder was the product of calm and cool reflection. Calculated means having a careful plan or prearranged design to commit murder. A killing is premeditated if it occurs after the defendant consciously decides to kill. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. However, in order for this aggravating factor to apply, a heightened level of premeditation demonstrated by a substantial period of reflection is required. A pretense of moral or legal justification is any claim of justification or excuse that, though insufficient to reduce the degree of murder, nevertheless rebuts the otherwise cold, calculated, or premeditated nature of the murder. 6, Tamiyah Peters, Taniyah Peters, or JaVonte Segura were persons less than 12 years of age. As explained before the presentation of evidence, the state has the burden to prove an aggravating factor beyond a reasonable doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to disregard an aggravating factor if you have an abiding conviction that it exists. On the other hand, if after carefully considering, comparing, and weighing all the evidence, you do not have an abiding conviction that the aggravating factor exists, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the aggravating factor has not been proved beyond every reasonable doubt, and you must not consider it in providing a verdict. A reasonable doubt as to the existence of an aggravating factor may arise from the evidence, a conflict in the evidence, or the lack of evidence. If you have a reasonable doubt as to the existence of an aggravating factor, you must find that it does not exist. However, if you have no reasonable doubt, you should find the aggravating factor does exist. A finding that an aggravating factor exists must be unanimous. That is, all of you must agree that each presented aggravating factor exists. You will be provided a form to make this finding as to each alleged aggravating factor, and you should indicate whether or not you find that each aggravating factor has been proven beyond a reasonable doubt. If you do not unanimously find that at least one aggravating factor was proven by the state, then the defendant is not eligible for the death penalty, and your verdict must be for a sentence of life imprisonment without the possibility for parole. At such point, your deliberations are complete. Excuse me. If, however, you unanimously find that one of the or more of the aggravating factors have been proven beyond a reasonable doubt, then the defendant is eligible for the death penalty, and you must make additional findings to determine whether the appropriate sentence to be imposed is life imprisonment without the possibility of parole or death. If you do unanimously find that the existence of at least one aggravating factor and that the aggravating factors are sufficient to impose the sentence of death, the next step in the process is for you to determine whether any mitigating circumstances exist. A mitigating circumstance is anything that supports a sentence of life imprisonment without the possibility of parole, and can be anything which might indicate that the death penalty is not appropriate. It is not limited to the facts surrounding the crime. A mitigating circumstance may include any aspect of the defendant's character, background, or life, or any circumstance of the offense that may reasonably indicate that the death penalty is not an appropriate sentence in this case. It is the defendant's burden to prove that one or more circumstances exist. Mitigating circumstances do not need to be proven beyond a reasonable doubt. Instead, the defendant need only establish a mitigating circumstance by the greater weight of the evidence, which means evidence that more likely than not tends to establish the existence of a mitigating circumstance. If you determine by the greater weight of the evidence that a mitigating circumstance exists, you must consider it established and give that evidence such weight as you determine it should receive in reaching your verdict about the appropriate sentence to be imposed. Any juror persuaded as to the existence of a mitigating circumstance must consider it in this case. Among the mitigating circumstances you may consider are: Henry Segura has no significant history of prior criminal activity, the existence of any other factors in Henry Segura's character, background, or life, or the circumstances of the offense that would mitigate against the imposition of the death penalty. Your decision regarding the appropriate sentence should be based upon proving aggravated factors and establish mitigating circumstances that have been presented to you during these proceedings. The next step in the process is for each of you to determine whether the aggravated factors that you have unanimously found to exist outweigh the mitigating circumstances that you have individually found to exist. The process of weighing aggravating factors and mitigating circumstances is not a mechanical or mathematical process. In other words, you should not merely total the number of aggravating factors and compare that number to the total number of mitigating circumstances. The law contemplates that different factors or circumstances may be given different weight or value by different jurors. Therefore, in your decision-making process, each individual juror must decide what weight is to be given to a particular factor or circumstance, regardless of the results of each juror's individual weighing process. Even if you find that sufficient aggravators outweigh the mitigators, the law neither compels nor requires you to determine that the defendant should be sentenced to death. Once each juror has weighed the proven factors, he or she must determine the appropriate punishment for the defendant. The jury's decision regarding the appropriate sentence must be unanimous if death is to be imposed. To repeat what I've said, if your verdict is that the defendant should be sentenced to death, your finding that each aggravating factor exists must be unanimous. Your finding that the aggravating factors are sufficient to impose death must be unanimous. Your finding that the aggravating factors found to exist outweigh the established mitigating circumstances must be unanimous, and your decision to impose the sentence of death must be unanimous. You'll be provided with a form to reflect your findings and decision regarding the appropriate sentence. If your vote on the appropriate sentence is less than unanimous, the defendant will be sentenced to life in prison without the possibility of parole. Deputy. All right, let's look at the verdict form. Unfortunately, it's a little complicated because we have the steps that you have to go through, and for each of those, you have to consider it as to each count, and there are 4 different counts, so it gets a little complicated, but I think once you get into see the pattern of it, it'll be fairly clear-cut. So the first thing you have to look at are the aggravating factors, which is in subsection A. The state has alleged 6 aggravating factors. You need to make a decision as to each count what aggravating factors have been proven as to that particular count. The first one would be as to Brandi Peters in count 1. The court has eliminated 2 of the 6. So you have 4 aggravating factors that you're to decide whether have been proven beyond a reasonable doubt or not. You would check each one that you find has been proven as to count 1, dealing with Brandi Peters. Then you would do the same as to count 2, as to the children in counts 2, 3, and 4. They're the same. The court has eliminated 1 of the aggravating factors as to them. So there are 5 potential aggravating factors that you're to determine. So as to each of the aggravating factors, as to each of the counts, you would decide whether the state has proven them beyond a reasonable doubt or not, and you would check that. If you go to page 5, the bold language at about 2/3 of the way down that page is very important, so let's read through that. If you answer yes to at least one of the aggravating factors listed in a count, so it's done by each of the 4 counts, please proceed to section B as to that count. If you answered no to every aggravating factor listed in a count, do not proceed to section B in that count. Henry Segura is not eligible for the death sentence and will be sentenced to life in prison without the possibility of parole as to that count. So you have to consider it as to each of the counts. If there are no aggravating factors proven beyond a reasonable doubt as to a particular count, you are done. You don't have to do anything further as to that count. If you find that at least one aggravating factor has been proven as to the count, then you would move on to B, which is sufficiency of the aggravating factors. And again, it's broken out into each of the 4 counts as reviewing the aggravating factors that we unanimously found to be established beyond a reasonable doubt in Section A, we, the jury, unanimously find the aggravating factors are sufficient to warrant a possible sentence of death. So as to each of those that you found an aggravating factor, you need to answer that question, yes or no. Then let's go to page 6, the bold language at the bottom of page 6, I think is worth reading through. If you answer yes to Section B in a count, please proceed to Section C in that count. If you answer no to Section B in a count, do not proceed to Section C in that count. Henry Segura will be sentenced to life in prison without the possibility of parole as to that count. So any of them where you say no, your job is done. If you say yes, then you need to go to C. C relates to mitigating circumstances. Again, it's broken out by counts. If one or more individual jurors find that one or more mitigating circumstances were established by the greater weight of the evidence, and you would check yes or no. Now, note this is not necessarily a unanimous decision. This is the first time where it does not have to be unanimous. It says one or more individual jurors. So any juror could determine that this is yes. It says, please, the bold at the bottom of the page, please proceed to Section D, regardless of your findings in Section C. Then in D, the question is, we, the jury, unanimously find that aggravating factors that were proven beyond a reasonable doubt back in Section A outweigh the mitigating circumstances established, which are found in Section C. Would be yes or no. Again, it's broken out by counts. You would answer yes or no as to any where you're still proceeding. In other words, there are some where you may have already concluded from the prior subsection. If you answer yes to, now I'm on the top of page 9, look at the bold language. If you answer yes to Section D in a count, please proceed to Section E in that count. If you answer no to Section D in a count, do not proceed. Henry Segura will be sentenced to life in prison without the possibility of parole in that count. Under E, the question again is broken out by count. Having unanimously found that at least one aggravated factor has been established beyond a reasonable doubt back in Section A, that the aggravating factors are sufficient to warrant a sentence of death as to Section B, and the aggravating factors outweigh the mitigating circumstances, Section D, we, the jury, unanimously find that Henry Segura should be sentenced to death, yes or no. You would do that as to any counts that you're continuing to proceed with from early. And now at the bottom of page 10, the bold language, if your vote to impose death is less than unanimous in a count, the trial court will impose a sentence of life imprisonment without the possibility of parole in that count. It would then be dated and signed by the foreperson. So I know that's a little complicated, but it's kind of, I think if you follow it along, I think it flows through it. We've tried to make it self-explanatory. Now back on the jury instructions, page 5, right after read verdict form. The fact that a jury can make its decision on a single ballot should not influence you to act hastily or without due regard to the gravity of these proceedings. Before you vote, you should carefully consider and weigh the evidence, realizing that a human life is at stake, and bring your best judgment to bear in reaching your verdict. I've previously instructed you on weighing the evidence and rules for deliberation. You should consider the instructions I gave you during the initial stage in making your determination. A copy of those instructions will be provided to you for your consideration. Now I'll come back to the last page after The attorneys have been given an opportunity to make give a closing argument.
All right, so that was jury instructions. So they are going to debate life in prison without the possibility. They're going to debate life in prison without the possibility of parole or the DP. Have the aggravating factors been proven beyond a reasonable doubt? 1. Was Henry previously convicted of a capital felony? 2. Was first degree M was created to avoid or prevent a lawful arrest? 3. Committed for financial gain. 4. Heinous, atrocious, and cruel. 5. Cold and calculated manner. 6. Kids were less than 12 years of age. If you find no aggravating factors, then you must find life without parole. Needs to be unanimous. Do any mitigating circumstances exist? They may include aspects of character and background of defendant. Now, here's where I had a question. What if the defense doesn't put on any evidence? How are they going to know what the mitigating circumstances are? Right? How do you know what his background is other than, I guess, what you heard through trial? But that to me would be a huge thing of like, well, how do we know what he was like as a kid? Is his mom going to come and talk? Does he have any sisters or brothers, cousins? How do we know what his character really is other than what we saw on the stand and then, of course, what evidence was presented to us? So to me, there are really no mitigating circumstances that I can debate. Aggravating factors were first on the form. Brandi had 4. 2 through 4 are the kids, and they had 5 for each of them. So, what do you guys think? Nan R says, I would think that knowing that you will never get out of prison would be bad. Few states actually carry out DP. They're segregated. Good or bad, I'm not sure. Yeah, we actually looked that up. I think it was for Alyssa. The Alyssa, when he offed 19 people in that store out in Colorado. I think Tennessee is the shortest time you spend. I think it's like 17 years. I think generally you spend about 20 to 25 years. All right, I took a poll. Let's see, the poll was, what would you give Henry? Life without parole. DP. Let's see what you guys thought. Life without parole, 47%. DP, 52%. Yeah, we're kind of split. I think I did life without parole. I don't think I would have voted DP. All right, let's move on. We go to, we only have a few more things here. 3 more segments. This one's 32 minutes. And then we're going to do Billy Wagner. So definitely stick around for that because that's always fun. That's coming out of Ohio. If you guys, we'll be covering it. If it's going to be aired, we're definitely going to cover it. So stick around for that. We're going to cover the pretrial after Henry's done. All right. So this is prosecutions. So here we go. Prosecutions closing. See, I gotta get prosecution spelled right. Prosecution. Prosecution closing argument coming up. All right, prosecution's closing argument. Jenny says appeals can take many years. That is why it takes so long. Oh, absolutely, for sure. Wow, McVeigh was found guilty in '97, and that was quick. That was quick. That's probably one of the quicker ones. All right, let's get back to the courtroom.
Mr. Evans.
Ladies and gentlemen, as the judge has indicated, this is a weighing process. It's to weighing whether or not there are sufficient aggravating circumstances, and they've been listed in this crime to warrant the imposition of the death penalty. The state would submit to you that there are. And when you compare them to the weighing factor of any potential mitigating circumstances, any mitigating circumstances pale in comparison to the crime that was committed on these four people. And that there are sufficient aggravators to outweigh the mitigators. And that the appropriate sentence in this case is to impose the death penalty on each and every count in this case. Now, let's talk a little bit about the case. As we have indicated, the aggravating factors, prior conviction, which is the contemporaneous conviction of the four murders. That was done for avoiding arrest, and that's the witness elimination, which the court has instructed you on, and you have for you in the instructions. That it was for financial gain. It was done in a heinous, atrocious, and cruel manner. That it was cold, calculated, and premeditatedly done. And that 3 of the victims were under the age of 12. As the court indicated to you whenever he was going over the verdict form, there are going to be some aggravators that apply to some of the victims in this case, their murders, but not necessarily to all. For instance, we know right off the bat, number 6, we know that Brandi Peters was not under the age of 12, so that aggravating circumstance would not apply to her. You also know that, for the twins and for JaVonte, that the court, the jury or the verdict forms are not going to include an indication of whether or not financial gain being a motive in this case, as one of the dominant motives in this case, apply to them. And we also know that you will see that the purpose of avoiding arrest, the purpose of witness elimination, isn't being requested on Brandi Peters. So I'm going to go over the number of aggravators in line. Just recognize there will be some aggravators that will apply to some victims, some aggravators that will not apply in their murders. So, and I think the verdict form accurately reflects that. So the ones we're seeking in each of the individual murders are set forth in the verdict form. All right, the contemporaneous conviction. It includes, as noted, contemporaneous conviction for capital felony may qualify as a prior conviction. In this case, I think you will see that the evidence clearly shows that that aggravating circumstances is shown beyond a reasonable doubt in each of the crimes that have been committed. And that is because that in Brandi Peters' murder that we see that there were other murders that occurred. In Brandi's case, the other contemporaneous convictions are for the 3 kids. And while there will be some photographs that were proposed that will be placed before you, I'll let you know now there will not be a tremendous amount, simply because you have them, you're able to review them. You reviewed them during the guilt phase. They were shown to you a lot. You know what they see, and you can imagine what what they are and go back and see what they are and compare them what they are should you have any additional questions. So I will do my best to limit those. So I believe in each and every case that there will be at least three contemporaneous convictions for murder that would apply in each of the four victims in this case. Therefore, I submit to you that that has been proved beyond a reasonable doubt and that you should find that aggravator exists. I also believe whenever you take a look at the evidence that you will, in your weighing process, that the weight given to that should be a very great weight should be placed on it. And very great weight should be because you have 4 victims in this case. This is not a case of a single murder. It is a multiple murder. It is a murder of a family. It is a murder of children. Now, the purpose of avoiding arrest. It was committed for avoiding or preventing lawful arrest or effecting escape. And this, your jury instructions show, the judge has shown you that this applies where the dominant motive of the murder was to kill a witness. You know, the existence of other motives for the killing does not preclude the application of this aggravating circumstance. We have 3 kids. Now, these 2 young ladies had absolutely nothing to do with the child support in this case. The only reason the statement that they were killed is because they could identify the defendant. He had a choice, and we'll touch on this during the cold, calculated, premeditated part of it. If he wanted to eliminate Brandi Peters or eliminate JaVonte Segura, he didn't have to kill these 2 little girls. He had a plan. We know he had a plan. Again, we'll touch on it a little bit more. He went in either knowing they were there or not caring they were there, that he was going to kill everybody there. The reason these 2 little girls were killed was because if they weren't killed, they could have walked in this courtroom, walked up and got on that stand and said, "This is the man that killed my mama. This is the man that killed my little brother." We have JaVonte. It wasn't necessary that he kill him. He too could identify the defendant in this case as being the killer of his mama. The defendant's plan included going there and doing that killing and killing these witnesses. Because where were they earlier in the day? They weren't necessarily at home. He could have planned this when they weren't there. He could have lured Brandi Peters away from the home and did it there. But he elected not to. The murder was committed for financial gain. It takes a second for it to load. We have the fact that the child support payments were owed. They were coming to be owed. And he killed this family because he was trying to avoid that responsibility. We know he attempted to go in and the dates of when all this occurred. Everything started coming together. We'll touch it a little bit more on that cold calculated premeditated. But the dates were significant. Heinous, atrocious, and cruel. It means extremely wicked, shockingly evil. When you view the photographs of what occurred in that home, how it occurred, and why it occurred, these are very appropriate words. Extremely wicked, shockingly evil, atrocious, outrageously wicked and vile. Cruel, high degree of pain with the utter indifference to or even enjoyment of the suffering of others. It's a kind of crime that's included is to be as especially as cruel one as comes by additional acts that show the crime is conscienceless, pitiless, unnecessarily torturous. Brandi Peters, Tamiyah Peters, and Taniyah Peters or JaVonte Segura. It also says in the jury instructions that the court read to you that, and I'll go back, designed to inflict a high degree of pain, utter indifference to or enjoyment of suffering of others. Again, we go back. He could have committed this crime of killing Brandi Peters without doing this to her children. We also know, as we're going through, the degree of injuries, and I'll take these as we go through each of the victims on the heinous, atrocious, and cruel. The number of injuries, remember this came from the autopsy report of Dr. Flanagan and through her testimony and the testimony of the other witnesses in this case as to the amount of injuries and the degree of injuries that occurred to Brandi Peters. Brandi Peters was shot. I believe the testimony was she had 8 wounds and there were at least 7 gunshot wounds. We know from the back of the house, from the bedroom, all the way through the house, even outside in front of the house, her blood was found. She fought back. We see the defensive wounds to the point where her nails were ripped off. We see where she was trying to block the blows that the 7 gunshots didn't kill her. But it took her being pulled back into the house and beat repeatedly on her head and face to kill her. Heinous, atrocious, and cruel. Brandi Peters was very aware of a number of things in this case that showed that this aggravator has been proven. She was very aware of the fact she was attempting to be killed. And at some point, maybe as she got drugged back in the house and started getting beat, she was very aware that she was going to die. She fought as hard as anybody you will ever see in this situation. From one end of the house to the other, then pulled back in. Her hands up trying to block the blows that repeatedly fell on her head over and over and over and over and over. And I ask you another question. What kind of rage, what kind of hate, what kind of vile, what kind of wickedness played into the beating that this woman took? The other thing she knew, which probably is even worse, more vile, more wicked, more cruel than anything else, she knew she was going to die. But she knew 3 little babies were going to die with her. And they did. She died knowing that. And he killed her knowing she knew that. This aggravator has been proven. And it, if nothing else alone, warrants the imposition of the death penalty in her case. Heinous, atrocious, and cruel as it relates to the kids. Tamiyah was shot in the back of the head. Tamiyah's death, somebody could say, well, you could say it was somewhat merciful because she didn't have to go through the drowning that her siblings went through. She didn't have to go through the beating that her mother had to go through, shooting and beating. I submit to you, it was not merciful. It was merciless. In its own way, it was just vile, cruel, and wicked as anything else. Remember Henry Segura? He told, I believe they said at least 23 to 26 lies they were talking about, they were documenting as they were going through his statement. But one of the biggest lies he told that wasn't brought up then was his claim that he loved these children. Love doesn't do this. Wickedness, violence, cruelty does this. To have a bullet put in the back of your head by somebody who you love, who's supposed to take care of you, is heinous, atrocious, and cruel. Tamiyah Peters. Remember Dr. Flanagan talked about 10 to 20 seconds after they breathe in the water. So once the water is in the lungs, 10 to 20 seconds. Remember Mr. Fuchs stopped and waited 20 seconds. That's when you got water in your lungs and you can no longer breathe. The lights go out. Well, what did it take before you get the water in the lungs? Your mama has just been beat from one end of the house to another, shot multiple times. Remember the crime scene technique? Children get scared. What do? They run hide. They run hid. Unfortunately, it probably was in the bathroom. So they're hearing this horrendous event occurring outside. Sister has a bullet in the back of the head. Mama has been shot multiple times. Gunshots are ringing throughout the house, and you see it's not the largest house in the world. She's running up and down, trying to get out, trying to fight. Blood is everywhere. Everywhere. She's fighting back. Boom, 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 as she's getting hit in the face. In little ears, you're hearing this. Then in he walks. After what he did to Brandi Peters, we know he has to be covered in blood. Then he takes one. Maybe it was JaVonte, because he's at the bottom of the tub. Someone he believes and knows is his daddy. Picked up, placed into the tub, and held down. And what's an actual reaction when you're in the water? Whether if you're 3 years old, you're going to try to get out of that water. You're going to try to stop. You're going to want to breathe. He's held down to the point where all he can do is gasp for air. And when that happens, his lungs fill up with water. And 10 to 20 seconds later, he's dead. Remember, this is after the 10, 20 seconds. The time he had to sit there and listen to his mama being killed, his sister being killed. The time he had to watch in horror as this man walked through the door, covered in his mother's blood. And then him be put in the tub and killed. That, I would submit to you, is heinous, atrocious, and cruel. Then Taniyah. Who is next in line? Now, she heard her twin sister being killed. Boom. And mind you, the defendant's having to reload during all this. His mama shot multiple times, fighting her way from one end of the house to the other, outside the house, back in. More gunshots still ringing out. And then the beating. She's trying to defend herself. Shot to pieces, but still trying to defend herself. All that going on. In walks Henry Segura into the bathroom. Holds JaVonte down till he's dead. Then she's next. And this entire time, wondering what's going on, why this is happening, what's about her sister, what about her mama? Oh my God, what he just did to JaVonte, and why is he doing this? Why is a man who professed to love me so much doing this? Then she goes into the tub. She's held down, struggling for her life. She gulps. Her lungs fill with air, with water. Not the air she needs. And 10 to 20 seconds later, she's dead. Now, to accomplish this, took some planning, took some forethought. Decisions had to be made. Bridges had to be crossed. Cold, calculated, premeditated. Cold means the murder was the product of calm and cool reflection. Calculated means having a careful plan, a prearranged design to commit the murder. You know what killing through premeditation means. To this, there has to be a heightened level of premeditation to demonstrate that a substantial period of reflection is required. And this one, a pretense of moral or legal justification. There's no way that Henry Segura can claim that he had any moral or pretense of legal justification for the crimes he committed. We have the dates. We know at some stage, November 3rd, gave him 14 days on the child support. Is this when he started thinking about it and planning it? We don't know. But we know when we look at what he did, how he did it, we know it was, he didn't just walk in and decide to do this all of a sudden on the spur of the moment. We have him outside the house for a very long time on that day, on the 17th. At some point, there was some talking. We know she calls, Brandi calls DOR hotline on Wednesday. We know before the murders occurred, the defendant got up with Tyra Wilcoxon about trying to get the throwdown gun. That didn't work out. He had his own. He had the ammunition. He set up his alibi. He left his phone, his primary phone at home. The other phone he took with him. Some people may ask why. We needed to contact Brandi to make sure Brandi was there and everything else was on his schedule in order for him to get ready to commit this crime. We know he waited in the church parking lot for hours. If you wanted to kill just Brandi Peters, why didn't you kill when it was just her? Why didn't you isolate her? If you wanted just to kill Brandi Peters and JaVonte, why not wait till it's just the two of them? He waited 4 hours, and in those 4 hours, he had his protective clothing, because we know there were not a lot of defensive wounds and stuff on him. We know he had enough ammunition with him. He brought enough ammunition to know if the 5 or 6 rounds he had in that revolver didn't work, that he may need more. Why? Because you got 4 people to kill. We have him killing Ms. Peters. We have him killing the 3 kids. Then he disposed of the evidence. And mind you, the cold, calculated, premeditated nature for each of these victims were, he knew Brandi Peters for sure was going to be there. That was somebody we know he fully intended to kill for everything he did. He also made sure the kids were there. He certainly didn't abort the plan because the kids were there. He carried enough ammunition to do the killing of the kids, and he did it. And when he ran out of bullets, he used what he had, which was the tub. victims under 12 years of age. 6, 6, and 3. The aggravating factors. Previously convicted of a contemporaneous, or previously convicted a contemporaneous conviction of these murders. Proven beyond a reasonable doubt. Purpose for avoiding arrest, the witness elimination. Proven beyond a reasonable doubt. There was no other reason to kill those kids but to eliminate them, to be able to tell you who killed their mama. Financial gain. He wanted to do away with the Brandi Peters. You know, if you just want to kill Brandi Peters, kill Brandi Peters. If it wasn't for financial gain, then why is he killing JaVonte? Heinous, atrocious, and cruel. We covered that. Y'all know that it was. And the evidence shows that it was. And your verdict needs to show that these killings were just that. Cold, calculated, premeditated. That's been proven beyond a reasonable doubt in each of these murders. It's been proven that these 3 children were under the age of 12. We ask you, in the case of Brandi Peters' murder, that you find the existence of the aggravating factors presented on the verdict form, each and every one of them. Find that they warrant the imposition of the death penalty. They are sufficient to impose the death penalty. The mitigating factors, the instructions you heard, anything you want to consider about his background, what he does or what he says, or lack of criminal history. Even if you find those, and I'm not suggesting that you should, but even if you find anything mitigating about Henry Segura, these aggravating factors outweigh any mitigation that you could find or should even consider. And we ask that you return with a recommendation of death being imposed in the murder of Brandi Peters. We ask that you return with a verdict of recommending death in the case of the murder of Tamiyah Peters. We ask that you return with a verdict recommending death in the murder of Taniyah Peters. And we ask that you return with a verdict recommending death in the murder of JaVonte Segura. Thank you, ladies and gentlemen.
Okay. So we just heard from Mr. Evans there, Eddie Evans, giving the prosecution's closing argument. There was no defense closing argument. So it was just prosecution. He talks about Henry being previously convicted. I'm sorry. These were the 5 things I have to under. 1, 2. Yeah. Was he previously convicted? Did he do this to avoid arrest? Was it for financial gain? Was it heinous, atrocious, and cruel? Was it cold, calculated, and premeditated? And the kids were under 12. And he brought up a good point. He said if he wanted to just eliminate Brandi or JaVonte, he didn't have to delete the twins. Sadly, he kind of had to, because the twins would have pinned him out. I mean, you can't go in there and just take out 2 and especially the 6-year-old. You know, the twins were 6. You can't leave them. You know, can't leave them alive. They're going to say, yeah, this is what happened. Not only did Brandi know she was going to be deleted, but she knew her kids would be too. I think he started to choke up at that point. And then at the end, he recommends the DP. So I haven't been able to find how long they deliberated. Let's see. Mandy Strong says, what mitigating factors could the jury come up with? Well, have his mom come and testify, his sister's brother, cousin, somebody? I mean, we've heard that before where they have a teacher from high school or elementary school come up and say, oh, Henry was such a kind little boy. Or somebody, his people in the, he's been in jail for 9 years. Somebody in the jail saying, you know, look at Jodi Arias, you know, she's, or Sarah, well, Jodi Arias, she's doing prayer groups. You know, they could have said Henry's in charge of prayer groups. He deserves to continue on. I mean, there's all kinds of things they could have. Yeah, Lily Wayne, they already talked about this kind of in a way. Henry is stoic, no sign of emotion. He kind of talked about that in the sense of he didn't cry. You know, he was taught not to show emotion. So they already kind of talked about that. So I guess that's why. But he's also not looking up at the kids because they showed him briefly and they were showing the autopsy photos. So, yeah, I mean, he's not looking at them, but he's also showing no emotion. You would think at some point he'd be showing emotion. You would think. But, let's see. What does Curviel say? Many would, depending on the case, like in Nick Cruz, they knew how many families were forever irreparably harmed, and that lady that lied and then swayed others really did a disservice. Mandy Strong, he is obviously a criminal regardless of having a prior record. He was knowingly in possession of a stolen car, in a gunfight, deadbeat dad, etc. Well, you know what, Mandy? Actually, the previously convicted, I think, was previously committed a felony was that he committed these crimes and he was charged. I'm sorry, he was convicted. So it has nothing really to do with if he did anything, 20 years ago or 5 years ago, whatever it was. I think the judge explained that he committed these crimes and the jury found him guilty. So that's his previous convictions, right? And yeah, Mandy, they didn't. The jury was given nothing to come up with. Yeah, they did nothing. Julie says, he said on the stand, men don't cry or show emotion. Yeah. Brett says, yeah, he may not have had an official record of serious crimes, but I believe he had committed some. And he very well may have, but ultimately this boiled down to he was, by that jury, he was already convicted. So that's what they're considering a previous felony or a felony. It's safe to assume he was much more than a welder. Yeah, who knows? Maybe he was the one that was running drugs. Who knows? Why do I know Nick Cruz's name? That name sounds familiar. Was he flipping the bird and laughing at the... I don't know. Nan R says, with only 6 jurors, I wonder if this has to be unanimous. I think so. Maybe that's why the defense wanted 6. I still can't wrap my head around it. Yes, I think they did say that. I wrote that down. Needs to be unanimous. That was the judge. So yes, Nan R, this needs to be unanimous. And that's also why Henry suggested 6 to 12, because he wanted it. He didn't want another hung jury. He wanted to cut down the options of possibly being a hung jury. Julie, and I'm wondering if he was actually on some level a hitman. Possibly. Or running drugs. Right? He traveled a lot. He was a welder. He said he traveled around a lot. Maybe he was running some drugs. Who knows? Kerrville says, we only discuss it as that is a case that caused the changes in the DP no longer needing to be unanimous. Why do I know that name? Nick Cruz. Who is Nick Cruz? I know that name. Oh, Parkland, right? Yeah, that's Parkland. Okay, that's why I know that name. I did not watch that trial per se, but I was actually working and I was driving home. I was working in that area and I was driving home and I'm like, what is all this traffic for? And then when I got home, I found out. I didn't live anywhere near it, although I had coworkers that lived in that area. They said, yeah, it was pretty life-changing for them. Kerrville says, yeah, he wanted more money and drugs would be a good way to get more money that could not be taken for child support. He said he did a lot of jobs, worked a lot of jobs off the books. Brad says, unlike Brandi, he was running around in a flashy truck while claiming to not be making enough money to pay child support. That is true. Mandy says he knew who to ask to borrow a throwdown pew pew. Do any of us know anyone who can get a throwdown pew pew? I think not. Guilty. I added that guilty. You're going to go with running drugs? I could see that. I could see that. I mean, why not? I mean, it's a quick way to make some serious money. Nanar said he could have been both, a hitman and drug dealer. I've never heard of a traveling welder. Haha. That is true as well. All right, let's get to the jury charge. This one is 6 minutes. So let's get to this. Jury charge is coming up. We're almost done with this one, guys. And then we're going to go over to Billy Wagner. We got 2 more segments. This is 6 minutes. Next one is 13, and then we'll be done. So 20 minutes with a little recap. So we'll be done around 5, and then we can jump on. Oh, yeah, I got to be done by 5 because Billy Wagner's coming up. Okay, let's get to it.
Defense will not make an argument, Your Honor.
Right. Let's go back to the jury instructions, page 6. Top of the page. In just a moment to be taken to the jury room by the bailiff. When you have reached decisions in conformity with these instructions, the appropriate form should be signed and dated by your foreperson. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. You are not to communicate with any person outside the jury about this case, and you must not talk about this case in person or through the telephone, writing, or electronic communication, such as a blog, Twitter, email, text message, or any other means. Many of you may have cell phones, tablets, laptops, or other electronic devices here in the courtroom. The rules do not allow you to bring your phones or any of those types of electronic devices into the jury room during deliberations. Kindly turn those devices over to the bailiff while you deliberate. Do not contact anyone to assist you during deliberations. These communication rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions, or any other instruction I have given in this case, you must tell me by giving a note to the bailiff. During this trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. These exhibits will be sent into the jury room with you when you begin to deliberate. I cannot participate in your deliberations in any way. Please disregard anything I may have said or done that made you think I preferred one decision over another. If you need to communicate with me, send a note through the bailiff signed by the foreperson. If you have questions, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions if I can in writing or orally here in open court. In closing, let me remind you that it is important that you follow the laws spelled out in these instructions. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate rules we all share. Let's go sidebar, please. Adams, once again, you need to remain with us. We'll let y'all step out, begin your deliberations. We'll be sending the evidence to you. Everybody be seated. All right, well, appreciate you coming back. I know that's tough to not be involved in the other part and then asked to come back. We appreciate your cooperation with that. This will conclude your service with us. We do appreciate the time and attention that you've given. Make you aware of the right, the juror, you have a right to discuss your participation or not. I don't know that whether anyone would inquire of you, but it's possible they would inquire of you. You can talk to people or not as you see fit. You're now excused, so you can govern yourself as you see fit. You can't go back in the jury room. Do you have any personal effects back there? With deputies, we need to make sure Granger's going to get their personal effects. And I'm surprised he's not back by now. If y'all hold there for just a second, he'll be back momentarily. If we kept the evidence separated, so we still have what we went through the other day, we're also sending a copy of the jury instructions with them. I had the copy just printed up, so if they have any questions about the original jury instructions, so evidence can be delivered to the jury. Here he is. Okay. They have some personal effects they need to retrieve for them. We'll let you step out with the deputy. Thank you and have a good day. You can take it with you or not as you see fit. They can't go back in the jury room to look at their personal effects. All right? Anything else from either side?
No, we just need to put as a court exhibit the PowerPoint.
Why don't we hold it? Okay. Clerk's got her hands full at the moment. Let's not give her one more thing. Yes. But once she gets back, you can put the PowerPoint as a court exhibit, whatever it would be. Anything else from anyone?
No, sir.
All right, we'll be in recess. We'll hear from the jury.
All right, so now we will go on to what the what little one? What? Hi. Why are you? Oh, all right. Oh boy. All right. Let's we're gonna now get to the to their verdict. Will Henry spend his life in behind bars, or will he be put to death? Let's find out.
Station.
I'm informed we have a verdict. We ready for the jury?
Yes, sir.
All right, let's have a jury, please.
Jury's in the courtroom.
Everybody be seated. Mr. Brill, have we arrived at a verdict?
We have.
All right, would you hand it to the bailiff, please? Just a minute to read through it. It's a little more complicated than the average. All right, I'm going to summarize the results of the findings of the jury as to A, aggravating factors. The jury has found that at least multiple aggravating factors have been found as to each of the 4 counts. As to B, the sufficiency of the aggravating factors, the jury has found that the aggravating factors are sufficient as to each of the 4 counts. As to C, mitigating circumstances, at least one, the terminology, one or more individual jurors have found that there is proof of mitigating circumstances as to each of the 4 counts. As to the eligibility for the death penalty, under D, each of the jurors found that the aggravating factors were proven beyond a reasonable doubt and outweigh the mitigating circumstances as to each of the counts. As to the jury verdict as to the death penalty, having unanimously found that at least one aggravating factor has been established beyond a reasonable doubt, Section A, that the aggravating factors are sufficient to warrant the sentence of death, Section B, and the aggravating factors outweigh the mitigating circumstances, Section D, we, the jury, unanimously find that Henry Segura should not be sentenced to death as to each of the 4 counts. Mr. Brill, have I accurately published the verdict of the jury?
Yes, sir.
Either side, we should have the jury polled.
No, Your Honor.
All right.
Yes, sir.
What's that?
Yes.
They have found that he's not subject to the death penalty, and you want them polled?
Yes.
Okay. Juror number 1, is this your verdict as well as the verdict of the jury as a whole?
Yes, it is.
Juror number 2?
Yes.
Juror number 3?
Yes.
Juror number 4?
Yes.
Juror number 5?
Yes.
Juror number 6?
Yes.
All right. It's been confirmed by the jury. Bill, it appears to be in order. It will be filed. So I guess the words you've been waiting to hear were done. I know this has been a long and arduous task for y'all. We call upon jurors to do a pretty Herculean job, and they work hard at it, and we appreciate it. As I said earlier, you've been the most reliable jury for this length of time that I've ever had. We haven't had a single problem from day one. We've not had a single time in the morning or after lunch or at any other point where we had to wait on you. I appreciate that. I try to run court on time, and if everybody runs on time, it runs smoother for everybody, and I appreciate that. Let me make you aware of one right that you have as a juror. You have a right not to discuss your deliberations. That doesn't mean you're prohibited from talking about them. You can talk about them if you desire, but you have every right to simply say, I'd prefer not to talk about it. As I say, that's entirely up to you. It is quite likely that someone is going to approach you and ask you about your decision making. It's possible they approach you to find fault with what you've done. You have every right to simply say, I'd prefer not to talk about it. We will be giving you a letter from the court as you leave. It will express our appreciation in writing and give you a little certificate, but it'll also do one more thing. It does give you the ability to contact some counselors that have agreed to meet with jurors at least on a one-time basis for free to talk and see whether you feel like you need further assistance along that line. There'll be a list of those counselors and a letter that Mr. Wills will give you as you leave. You should not hesitate to take advantage of that. I know we've shared some pretty awful things with you here in this courtroom, and I regret that, we have to do that, but our system works on jurors coming in and listening to the evidence and making a decision. So we do appreciate the time and attention you've given us. I'd ask that everyone stay in the courtroom until we get the jurors safely out of the courthouse. We'll allow you to go out with the deputy and have a wonderful day. And I know you hope not to see me for a long time, so y'all have a good day. All right. Any reason not to proceed to sentencing at this time?
No, Your Honor.
All right. If y'all prepared a score sheet?
We have not, Your Honor. They're all capital counts, so therefore there is no score sheet on this. Normally we have to do it on one when there's not a capital.
Okay. All right. There's only, all of the sentences require a life sentence. I guess the only issue is the concurrent or consecutive nature of the sentences to be imposed. I'll let you be heard, Mr. Prince.
Leave it to the court's discretion.
All right. Mr. Fuchs.
Your Honor, the state would ask for a consecutive sentence on each given the nature of the offenses. And the fact that there are, in fact, 4 victims in this case, they should always be accountable for each one of them.
I did have the clerk, I'm sorry, do we want to present a victim impact statement?
No, ma'am. No, sir.
Okay. All right. I had the clerk figure out jail credit. I don't know whether this was discussed with you, but I know there was some time in Minnesota. Clerk has calculated 3,002 days of jail credit. What was the starting date you used, Madam Clerk?
It was, we helped with that. It was September 2nd, 2011.
And he's been in custody since that
Correct.
date. Is there any dispute on that amount?
No, Your Honor.
Okay. Any other issues either side wish to raise?
No, Your Honor.
Friend.
I would just ask that the court recommend to the Department of Corrections he be housed as close as possible to Leon County.
Okay. All right, Mr. Segura, based upon the jury verdict in this case on each of the 4 counts, I do adjudicate you guilty of each of those counts. On each count, I sentence you to life in prison. Counts 2, 3, and 4 will run concurrently with each other, but consecutively to count 1. So there'll be 2 consecutive sentences of life. As to count 1, you're given credit of 3,002 days. There's no credit as to 2, 3, and 4 counts 2, 3, and 4 since it's a consecutive sentence. Order $420 costs, $100 cost to prosecution, or reduce that amount to a civil judgment. I recommend to the Department of Corrections they house Mr. Segura as close to Leon County as is feasible. Does that leave anything outstanding?
Your Honor, we just had a question regarding this screen erected to ensure the integrity of the process as it related to Ms. Wilcoxon. Does that remain in effect, or has that expired with the end of the case now? Ms. Baker doesn't have any knowledge or information about what happened with that. The court directed us to screen her from that. That will be part of the...
I'll release that at this point in time. Anything else?
Yes, Your Honor, there's also an outstanding warrant for Kelsey Kennard. We've already taken care of it on the international and the interstate aspect of it, but we actually need you to withdraw the warrant as well.
You want it withdrawn?
We need you to withdraw the warrant, yes, sir.
Okay, withdraw the warrant as to Kelsey Kennard. All right, anything else from anybody?
No, Your Honor.
Mr. Segura, you have 30 days to file notice of appeal. If you can't afford a lawyer, one would be appointed to represent you. Mr. Prince, I would assume you would discuss with him his appellate rights if he desires to file an appeal, that you assist him in doing so. At that point in time, you can decide whether you wish to request a public defender to be appointed to represent him, or you're going to continue to represent him. If there's nothing further, we'll be in recess. All right, so I've got one more thing for you guys, but we'll just read through this. So the verdict and sentencing. So this was very confusing, I thought. Multiple aggravating factors were found. The factors are sufficient. One or more jurors found proof of mitigating factors. DP eligible aggravating factors outweigh the mitigating factors. It warrants the DP, but then they said Henry should not be sentenced. And then the news article said, despite agreeing with every argument that prosecutors made in favor of the DP, the jurors just couldn't make that decision. And then Nate Prince left the sentencing up to the court's discretion. The state asked for consecutive. There were no impact statements. He got jail credit for 3,002 days. And he got 2 life sentences, but 2 of them were concurrent.
Okay. All right, so I found his appeals. He did appeal. Let me see. Let me see if I can get this. Nope. Okay. Yeah, let's check this out. We'll read his, I'm not going to read his entire appeal, but we're just going to put a final little thing on this. I guess a bow, if you want to call it that. All right. All right, so this was November 3rd, 2021. So his Henry Segura appeals his conviction and life sentences on 4 counts of first-degree M. He advances 5 arguments for reversal. We write only to address the first. In his lead argument, he urges the court to engage in a weight of the evidence review because, as Segura characterizes it, the evidence below was overwhelming in favor of innocence. The other arguments relate to evidentiary rulings which we have carefully considered and reject without further discussion. 1. A jury found Segura guilty of the premeditated and brutal murder of Brandi Peters and her 3 children, one of whom was also Segura's son. There was significant evidence of Segura's guilt. The state's established motive was that Peters had repeatedly taunted Segura with an allegation that his son was not biologically his, yet he still had to pay child support he could not afford. A girlfriend of Segura's testified that he approached her close in time to the murders, shaking with rage and asking for a gun. A jailhouse informant relayed Segura's confession to the murders, which included a statement from Segura corroborating the girlfriend's testimony, and Segura's DNA was discovered on the bathtub where the children's bodies were found. Before Segura was a suspect, police interviewed him a day after the murders. Segura acknowledged his relationship with Peters but denied his presence at her house on the day of the murders. He repeatedly said he was at his house all day, even explaining inconsequential details of his home activities. He denied owning the same caliber gun as the bullets found at the crime scene, and he said he only had 1 phone. At a second interview, he was given an opportunity to correct his story. He admitted only to having a second phone that he used to talk to his girlfriends behind his wife's back and claimed to have disposed of it well before the murders. He continued to deny everything else. At trial, and in the face of conclusive evidence that each of these statements were false, Segura changed his tune. He acknowledged that on the day of the murders, he was at the crime scene, he did own the same caliber gun, he did have 2 phones, and he had left his primary phone at home, and he went to several other places. He claimed he lied because he was worried his wife would find out about his infidelity. He said he was in an ongoing sexual relationship with Peters. Despite these concessions, Segura insisted he left Peters' house before the murders occurred. He also presented his own theory that a 7-member drug cartel hit squad was responsible for the murders. The tent pole of the defense case, aside from Segura's testimony, was the testimony of James Santos. Santos is a self-proclaimed drug cartel leader currently in prison who confessed to ordering a hit on Peters. There was evidence that Santos and Peters had some sort of relationship through jail mail in the days before her murder. Santos claimed this relationship was transactional, that Peters worked for him as a drug trafficker and had for years. Sorry, cat fur. Santos said he ordered her passing when he discovered she was stealing from him. But Santos's testimony had problems, the first being that his story evolved significantly leading up to the trial. He initially denied any involvement in those, I should probably stop saying that word, in the deletions. As names of potential suspects were raised at publicized court hearings, Santos incorporated them into his story. The final version, after several revisions, had him as the behind-the-scenes leader of the hit squad, but the details are wanting. At trial, he could only name 2 of the 7-member group, and those 2 names were previously publicized by the media. Santos also admitted to confessing to another murder he did not commit, a diagnosis of schizophrenia and hearing voices. And despite claiming to know her for years, Santos could not name a single characteristic about Peters other than that she was a black woman. As part of the defense theory, Segura also pointed out that his DNA was only found on the bathtub by the children's bodies and nowhere else in the large crime scene. He noted that several samples of foreign, unidentified DNA were collected. He presented a cartel expert that testified the scene was consistent with a cartel hit, and he pointed to other suspects eliminated by police based on phone records. He made arguably incriminating statements. 2. Segura asks us to engage in a weight of the evidence review on appeal in the interest of justice. Segura argues his case is unique because of the overwhelming nature of the unrebutted evidence of innocence, and there was no room for rational minds to disagree with the fact that the state failed to carry its burden. There's no legal support for Segura's argument. He cites case law for the proposition that the interest of justice, standing alone, is a viable and independent ground for appellate reversal. This phrase is contained in Florida Rule of Appellate Procedure, which states that in the interest of justice, the court may grant any relief to which any party is entitled, but the plain language requires the party to first have a legal entitlement to relief. As this entitlement cannot be reweighed of the evidence, as Tibbs explicitly found, Tibbs eliminated evidentiary weight as a ground for appellate reversal. Segura's real request is for us, as appellate judges, to substitute our verdict for the jury's. We cannot. Opposing theories must be weighed by the jury. We do not try this case again on appeal. There was sufficient evidence for the jurors to reasonably reach a finding of guilt. Absent prejudicial error, appellate courts must respect a jury's verdict. Affirmed. J and M.K. Thomas, J.J. concur. So, there you have it. What do you guys think? Therapist says, I'm pretty sure they emphasize strongly that they have to be okay with the DP in a death DP case during jury selection. Oh, absolutely. Absolutely. Shirley Roth, denied. Right? Therapist, it's always possible for someone to believe they're okay with DP until it's actually put in their face to condemn someone too, though. I agree. You can say it all you want in voir dire, but when it actually comes time, Shirley Roth, cartel, yeah, sure, they do a clean job. Nan R says, I guess they believed he deserved DP, but maybe there was someone who said that they could give DP, really couldn't. I would say up front that I couldn't. They press asking, you wouldn't follow law? No. Brad says, he admitted he was there Wednesday but denied anything the day of so that his wife wouldn't find out about the infidelity. Yeah, that's logical. Not. Brad also says, I'm guessing they thought the lack of opposing arguments meant he wanted DP and they decided to let him rot instead. But that's just a guess. And yes, for Shirley Roth, he did an appeal. He absolutely did. Lily Wayne, would he be allowed to appeal again? Ken, that's a question for you. How many times can you appeal? Ken? Ken Rosenberg, that's an appellate panel's way of saying, go away, be gone. Off you go. Shoo-shoo. Mandy Strong says he wants us to believe he would rather lie to law enforcement about seeing 4 victims the day they passed than his wife find out he was cheating on Brandi. Sure, I know, right? Look at Rafa. Look at this little bean boy right there. Little beano. Do you want to go out too? Do you want to go outside? No. All right, off they go. All right, Ken. Almost certainly can appeal again in a capital case. However, specific times can differ between states, but he can likely be heard by the Florida Supreme Court. So that was 2021, right? I think it was 2021. Right? Yeah, because this was 2019. So 4 years. That's all I found so far. Yeah. Julie, shoo shoo. Out you go. Bye bye. And Julie, now that he is in prison, no child support for anyone. Or are they still taking his pittance and giving it to them? I don't know. Yes, Ken. Lily Wayne says, thanks for answering. Ken, or at least he has the option to petition. All right. All right, we're going to do Billy Wagner. I'm going to just take a little break here and get myself sorted out, get some water, and I'll see you guys. Sorry, don't get comfortable. I'll see you guys in a little bit. Thank you for joining us. I'm pretty sure everything's been set up. Join us for Billy Wagner. That happened earlier today, so we're going to go check out Billy Wagner. Make sure your trays and seats are in the upright position, and you have your arms close to your close to your body, and you don't get sucked out. Okay, I'll see you guys in about 10 minutes. Thanks for watching.